I don't know what the letter means, other than other than the secretary saying, we've had private communications, you and me, Mr. Moeti Kanyani, we've had these private conversations, and I've struck an agreement with you. I haven't told anybody else what that agreement is. They don't know about it, but I'm telling you what it is. Sorry, it was my fault. I should perhaps have told everyone. I still don't know what it is. So as I sit here right now, I can tell you that the commission are late. They were late by 3 days. They never applied for condonation. There's a rule that says that if you don't do it, you're time barred. And now we've got some private correspondence between the secretary and Moeti Kanyani, where they're having discussions that no one else knows about. And that is not proper. That is not proper. We are highly prejudiced by it. We now sit a month down the line. We may not get the relief that we want, or we may not get all of it because we're running out of time. And it's directly because of stuff like this. We've got the commission and the secretary playing fast and loose in circumstances that are highly prejudicial to us, and that can never, ever be good enough. So what now? Now, my lord, I'm going to refer, without taking you through it, just to paragraphs 17 to 24 of my heads of argument. And if you make a note there, those paragraphs talk about the bar that's been imposed by Rule 10. And why the bar should apply in this case and what should happen. Now, perhaps I can tell you that we rely on a constitutional court judgment of Justice Cameron in the Kurland matter. And the reference to Kurland you'll find in paragraph 22 of my heads. And what happened there is Justice Cameron said that in constitutional matters, the state and organs of state must be model litigants. Now, in this case, that requirement is amplified. It's amplified because the commission is not any old organ of state. It's a constitutionally created organ of state, number one. And number two, and most importantly, it's directly plugged into this court. So if anybody needs to litigate in this court as a model litigant, it's the commission. It cannot be the person that stands up and says, I know what the rules are, but I don't care. I stand aloof of those rules. I don't care what the rules say. I'm not going to comply with them. And if you tell me that there's a penalty and you tell me that the rule says there's a penalty, well, I'll tell you that you're being absurd. You cannot have a commission acting in that kind of high-handed manner. So what do we do with all of this? Well, I suppose what we do with it is we exercise the punitive provision in Rule 10. In other words, you impose a bar. You impose a bar. And this affidavit that is 3 days late, unaccompanied by any kind of explanation or condonation application, where no good cause has been shown, shouldn't be admissible. It really shouldn't be admissible. And if the commission thinks it's absurd, well, it's a rule of the court and it needs to directly attack that rule. But until it does that, the rule is there and it must be obeyed, particularly by an organization that was created together with this court to assist the court. It cannot stand aloof. So That's the first development. I said there were two matters of housekeeping. The second one, my lord, is
Mr. Hopkins, I just want to remind you that your 15 minutes of immunity is now over. You may now expect questions from the members of the panel. But
thank
proceed.
You. My lord, to quickly get the second housekeeping out the way, and then I'm into the heads, and then I'll entertain everything easily. The second part is that, as I said to you, very late yesterday, a concession was made. Now, let me tell you what the Commission's case was in its answering affidavit. It effectively says you're disqualified from contesting the election for two reasons. Number one, you didn't upload everything that you needed to get onto the portal. That's the first reason. But the second reason it says is, well, you didn't pay your deposit. Well, we then demonstrate to the court that we did pay the deposit. We paid it on before the portal closed on the 8th of March. And we uploaded proof onto the portal. But we say that the portal wasn't working properly. Throughout the day on the 8th of March, the portal wasn't working properly. It wasn't giving you reports. It wasn't giving you feedback. It wasn't telling you what was happening. The portal was a disaster. ACT had exactly the same problem. The Commission's case is, no, that's absolute nonsense. The portal was working perfectly, it says. Now, I'm going to come back to this in a moment. But for now, let's have a look at the concession that was made late in the day yesterday. The concession is, oh, I'm sorry. I cannot believe that I've accused you of not paying the deposit. I now eventually see 14 days later, 12 days later, that in fact, you did pay the deposit. I see that you've paid it. But the explanation comes in an affidavit from a chap called Mr. Siani, who works for the Commission, and you've got to look at the explanation to see the absurdity. You don't have it, unfortunately, in your papers because it was sent late last night.
Yes, I do have it, separately.
Oh, thank you. Mm-hmm. So Mr. Siani explains who he is. He explains the problem and he says there was a bona fide error. You see that above paragraph 5. But have a look at his reasons. You find the reason for him making the error in paragraph 8. I'm going to read it with you. The reason for the error is this. At the time the answering affidavit was prepared, that's 12 days after the portal closed. At the time the answering affidavit was prepared, the Commission's records reflected that the deposit hadn't been paid. And then it attaches a printout from its own portal to show that the portal wasn't recording what was happening. It wasn't giving reports. It wasn't giving reliable feedback. The portal wasn't working. It wasn't working to the point where the Commission didn't even know what was going on. It starts accusing people of not paying when they've paid. It starts disqualifying people for reasons that are not correct. And then it apologizes afterwards and says, my mistake, the portal wasn't working. Let's have a look at that in paragraph 8. It says they had not disclosed that the deposit had not been paid as payment did not reflect on the system. The system was faulty. Now, our whole case, as you know, is that the portal wasn't working. The system was faulty. Throughout these proceedings...
Sorry, Mr. Hopkins.
Yeah.
I'm just reading paragraph 8 of Mr. Siane affidavit.
Yes.
Does it say that the portal was faulty or because you have used faulty?
Let's have a look. Let's read it. I'm going to read it together. We get the exact words. The reason for the error is this. At the time the answering affidavit was prepared, the Commission's records, as reflected in Annexure 18 of the answering papers, disclosed that the deposit had not been paid as payment did not reflect on the system. I am of the view that the delay in the reflection of the payment was due to the method of payment used by the applicant. It's extraordinary. So we get blamed continuously. But the point is that we uploaded it. They've admitted that we uploaded it on time. It just doesn't reflect anywhere. And that's been our argument throughout, is that the portal doesn't work properly. It doesn't tell you what's going on. It doesn't give you reports. It doesn't give you feedback. Now the Commission are on the receiving end of it. They're on the receiving end of it. Now they can see that their portal doesn't work. And that's a very, very important concession. So with all of that in mind, I've structured my argument, which I'd like to present to you in the form of a roadmap. And that roadmap follows roughly my heads of argument. And I'm going to deal with 6 things. The very first one is I'm going to look at the facts. The second one is I'm going to identify what the real dispute is. Thirdly, I'm going to isolate the decision that needs to be reviewed by this court. Then I'm going to give you the grounds of review. And then I'm going to identify what I believe is the appropriate level of judicial scrutiny. In other words, how closely must you look at what happened? How critical should you be? And finally, I'm going to propose a remedy. So those are the 6 things. So I said I was going to start with the material facts, and that's exactly where I'm starting now. So I need to give you an acceptable factual matrix so that you can also see what happened. And I'll start off by just reminding the court that the timetable was published on 24 February. And that is where everybody in the country learned for the very first time that you had this 8 March deadline in item 9. So a mere 9 business days before the deadline, people heard about the deadline. That's what we know. Now, Mr. Janse van Rensburg, he's the deponent to the Labour Party's founding affidavit. He says he didn't really know how difficult it would be to comply with the deadline, given that he had 9 days. And why not? Well, he didn't know, because the real problems only became apparent in the last 2 days before the deadline, when he tried to upload onto the portal and the portal wasn't working. So the Commission, you will see throughout this case, the Commission say you should have challenged the timetable within 3 days of it being published. But we didn't know that there was a problem within 3 days of it being published. We only knew that there was a problem. And this is the problem that the court must focus on, is the problems that we experienced on 7 and 8 March, the 2 days before the deadline. To understand this, my lord, we need to really understand what is involved, what a political party needs to do in order to comply with the prescribed manner. And for that, I don't want to take up too much of your time, but I'm going to refer you to paragraph 41 in the replying affidavit. You have to go there now. It's on page 475. That's where there are 4 steps, and they are broken down and described in detail. If you want to know where I deal with it in my heads of argument, it's paragraph 32.
What's happening now? Just mute. Those who are not on the platform, they must just mute, please. Okay, thank you.
So, Judge Zondi, what we've got now in paragraph 32 of my heads, so we skip a long way ahead, is we really see that there are 4 stages to any political party complying with the prescribed method. The very first one is you've got to gather signatures. Now, this happens a long time ago. And all the signatures were gathered. So I'm going to refer to the 7th and the 8th, the 2 days before the deadline. I'm going to call it Birchwood. Birchwood is the name of a convention center. We'll come back to it. But our case is only about Birchwood. But long before Birchwood, we had to go and gather signatures. And as I said to you, we gathered approximately 51,000 of them. We had our candidate lists put together. All of that was gathered by various field workers in different regions of the country. So they would go to public places and they would find supporters, and those supporters would fill out their names and ID numbers and sign forms. That was the gathering of information, all done before Birchwood. So it's irrelevant. Then, once the information had been gathered, it had to be captured. So, Judge Zondi, what capturing means is that you take it from these raw forms that you get in the regions, and you capture it into a way that you can then upload onto the portal. So capturing really means taking down those details, particularly the ID numbers, and putting them into an Excel spreadsheet so that you could later then post them up onto the portal in what we call a bulk upload. We'll deal with that in a moment. That was also done before we got to Birchwood. Gathering is no problem. capturing is no problem. But then
sorry, Mr. Hopkins. Sorry, before the Birchwood event, you had already captured or gathered your signatures. What had you done?
Yes, we had gathered 51,000 signatures,
yes,
and we had captured them into documents that we had designed ourselves, our own format.
Okay. All right.
So we had, so really,
the capturing had been done. That's what I wanted. The capturing had been done.
Yeah. The affidavits tell us that the capturing can be done. Now what we had to do is to do two things. We call it consolidating and then uploading. And that had to be done at Birchwood. And in order to do that, we hired out a conference center. Now, you may ask, why did we hire out a conference center? Well, we hired it out for two reasons. Number one, we wanted a peaceful place where we could bring lots of people, set up computers and laptops, design a system in a big room, and we wouldn't be interfered with. So we got 25 volunteers to help us. We gave them each laptops. Jobs were assigned to each one of them. Everyone had a function that they needed to perform. And this, as I say, is set out in detail in paragraph 32 of my heads. And that mirrors the paragraphs in the replying affidavit. Now, what has to happen is, the second reason we hire out Birchwood is because we wanted to make sure that we had a facility with a high-speed internet connection so we could get an uninterrupted connection. You see, what the commission do in their answering affidavit is they say, well, if you couldn't upload and you had problems, it's your fault. You probably had a terrible internet connection. Well, we didn't. We had absolutely, and it's not challenged on the evidence. An allegation is thrown out there, but it's not, and that's the reason we went to Birchwood. We had no connectivity issues at all. We still couldn't get it done on time. And exactly the palaver and the level of detail and the cumbersome process that needed to be followed is set out in the founding affidavit and then reiterated in reply. So, Judge Zondi, what went wrong? Well, what went wrong is we got to Birchwood, gave ourselves 2 days to upload the stuff onto the portal, the Commission's portal that it provided, a system that we experienced problems. We explained the problems in great detail. We say, for example, the portal would hang. By hanging, we mean that it freezes. You know, one of the big complaints that we had is that as we thought we were uploading stuff, we would get no reports and no feedback. The portal wasn't giving us feedbacks and reports. Well, I've just shown you that the Commission itself is a victim of exactly that problem with the portal. It didn't know that we had paid when we had. It's a real problem. It actually happened. It actually did happen. We were there for 2 days with a lot of people. And the other point that is made in the affidavits, my lord, is that we're not just any old small spaza shop. The Labour Party has its origins in AMCU. AMCU is a big, successful, well-resourced, well-run trade union. We have got people with a great deal of experience in capturing data, uploading data, putting systems in place. We gave ourselves 2 days to do this, 2 full days to upload. We were not able to do so because of the portal problems. Now, I'll tell you what's interesting. The Commission, in their answering affidavit, say you only needed 1 day. You didn't need 2 days, you only needed 1 day. But then it criticizes us. It criticizes us for not going to Birchwood earlier. It says, why did you leave it until the last minute? We didn't. We gave ourselves 2 days, which is twice as long as you think we needed. So how can we be criticized for leaving it until the last minute? The timing that we gave ourselves is more than reasonable, even on the Commission's own version. Now, the portal problems, it comes down to this. This is the crux of the case, is did the portal malfunction or didn't it? And to know that, we need to look at the affidavits. And my lord, in my heads of argument, I refer you to, first of all, the founding affidavit. That's in paragraph 35 of my heads. Then the answering affidavit, which is in paragraph 37 of my heads. And then I refer you to the replying affidavit, which is in paragraph 38 of the heads. So that's where we get everything. That's where we get to understand what the factual matrix really is. Now let's go to paragraph 38 of the heads, if you don't mind, Judge Swandi. Because in paragraph 35 of the heads, I'm taking out the factual allegations in the founding affidavit. There we say we got a team of 25 volunteers. We went to Birchwood. We hired out this facility, high-speed connection, gave people laptops, set up a system. People sat around a big U-shaped table, and they had jobs to do. Mr. Janse van Rensburg explained that there were difficulties in those 2 days with the portal, and he said if there weren't difficulties, everything would have been uploaded. No problem. 51,000 supporters would have been uploaded, and all of our 12 national candidates and our provincial candidates would have been uploaded. We had the information ready to upload, but we couldn't because of the portal. We couldn't because of the portal. So what do we say went wrong in the founding affidavit with the portal? Well, there's a whole lot of examples of things, and I've teased them out in the heads of argument. But for example, we go back to the problem that the portal would keep on hanging. You know, very often, Judge Zondi, what happens with a computer system, particularly where there's heavy software that drives the process, is you get a thing that they call a spinning wheel. You may have seen it. It's that thing that turns like this in the middle of your screen. It tells you that your computer's thinking. It's processing data. Now, in this situation, there's no spinning wheel on this portal. So no one knows whether what you're doing is being processed or not. You don't know when it's happened or not. You don't get feedback. You don't get report. Quite frankly, as Mr. Janse van Rensburg says in the founding affidavit, he had no idea what was going on. He had no idea what was being accepted by the portal and what wasn't being accepted. But what he does say is that he knows that he was kicked off the system frequently. You get kicked off and now you've got to go and log in again. But when you log in again, you don't know how far you got because you don't know at what point you were kicked off. You don't know what the system accepted and what it didn't accept. He tells you that you had to upload ID numbers. Now, you upload ID numbers because they've got to match ID numbers on the Commission's computer system to make sure that these are properly registered voters. But sometimes the ID numbers would be rejected. He says he doesn't know why they were rejected. Is it because the ID number was entered wrongly? Was it given wrongly? What's the problem with the ID number? Isn't the person registered? The computer system never tells you, so you can never fix the problem. And Mr. Janse van Rensburg, under oath, says that he believes that they probably submitted 30% more than they needed to, because that's the wastage that you have, stuff that was rejected. And he lists the other problems that there were as well with the portal. And you'll find all of these dealt with, as I say, in the founding affidavit in paragraph 35. So what did the Commission do? Well, the Commission filed an answering affidavit. Now they must deal with these complaints. They essentially have got three answers for us. In the very first answer, the Commission says, it's all your fault. It says, I don't want to hear that things didn't work out for you at Birchwood. The problem is yours. You registered late as a political party. So because you registered so late in the day, it's your fault that you didn't meet the deadline. But Judge Zondi, let's stop and think about that for a minute. Registration has got absolutely nothing to do with it. Whether we had registered 6 months ago, or a year ago, or 2 years ago, we would always have had portal problems at Birchwood. So the question is not about whether we registered late, as the Commission says. The question is whether or not we gave ourselves enough time at Birchwood. That's the only question.
Sorry, please, just
No problem.
what's happening? Okay, proceed.
Thank you. Okay, so the very first answer from the Commission is blame yourself because you registered so late as a party. And as I've demonstrated now, that's irrelevant, absolutely irrelevant. The second problem that the Commission have is they say, well, I deny that the port is faulty. And it gives two reasons for saying that the port wasn't faulty. In the first instance, it says, I know it wasn't faulty because I tested it and it was working. And then the second reason it gives, it says other people managed to use the portal. So those are the two reasons. Now, let's stop there quickly. Let's go back to that first reason. The first reason, remember, is I know that it was working because I tested it. When did they test it? They don't tell us when they tested it. Maybe they tested it 3 weeks before it started giving problems. Maybe they tested it 6 weeks before. I don't know when they tested it. They don't tell us. But what I do know is that on the 7th and 8th at Birchwood, it wasn't working properly. And I'm not the only one who says that. There are other political parties that say exactly the same thing. Soon you're going to hear from Mr. Am, who will tell you what trouble ACT experienced. Same glitches. All right, and then the next leg, of course, is they say, well, other people managed to do it, and they give examples of 3 parties who were able to upload stuff. And they say, therefore, the portal was working. But again, I don't know. They tell us a little bit about who those 3 parties are and when they try to upload, but we don't know what problems they experienced. Maybe they experienced problems. Maybe they tried to upload everything and they only uploaded some stuff. I don't know. We're not told enough. And unfortunately, when you don't say enough, then on the Platscon-Evans rule, you don't raise a genuine dispute of fact. And by giving these unsubstantiated denials, which the Commission does, it doesn't rise to the level of a genuine dispute of fact. And if there's no genuine dispute of fact, then it's the founding affidavit that you must accept. But, my lord, there's another reason why you must accept the founding affidavit. Don't forget, it's because the answering affidavit isn't actually before you. They barred from filing an answering affidavit under Rule 10. But even if I'm wrong, and even if you're inclined to allow, them to file an answering affidavit, and even if you give some credence to what they say in the answering affidavit, we file a reply. And what we say in the reply, you find in paragraph 38
now
of
we
my
have
heads
the
of
new one.
argument.
Site is updated.
There's somebody who is on the platform who is abusing the platform. He talks while Mr. Hopkins is still on the floor. Could you please just switch off your micro, please?
Thank you, my lord.
Proceed, Mr. Hopkins.
Thank you. My lord, and then, of course, the third factual dispute. Remember, I said that there were 3 big factual disputes raised by the Commission in the answer. The third one is they say, you're disqualified anyway because you haven't paid your deposit. Well, they've now conceded that they were wrong. The portal let them down. Had the portal been working, they wouldn't have made that mistake. They now concede they've made the mistake. We did pay the deposit. So 3 big factual disputes. One of them they concede. The other 2, for reasons that I'm about to give you, should be resolved in our favor. First of all, there isn't an answering affidavit. And secondly, the answering affidavit doesn't trigger a genuine dispute of fact. But thirdly, even if it did, it's dispelled in the replying affidavit. So let's have a look at what the reply does. I say to you that it's dealt with in para 38 of my heads. Now, there we explain exactly why late registration is not the point. And I see from the Commission's heads of argument, with the greatest of respect to them, that they've misunderstood the point. They've misunderstood the point completely. The point is that it doesn't matter. It doesn't matter, my lord, when we registered. It doesn't matter how long it took us to get to Birchwood. The point is, when we got to Birchwood, we had everything we needed. The portal let us down. That's the point. And the second point is, was the portal faulty? Well, what we do...
Sorry, Mr. Hopkins.
Yeah.
When you encountered all these difficulties that you have alluded to,
yeah,
did you raise them with the Commission? Did you phone did somebody who was in charge of the center there?
Yes.
Where the operations were happening? Did they contact the Commission and say, we are experiencing this problem, and what was the Commissioner's response?
Yes. So my lord, this is all set out a chapter and verse in my heads of argument. And I'm going to take you to paragraph 47 of my heads of argument. Paragraph 47 tells you the time of the telephone call, who it was made to, what the nature of the complaint was, and what advice was given by the Commission's representative, and whether it worked or not. And you will see that there are a number of phone calls made, and advice was given, But the advice often didn't resolve the issue. In fact, there were times when the commission said, log off, try start again. Let's see if it fixes the problem. Sometimes it did, sometimes it didn't. But that chewed up a lot of time. And again, when eventually we did get back on, we didn't know what we had uploaded previously. We had no record. Because remember, it doesn't keep records. It doesn't give you report backs, as the commission now knows from its own experience. So these problems were all made known, and paragraph 47 sets all of that out, chapter and verse. It tells you what we did at Birchwood while we experienced the problems in real time. It even says that we couldn't make the payment because the portal wasn't working. And then there's some story that the commission give, well, actually you couldn't make the payment because you exceeded your payment limit. That's not true. Eventually, we went and did an EFT. The portal wasn't working. We did an EFT, uploaded their proof of payment onto the portal. They never got it, as you know, for 2 weeks. It never registered on the portal. That portal does not work. It does not work, Judge. No.
Tell me now, sorry. The stage at which you paid a deposit,
yeah.
Where were you? Had you uploaded all the information, or were you still uploading? And if you are still uploading, how did you know that you are supposed to pay 500,000 as opposed to 350,000, for example?
So I'm not entirely sure, excepting that what the affidavits tell us is that you're in the process of uploading certain things, and then what the portal does is it gives you a calculation. It tells you what you need to pay. Now.
Sure.
Now, my client tells me, and this is what I understand, but I don't know for sure. But I understand that based on the signatures that they had collected, they needed to pay R500,000, and they did pay R500,000. Oh, so I'm sitting with Mr. Janse van Rensburg, who's in my chamber with me, and he tells me that he's written it on a board in front of me. He said, "My eyes wander." I'm looking at the board. He says that you pay per province. So there's a fee per province that you contest. Remember, we contested national and 4 provinces. So that's how you arrive at that fee. Now, that fee was then paid about 3.5 hours before the portal shut. It was paid at lunchtime. The portal shut at 5 p.m. Incidentally, at lunchtime, there was no one from the commission. That person had gone on a lunch break. No one there to answer any queries, and that's recorded also in the affidavits. So eventually, the Labour Party says, "I'll make my own plan," and they're going to do. But now,
the system, how does it generate the invoice before it has accepted all the information that you had uploaded? Like you wanted to contest the election nationally in 4 provinces, because it will seem to me that it does calculations based on what you have uploaded. Am I correct in my understanding, or how does it work?
Can I take an
Can you pay that 500,000 upfront before uploading, or do you have to wait for uploading to be completed before you pay whatever amount that the system will generate? How does it work? That's what I'm interested in.
Judge, I'm about to take an instruction. Would you mind if I muted while I took it and then came back? Thank you.
Go ahead.
Judge Zondi, thank you. I've taken an instruction from Mr. Janse van Rensburg. So Mr. Janse van Rensburg is the one who did the uploading. He was at Birchwood. So he tells me that it's not based on how many. You don't have to do your uploading first before you generate an invoice. What you do is you identify which elections you are going to contest. So he says it's like a little tick box. So it'll say, are you contesting national? He ticks yes. We also tick that we contest in Gauteng, Limpopo, Northwest, and the Northern Cape. We ticked those
Okay.
boxes. We didn't tick the others. Then the system generates an invoice based on that. The invoice that was generated for us was 625,000 Rand, but the system gives you a discount. That amount was discounted to 500,000 Rand, and we couldn't pay because the portal was faulty. So what we did is we did an EFT. There is, in fact, provision made to pay by EFT, but if you do that, you've got to upload proof of payment. So we did the EFT at 16 minutes past 1, in other words, at lunchtime, and we came back and we uploaded the proof of payment. And although we uploaded it long before the portal closed, as I said, 2 weeks later, the Commission still hadn't heard about it, didn't know about it. The portal wasn't giving them the right information. Portal was a problem. So, but that's how that worked, apparently, according to my client. Now, so we've got some factual disputes, maybe. I don't think they're real factual disputes for the reasons that I've given you. First of all, I don't think that the Commission's answering affidavit, I think it should be barred for reasons I've advanced, number one. Number two, even if you look at it, there are bare denials. There are no proper, genuine disputes of fact. And then in the third category, even if there are disputes of fact, I can deal with them because the replying affidavit dispels the version that was put up. Most obviously, it is absolutely ridiculous with respect to the Commission for them to say that the portal didn't give problems. Of course it gave problems. We were phoning them all the time. We were sending them emails. They had people on standby who were fielding calls. In fact, and I give the references in my heads of argument. In fact, the Commission in its answering affidavit concedes that it was receiving complaints from people and addressing those complaints. Now, if there weren't any problems with the portal, why were we phoning? If there weren't any problems with the portal, why were they dealing with us? If there weren't any problems with the portal, why did they say that they realized that there were some problems in their answering affidavit? Most importantly, they've experienced problems.
Can I interrupt you, Mr. Hobson? Can I interrupt you?
Yes, yeah. Go ahead, Choma.
Okay. What I want to know is, once you have registered to do your uploading and the submission of signatures and the list of names, are you barred from like going to the offices and doing it manually if you experience problems with the portal?
No, there are certain documents that you can manually deliver, but so there might have been a way. But remember, one can only go and manually deliver documents if there comes a moment when you say to yourself, I'm going to now abandon my attempts to make use of the portal. I realize the portal is not going to work, and now I'm going to stop, and I'm going to pack all of the information into various buckies, and I'm going to transport it to the Commission's offices, and I'm going to deliver it there. You could do that, and it's only candidate lists, not the supporter signatures that you could deliver to the Commission. Only candidate lists. But we're a long way away from the Commission. We're now sitting in Birchwood. We're sitting in Birchwood. The deadline hasn't arrived. We are battling and battling and battling. So either we abandon the portal because it's so problematic and we change tack and try another method, or we say to ourselves, hang on, I think we need to do what we can while we can in the limited time that we had available. And the Labour Party elected, and it's not unreasonable, it elected to struggle with the portal, phoning the Commission from time to time and getting help. And if you look at the times that they phoned the Commission, I've given them
perhaps you could also, and perhaps you could also do both, the online and the manual. Is that not possible?
It might have been possible, but remember, not everything can be done manually. Again, it's only the candidate lists. It's not the supporters' documents. In other words, not the 51,000 supporters' signatures. Those you can't manually go and drop off. Those have got to be uploaded in the portal. You can't get away from that. It's only the candidate lists that you had the option to do. But as I say, my client is sitting on the horns of a dilemma. You know, you have a look and you see they worked until 2 o'clock in the morning. They started early in the morning. They are frantic. They are phoning. They are sending emails. They are doing everything they can to make this portal work.
No, that's fine. Thank you. I'm answered.
Thank you. Okay. So on to whether or not the portal worked or not. I think
sorry, Mr. Hopkins,
Yes,
Professor Nhlama Makhanya, she raised her hand. Professor Nhlama Makhanya, do you have a question for Mr. Hopkins?
Yes, Judge. Thank you very much. Good morning, Mr. Hopkins.
Good morning,
Actually,
Professor.
I'm following up on Justice Zondi's question on the payment of the deposit.
Yes.
And my question is directly, on what moment does the system generate the reference number so that you can effect payment as you allege that you made payment? Because my understanding is that you get a reference and then you pay. Thank you.
Yes, thank you, Professor. So, Professor, I think what happens from the instructions that I took a moment ago is that the system itself has a page, and on that page there is a question, and it says, "Where do you want to contest?" And then next to each thing, National, Gauteng, Limpopo, whatever, there's a little box, and you then tick that box. And whatever box you tick, however many boxes you tick, the system now knows where and to what extent you want to contest. It generates an invoice. So it does all of that depending on what you've ticked. Now, it's in that regard that at lunchtime, we had then ticked the fact that we were going to contest nationally. In fact, we did it in the morning, nationally and in the 4 provinces. We ticked what we were going to do, and then we tried to pay it. An invoice was generated. We tried to pay it. The portal gave problems. Eventually, we couldn't get hold of anyone. They're off on lunch break. So what do? We go to the bank. We do an EFT. We do an EFT. We then upload the proof of payment onto the portal, and we know the rest. They've now conceded that we did pay on time, that they've received it. They just couldn't find it because the portal wasn't working. Professor, does that answer your question?
Thank you very much. Okay.
So,
okay, I'm fine, Mr. Hopkins. Thank you.
Thank you, Professor. Judge Zondi, to carry on quickly, if we can come back to the way that we deal with disputed facts in motion court, we know Plaskon Evans and we know Whiteman. Those are our 2 leading cases. When you read those cases together, what those cases effectively tell you is that you must accept the respondent's version. We must accept the commission's version unless it's implausible. If it is implausible, then you must reject the commission's version. Now, the commission's version, remember I told you, came in 3 parts. Part number 1, you didn't pay the deposit. Implausible. You must reject that. And in fact, they've conceded it. The second thing they say is the portal was working perfectly. Well, it wasn't working perfectly. I've demonstrated now in relation to the affidavits that it wasn't. And even when they said it was, I've shown in reply that it wasn't, where we produce times and date stamps and we produce evidence of actual conversations with real people. It wasn't working. We weren't the only ones. There were other people. So you've got to reject. And then the third category of dispute that you can also reject because it's implausible is that the date of registration had anything at all to do with our non-compliance with the portal. It didn't. It had nothing to do.
Well, sorry. While on that point, my understanding of the ICC Commissioner's case is that your delay in registering has the following consequences. They say the OCNS system was open to capture signatures of supporters from the 26th of January 2024. That's the first thing that they're saying. And secondly, they said it was open to capture candidates' nomination on the 23rd of Feb 2024.
Yes.
The point that I'm trying to make here is if you had registered earlier than the date on which you registered, you have been able to commence the uploading of information into their system.
Yes.
That's
So,
a nutshell of that case, as I said.
Judge
Insofar as the delay in registration is concerned.
Judge Zondi, you're absolutely right about that. But the
Yes.
question is whether or not we should be expected to have started doing things 2 weeks before the deadline. If you've got a deadline, surely you need to comply with the deadline. You can't. Let me give you an example. I need to catch an airplane. And my airplane, in order to catch the airplane, I need to be at the airport at 6 p.m. Well, if I leave home, no. If somebody at AXA says to me, if you leave home at 5 p.m., you'll get there no problem. Well, let's say that I leave home not at 5 p.m., I leave home at lunchtime, but I still can't get there for whatever reason. Why must I be penalized? It's true that had I left a week before, I would have got to the airport in time. But my aeroplane leaves. I only have to be there at 6 o'clock. Why mustn't I comply with the deadline? Why must I anticipate problems? And this ties into the Commission's entire case. The Commission relies heavily on the Liberal Party matter. Now, Judge Zondi, you will remember that in Liberal Party, candidate lists in that election had to be submitted also by 5 p.m. on a particular day. Well, the Liberal Party didn't get there on time. It was 21 minutes late. And because it was 21 minutes late, it was disqualified from contesting in the election. It says that's unfair. Why can't you just exempt me? Let me submit my stuff. I'm 21 minutes late. The Constitutional Court said no. No. When there's a deadline, you need to meet the deadline. But here's the important part, and this is the part glossed over by the Commission in its heads of argument. It's paragraph 30 in the Liberal Party judgment. I'm going to read it to you. Paragraph 30 says the following. The applicant's inability to contest the forthcoming elections, therefore, arises solely from its failure to comply with the mandatory provisions of the Electoral Act and the regulations, and cannot be laid at the door of the Commission. And that's the point. Liberal Party didn't comply with the timetable because of reasons that were solely to blame on itself. That's not the case here. We couldn't comply, not because of reasons that are solely of our own doing. We couldn't comply because the portal didn't work. In other words, the Commission is to blame. We're completely different. So, in order for us to get caught up by the Liberal Party case, we would have to show that we are blameless. We are blameless. The portal was the problem. And to say to us, yes, but you could have avoided the portal problems by starting 2 weeks before the deadline. You don't have to start before a deadline. Mr. Am, in his heads of argument, points to a very useful case where this
we've got a problem here. It's cutting. We can't hear him.
I beg your pardon?
Sorry, just Sean, are you having a connectivity problem?
Yes, we can't hear certain things that the council is saying. It's cutting.
Yeah, but I can hear him loud and clear. When did you
not
lose
all
him?
the time, but as and when you can see, even the picture is. So
it might be from your side, because from where I am, the visuals are clear,
okay,
and the sound is clear. So
okay,
it might have to do with where you are. I see there's a hand. Is it Professor Ntamamakanya or Professor Poku?
Professor Poko's hand is up as well, Judge.
Yes.
Okay.
Who wants to go first? Yeah.
Thank you, Mr. Hopkins.
And mine, Judge, as well.
Okay. Go ahead, Professor Poku, and then it will be Professor Ntamamakanya. Yes.
Thank you, Mr. Hopkins. Just on the challenges that you have just alluded to, I want to draw your attention to paragraph 46 of your founding affidavit.
Yes.
isn't the applicant there making a concession that indeed we encountered several challenges, hence, we ended up trying to register at the very late stage? Had that not been done earlier on, maybe we wouldn't be here. Thank you.
Thank you, Professor. Professor, it might be true at the level of fact that had we registered earlier, we could have gotten the stuff done sooner. That may be true. But that's not the question. The question is, was there a duty on us to start doing stuff sooner? Or did we only have to comply with the deadline? I've given the example of getting to the airport on time. Now, if I don't get to the airport on time, do I have myself to blame? Well, yes, I suppose I do, unless it's the airport's fault. I can't get to the airport. Why? Because the boom gate at the airport is not working and I'm locked out. Now it's the airport's fault. Depends whose fault it is. In this case, we were geared up and we would have easily met the deadline. Remember, the Commission's own version in the answering affidavit is you only need 1 day to get this job done. We give ourselves 2 days, twice as long. We can't get it done. Why not? Because the portal's giving problems. Why should we have started earlier? There's nothing unreasonable about the time that we gave ourselves, not even on the Commission's version. So, Professor, that's how I would deal with that particular question.
Thank you. But even if you look at para 50, although you experience some challenges, you still almost slightly over the half of the document of signatures to upload. So what does that suggest?
No. So I don't think that's what this paragraph means. Professor, what it means is that, remember, we had collected roughly 51,000 signatures. You can see it in paragraph 49. You get the exact number, 51,542. What we say is that we only needed 33,245. Why? Because if you take the number that we needed to contest nationally, and then you add to those the number that you needed to contest in the 4 provinces that we wanted to, we only needed 33,000. So we had a lot more signatures than we needed. But we couldn't even get the 33,000 up onto the portal. That's the problem. That's the problem. This thing, it kept hanging, it kept kicking us out, it kept rebooting, it kept requiring us to log in again. All of those problems were encountered. It didn't store records, it didn't give us reports. All of those were real problems that we experienced. We kept phoning, sending emails, trying to find out. None of that helped. So I'm hoping that my explanation of the numbers sort of clarifies what that 33,000 is.
Thank you, Mr. Hopkins.
Thank you, sir.
Professor Ntlama-Makanya, we have got a question for Mr. Hopkins. Yes.
Yes, Judge, thank you very much. Mr. Hopkins, you made mention earlier that you only learned of the date on the day when the timetable was published. You didn't know about it. And also, my question to that effect or allegation goes to your initial introduction to this court, that in order to ensure free and fair elections, the Commission is put in a pedestal to undertake that responsibility. I'm relaying this to you because as much as we have a right as well to participate in the elections, it is a core responsibility that is attached to the right. My question is, were you also not part as an organization of the consultation process that adopted the timetable so that we don't find ourselves in the situation that we are faced with today, wherein the timetable was approved for the date to submit the candidates? Thank you.
Thank you for the question. So the question that you ask, strikes to the heart of the case, and it's the section that I want to come to next. So it's good timing. And that is, what is our case really all about? What our case is about is we don't have a problem with the timetable per se. We don't have a problem with the timetable. In other words, we don't mind. We don't say that the deadline of 8 March, 5 o'clock on the 8th of March, we don't say that there's a problem with that deadline because it's a deadline. We say that the deadline only became problematic when we wanted to use the portal, but the portal wouldn't allow us to upload stuff. If the portal was working, the deadline would not have been an issue, and that is clear from the affidavits that have been deposed to by Mr. Janse van Rensburg. He says as much. He says if the portal was working, there would have been absolutely no problem. Then, as the Commission says, one day would have been enough. Problem is the portal wasn't working, and that's why the deadline became a problem. So I'm hoping that addresses the issue in that regard, that it's really not a timetable problem, but a portal problem. No.
Okay.
Should I move
thank you
on?
very much, Mr. Hopkins.
Thank you for the question. So what we find in and perhaps just to assist you, Professor, is paragraphs 54 to 66 of my heads of argument. Those paragraphs tell us what the case is about. They also tell us what the case isn't about. Those are extremely important paragraphs. And as I point out in the heads of argument, it was necessary for me to deal with this in the heads because the Commission continually mischaracterizes our case. The Commission continually says, your problem was with the timetable. You should have challenged the time. Our problem is not with the timetable. We continuously say it wasn't with the timetable. We continuously say it was with the portal. We couldn't comply with the timetable because of the portal. The problem was with the portal. Now, it's wrong for the Commission to continually mischaracterize our case by saying, in fact, at one point it says it's quite clear that its real problem is with the timetable. It should have challenged the timetable. That's not at all the case. Either it doesn't understand or it has deliberately mischaracterized it in order to show that we've challenged the wrong decision. And that brings me to the next point. What is the decision that we've challenged?
Now, before you get there, sorry, Mr. Hopkins, before you get there, in one of the responses that the Commission gave, it stated that the applicant only uploaded its first candidate at 16:24 on the 8th of March. That's what it says. 16:24.
Yes. So what is explained by the Labour Party is the process that it adopted, and I want to take you to it because in this, Mr. Janse van Rensburg says it's paragraph 47.2 of my heads, and they give you all of the references in the affidavits. But what he says, I've never done this before. This is my very first time. I didn't know what order to upload the information. So he says, what I did is you're talking about we uploaded our first candidate. We had 12 candidates. He says we uploaded the first of the 12 at that time, roughly 2 hours before the portal.
Sorry, you had, the applicant had 12 candidates.
Yes. 12
Right.
national candidates. 12 national candidates.
Yes.
But what it says though is it says why? Because it spent it spent all of the time up until then trying to get the supporters' signatures and supporting documents uploaded.
Now, out of the 12, how many were you able to upload?
I think 10. I understand 10 according to the affidavit. 10 of the 12.
And then you required about 30,000 something supporter signatures.
Yes.
Is that so?
Yes.
Out of that 33,000
Yes.
support signatures. Now,
Yes.
out of that 33, how many were you able to upload?
So I've got two responses to that. The first one is we don't know, as we say in the affidavits, because you don't get reports and feedback. The portal doesn't work; it doesn't give you that. And I've shown you that the Commission had the same problem, but the Commission try and tell us a little bit about it. They give us an idea, and I just need to find where they've done it. We invited them to tell us because we had no idea what was going on. So we invited them to tell us, and they tell us, if you look on page 49 of Mr. Bishop's heads of argument. I think it's round about there. Now, I may be mistaken. But that's where he sort of gives us an indication. But maybe he doesn't also give us the numbers because we just didn't know what those numbers were. We really didn't know what those numbers were.
Okay, well, Mr. Bishop will assist us then.
He will hopefully assist us, yes. Let me just have a look. Yeah. So, and there is a section in the founding affidavit, repeated in the replying affidavit, where Mr. Janse van Rensburg says, I don't know what happened. You know, we don't get feedback. We don't get reports. So I've explained what the case is about, Judge Zondi. The case is about you can't meet the deadline because of the portal problems, nothing other than that. So now what's the decision? Because what the Commission have said to us in their papers and in their heads is they say to us, no, you've challenged the wrong decision. You should have challenged the timetable. Well, the very first point is we didn't have a problem with the timetable. It only became problematic when the portal didn't work. So we couldn't challenge the timetable. We didn't have a reason to do it. That's the first point. But the second point is, when we did have an issue, we lodged a complaint with the Commission. We went to the Commission and we lodged a complaint. Why did we lodge a complaint? Well, we didn't know what had happened. Media reports were reporting that other parties had lodged complaints. An open letter that had been sent to the Commission had been published on the internet, had been circulated amongst people. We were part of a WhatsApp group.
Sorry, when did you lodge a complaint with the Commission?
On the 6th of March in an affidavit.
The complaint was about what?
Well, what we do, we file an affidavit in the High Court. It was Judge Muki J.
Yes.
Presided, and what we say to him is, in our papers, is we say to him that we don't know. We're aware of the fact that a lot of political parties have lodged complaints with the Commission, but we don't know whether the Commission has made a decision as to whether it's going to grant an extension or not. We say that. Why don't we know? Well, because there are conflicting versions in the media. Judge, my computer has just told me that I'm going on to battery saver. Would you mind if I get my power cable and just plug in?
Yes, sure. Go ahead, yeah.
Thank you.
Yes. Go ahead.
Unmute yourself, Mr. Hopkins, unmute.
Oh, beg your pardon. I'm so sorry. So sorry.
Sure.
Thank you. So where we were was you asking me, Judge Zondi, when it is that we lodged our complaint. And I was saying to you that we were part of various WhatsApp groups, and we saw on the internet, we read in the newspaper that various people had complained to the Commission, effectively wanting an extension of the deadline in item 9. But we didn't know what was happening, because in one report, one of the commissioners, acting as a spokesperson at a media conference, said we're not going to make any amendments because the timetable is cast in stone. That's very important. This is the commissioner. The commission in its heads of argument misunderstands the point. It says that the commissioner can't make a decision. We're not saying she made a decision. The decision had already been made by the commission. We are saying it's a reason. In a review, you challenge the reasons for the decision. The reason for not amending the timetable was given by the commissioner. And that reason was, well, it's cast in stone. In other words, I can't do anything about it. I see in the Commission's answering affidavit, it says, cast in stone doesn't mean that you can't do anything about it. Well, that's not correct. So what I did it.
Sorry, Mr. Hopkins. Are you challenging the reasoning or are you challenging the decision? And if it's a decision, which decision are you challenging?
Okay. Let's start with the decision.
Sure.
So we don't know whether a decision has been taken definitively to amend or not to amend the timetable. So we force the Commission to tell us whether they will amend or whether they won't amend. How do we do that? We bring an application to the High Court, and we say to the High Court, they've got an obligation. They've got an obligation to tell us. And they are evasive. They are so evasive. They won't say anything. They say, I refuse to tell you whether I'm going to amend it. I don't have to tell you, they say. Well, Judge Muki says, well, if they tell you that they're not going to take a decision, then that is a decision. It is a decision of itself. They've decided not to amend the timetable. That's what Muki says. And I see the Commission come back in an affidavit saying they accept that this is what Muki J says, but they disagree. And the basis for their disagreement is they say I never had to make a decision in law. You can only impute that I didn't make a decision if I had an obligation in law to make the decision. And they quote off it as a case. And they're absolutely right. I agree with that. The question then becomes, did they or didn't they have an obligation in law to make a decision? In other words, to adjudicate the complaint that we had raised. Did they have that decision? They say, no, we didn't have that decision. We say they did. And we refer to Section 510 of the EC Act. And my lord, you will remember that Section 5 of the EC Act sets out the powers, duties, and functions of the Commission. 510 says it is a function of the Commission to adjudicate disputes which may arise from the organization, administration, or conducting of elections, and which are of an administrative nature. We say, well, you've got a timetable. You've got a prescribed manner of compliance within the time periods in the timetable. You have organized this election. You are administering it. You are conducting these elections. I've asked you to adjudicate my dispute because I don't like the way you're doing it. And now you tell me you don't have any duty to adjudicate the dispute. Well, I'm showing you where the duty is in the Act. The response to this from the Commission is they say, no, you misunderstand. The adjudication function referred to in the Act is the Commission adjudicating disputes between two political parties. So you've got two political parties and they're fighting with one another. He says the Commission can adjudicate that dispute. But they say the Commission can't adjudicate a dispute against itself if you complain against what the Commission has done. So we need to interpret Section 510 of the Act to see what it really means. How do we do that? Well, we do it in accordance with the Endumeni principles. Now, I'm not going to sort of state the obvious at all, but I can tell you that Endumeni is dealt with in paragraphs 73 and 74 of my heads of argument. But essentially, you will know from Endumeni that you look at the literal meaning of the text, but you don't consider it in a vacuum. You must also look at it in its context. Now, when you look at the literal meaning, you don't see anywhere in the wording of the section that the Commission is limited to only adjudicating disputes between political parties. It doesn't say that. It says something completely different. It says adjudicating disputes dealing with the administration of an election. Now, the only person that can administer an election is the Commission. So if you're unhappy with something that the Commission has done, then that's your dispute, and that's what it must adjudicate.
Sure.
So that's both the literal meaning and the context. I've summarized it for you because there are, in fact, 17 different propositions that get me to the conclusion that I've given you now. And, my Lord, I'm so conscious of taking up time here.
Yes.
So I don't want to carry on, but I
Sure,
would refer
yeah.
you, please, to my heads of
Take
argument.
You must take it that we have read your heads of arguments. So yeah, just deal with the points that you think that are important for
Thank
us
you,
to know.
Judge Zondina, more than that, the Commission has the power to amend the timetable. It gets that power,
Yes.
as you know, from Section 21A of the Act. Now, if it's got the power to amend the timetable, then any decision that it takes to either amend it or not amend it is a reviewable decision. Right?
Yes.
Why? Because if I look at the power of the court, the Electoral Court, you were established, you as a court were established under Chapter 5 of the EC Act. And you've got two jurisdictions, appeal and review jurisdiction. Your review jurisdiction is to review any decision. That's an extremely wide power, because any decision means any decision of the Commission. Now the Commission wants to say not any decision, only decisions that have to do with me dealing with a dispute between two other political parties. That's not at all what the Act says, not the EC Act, not Section 5 of the Act, not Chapter 5 of the Act. They say any decision. So I think that a decision then not to amend the timetable is a decision that falls under any decision. It triggers the jurisdiction of this court, and that's what we're reviewing. We are reviewing their decision to do nothing about the deadline in the timetable, knowing that people can't meet it because there are problems. That's what we are reviewing. And the question then was, and I'm coming to the end now of my submissions, my Lord, you'll be grateful to know, is what are the grounds of review? And the primary ground of review is an error of law. And you find this being dealt with in my heads of argument, and I'm going to give you the paragraph so that I don't have to repeat stuff. I think it's paragraph 79. Paragraph 79 deals with the grounds of review, and the very first one is you've committed an error of law. And as you know, my Lord, from cases like the one that I quote in paragraph 82 of my heads, the union government case, an error of law is when an administrator doesn't appreciate the discretion that they have under the law. Now, I can tell you now that the Commission didn't appreciate the discretion it had. It gave a meeting, a press conference, saying, we've decided that we can't amend the timetable. And here's my reason, says the spokesperson of the Commission at the press conference. It's cast in stone. In other words, I'm not allowed to. I can't do it. It can't be done. It's cast in stone. We know that it's not cast in stone. In fact, we know that the Act says it's not cast in stone, and the timetable must be amended when it's necessary to do so. So the Commission completely misunderstood its discretion. It committed an error of law. Now, I hear Mr. Bishop in his heads of argument saying, no, that's not what casting stone means. Casting stone means something else. So what I did before I came here is I went to a legal dictionary, the Merriam-Webster Legal Dictionary, which is an online dictionary, to Google what it means, casting stone. And I'm going to find the page from Merriam-Webster. It says the following. It says, a permanent decision not able to be changed. And then it goes on to say, it gives an example. It says, these new rules are not carved in stone. If they don't work, we can change them. So it does mean that if it's cast in stone, it can't be changed. There is Microsoft have got a thing called the free dictionary. So if you've got a Microsoft subscription, you've got a free dictionary there. And I also looked up cast in stone, and let me tell you what it says. It says, permanently fixed or firmly established, not subject to any amendment or any alteration. often used in the negative. For example, the deal isn't cast in stone, meaning that it can go ahead. So that's the point. The point is that it means exactly what we say. And that's the problem. The Commission laboured under the idea that they couldn't amend the timetable, but they could. And in fact, the Act says they should have, if they felt that the elections weren't free and fair. So they laboured under the wrong impression. The second error of law is the one that I've referred to now, and that is the Commission saying, well, I couldn't make a decision anyway. I know you complained to me, but I can't make a decision. I can only make a decision about when to set the timetable. Adjudicating a dispute of the kind that you've got isn't one of my functions. Well, I've tried to persuade you that it is one of their functions, and that they were wrong to assume that they couldn't do that either. So they laboured under two misapprehensions of what the law is, and both of those tainted the discretion that they exercised and made them take a decision to refuse to do anything in circumstances where they should have. There's another ground of review, and that is we review the decision to say, well, you're disqualified anyway because you didn't pay the deposit. I've dealt with that. They've conceded it. So that ground of review, they've conceded. They conceded that they're wrong. And then, my Lord, I want to remind the court about the Witbank Town Council. I give the case in my head, paragraph 85. I won't repeat it, except to say that the ratio is that where a decision maker gives more than one reason, all you've got to do is to show that one of them is wrong and the whole decision is vitiated. I've only got to satisfy you that one of the reasons that they gave is wrong. They've already conceded that one of them is wrong, but in relation to the timetable, they are absolutely wrong that it's cast in stone. Absolutely wrong. It's not cast in stone. And they're also wrong in my submission that a proper interpretation of the Act shows that they should have adjudicated the dispute and made a decision for us to review. They chose not to. So, my Lord, those are our grounds of review. There's one other, which is rationality, and that I set out in their heads. It's an easy one. It simply says that if you are given a power to do something, then you act irrationally if the situation arises that calls for action on your part, but you do nothing. That's pharmaceutical manufacturers. In this case, they're given the power to amend the timetable. A situation arises where it needs to be amended. They refuse to do so, even though they've got the power. They were then irrational, because their conduct is not rationally connected to the power for which the statutory provision was given. So where are we? Where are we, my Lord? If you are with me that there's a ground of review, then the decision should be set aside. It's then up to this court to make a just and equitable order. And I submit, my Lord, that for reasons that I deal with quite heavily, and I'm not going to canvass now, I think Mr. Am can do it in his heads, but in CAM, this court said that the intervention of the court is required if the election is not free and fair. But the court said, I can't tell you what a free and fair election is. You'll know it when you see it, but I can't define it. Now, I'm telling you that I think that we know that this election will not be free and fair if people that genuinely wanted to contest it had enough support to do so, but couldn't because the portal gave problems. It cannot ever be free and fair to disqualify them. So the way that I think CAM should be interpreted and applied to the facts of this case, there are 5 very short bullet points. Number 1, free and fair elections is a value judgment. The impact of the decision and the perception to the public should inform the values. Now, the impact here is serious. You're disqualifying a lot of political parties. You're disqualifying them. Even though there's a constitutional right for them to be able to participate, you're disqualifying them. That's hectic. That's number 1. And there's a perception.
Sorry, Mr. Hopkins, in your case, are you disqualified, or what's the situation here because you do not know the number of support signatures that you were able to upload? You told me that at least you were able to upload 10 out of 12 candidates.
Yes.
So
yes. So we upload those candidates.
The failure of the system, to what extent did it affect your right under Section 19 of the Constitution?
It affects it as follows, because let's
Yes.
just have a quick look. I know we all know what Section 19 means,
Yes.
but it means that every citizen is free to form a political party and to participate in the activities of an election, essentially, and to campaign as a political party. Now, what happens with the portal is that we can't participate in this election and campaign in this election if we didn't get all of the information that we needed onto the portal on time. We had it in our possession, but we couldn't get it onto the portal. So we had it, but we couldn't get it on because we did everything we needed to, but the portal let us down. The portal wasn't working properly. And
how much more information do you still need to upload? Let's say we're on you on this point. Let's say out of 31,000 that you still needed to upload, you only able to upload 20,000. So the 10,000.
Yeah, so he says so Mr. Janssen van Rensburger, as I said, he's sitting with me now, tells me that at least half of it's up. He thinks probably half of it. 2/3, he says. 2/3 of it is up, but he's not sure because he doesn't have that proper report. But he thinks, he estimates 2/3, but he says the rest of it, he's got it. He's got it. It's all there. He just couldn't upload it. So, yeah, and we can give it physically as well. We've got it in boxes. All of the paperwork is there. We just couldn't get it on the portal, but we've got it. We've got it. So we don't need time to go and gather anything or capture anything. It's all done. We just need to upload it. And my lord, what he says to me, Mr. van Rensburg, is he says, if you were to open the portal, as I say, after this hearing, if you were to open the portal for the weekend, everything will be up by the end of the weekend. Everything will be up. It might even be up within one day. Provided the portal works, everything will be up because we've got it. We've always had it. We had it before we got to Birchwood. We still have it now. We just need to know that the portal won't let us down. So one last thing quickly. The final point to come from the value judgment that I take out of the CAM judgment is that, and in CAM, they rely on a California decision where the court says that one of the most important things for an electoral court to do is to preserve the integrity of an election. You can preserve the integrity of this election by opening the portal. If you don't reopen the portal, there's a terrible perception that these elections are not free and fair. And you can easily save it in a fairly non-intrusive way by simply opening the portal and say, well, get your stuff on the thing and do it quickly. Do it quickly, let's get it done. And that's all that we ask. It's all that we ask. And the final point to come from CAM is that when there's doubt,
but hang on. Let's say we allow you that opportunity. But
yes,
how is it going to affect the IEC's timetable? Because there are certain steps that needed to be taken or certain steps have been taken and you can't go back to them. You can't go back and forth.
Well, Judge Zondi, it's really for the commission to work that out. You know, I can't tell you because I don't know exactly, but what I can tell you is that the commission can't compile an incredibly tight schedule and have the constitutional obligation to amend it if there's a problem, but then to say, well, I made it so tight that I'm afraid to say I can't change it anyway, because then the power to change it becomes meaningless. If we're going to take the Constitution and if we're going to take the Act seriously, then we've got to recognize that changes must be capable of being made. We brought this review a month ago. A month ago. Not our fault that it's taken a month to get here. We complained about it a month ago. Not our fault that the commission didn't deal with it. It refused to deal with it. Why should we be punished? We are innocent citizens who have a constitutional right to do something. We merely ask you to vindicate that right. And, my lord, we say it's an unintrusive remedy. And we think it's just and equitable. And if you don't do it, unfortunately, there will always be a perception that this election is not free and fair. And if that's the case, what CAM says is err on the side of caution. You should, my lord, err on the side of caution. Those are
Can I ask the question?
Sorry, Judge Shong has got a question for you, Mr.
Yes.
Hopkins. Yes,
Yes.
Judge Shong.
Yes, you spoke about the case in the High Court of Judge Moki. What was the conclusion in that case?
So in the conclusion in that case is that, so remember we brought We brought the application to force the Commission to make a decision.
Yes.
And what they did is in their answering affidavit, they said, we are not going to accept your invitation to make a decision. So then I argued in front of Judge Muki that effectively by doing that, they have made a decision that they're going to do nothing. And that's what we're going to review. So that decision of theirs was then made on the 7th, not to do anything. It's that decision that we reviewed within 3 days as we were required to do. We brought that review to this court.
Yes, well, the conclusion was that the court said the IEC had made a decision. What was the conclusion? What was the order?
The order was that, so we asked that court for an interim interdict to keep the portal open until we could bring the review here. The court said, no, you're not going to get an interdict, but you've now got the decision that you wanted. So bring your review, take your review to the IEC. And when take your review to the Electoral Court. And when we did that, the Commission expressly said, you can go and do that because the court has got the remedial power to assist you if you can prove your case. The question is whether we can or can't prove our case. And in my respectful submission, we have proved it.
Thank you very much.
Thank you for listening to me. I appreciate it. Judge, you muted.
Sorry, any question for Mr. Hopkins? Judge Adams, are you still with us?
I'm still here, Justice Zondi. I have no questions from my side. Thank you.
Professor Ntamamakanya, any question?
No questions as well, Judge, on my side.
And Professor Poku, any question?
No questions from my side, Judge.
Thank you. All right, thank you, Mr. Hopkins.
Thank you, judges. Thank you.
Okay. So you said, Mr. Hopkins, sorry. Then you come back, Mr. Hopkins.
I'm back. Yes.
Okay, you said Mr. De Beer was going to argue which point in terms of the arrangement that you had.
In terms of the arrangement that I had, so I've argued for the Labour Party. Exactly the same issue arises for ACT, and Mr. Am is going to argue that.
Oh, sorry, Mr. M, ACT. I think that let's go to him. So he's going to take off where you left off.
Presumably. Thank you.
Let's go to Mr. M, ACT, no?
It's 12 o'clock, so good afternoon,
Okay.
Justice Zondi, and to the members of the court.
Right. Yes, proceed, Mr. M.
I appear together with my learned friend, Mr. Peter. There are certain overlaps between the cases, the case advanced by my client and Mr. Hopkins's client. But if I can just point out what the differences are, because there is a fundamental difference. In Mr. Hopkins's case, as we understand it, the complaints pertain to the failure to pay a deposit, which is no longer a complaint, a failure to upload all of the supporter lists, and a failure to upload candidate lists. We don't have the difficulties with the deposit or the supporter list. Our case deals solely with with an inability to upload the candidate lists. And I don't want to put too fine a point on it, but with respect, the Commission mischaracterizes the case. And by saying I don't want to put too fine a point on it becomes a matter of language. The Commission's case is quite simply that we failed to comply. Our case is that there was an objective inability on the part of our clients to comply. So an objective inability certainly doesn't carry with it the pejorative sense that would accompany a failure, particularly a failure of the type of that manifested itself in the Liberal Party matter. Now, how I intend to structure my argument, obviously subject to considerations of time, is on the following basis. There's a small housekeeping issue which remains outstanding, and it relates to an amendment to the notice of motion. I'm then going to make some general opening submissions, But in making those submissions, I will be dealing pertinently with certain of the arguments that are advanced in our learned friends' heads of argument, and I must compliment them because they have managed to complete a gargantuan task in a limited period of time. So, but we obviously don't agree with what's said in those heads of argument. Then I'm going to make certain submissions by referring the court to aspects of our heads of argument. I proceed on the basis that the heads of argument have been read and understood and digested, so I'm certainly not going to belabor that. Then I'm going to deal specifically with section 22A. Then I will turn as the fifth topic to disputes of fact. And then, because it is a dispute of fact relating to the portal malfunctioning, that will be the sixth topic. And then I would want to deal with the relief we seek in the issue of costs. Now, if I can just, even before that, tell you who my client represents. My client, in respect of the supporters list, as I understand it, was obliged to meet the minimum threshold of just over 50,000 supporters. It produced a supporter list of 121, just short of 121,000 supporters. It also, be in anticipation of the section 27 submission process, hired a venue, being, I think it was the Sandton Convention Centre. It got 20 people together to assist with the submission, and ultimately that team was led by a team of 4 individuals that dealt with the submission of the lists. But as to the compiling, there was a team of 20 people, and the reason why that venue was picked are exactly the same reasons why Mr. Hopkins's client picked their venue. It was because it had a secure and consistent and reliable internet access. And so if I can just dispel that complaint, the complaint of the commission is, well, the reason why you didn't meet the time period is because you had connectivity issues and you were using old computers. But that's just a complaint that, with respect, is thrown up into the air, unsupported by any facts. Now, the other difference where our case departs from that of Mr. Hopkins and his client is we also seek, as an alternative, to review the decision of the commission in respect of its, we want to appeal the decision of the commission in respect of its finding, and it's quite positively dealt with by Mr. Hopkins, that there is a finding that that date of the timetable, particularly our concern is item 9 of the electoral timetable, which dealt with the submission of candidates in terms of section 27, and that had to take place before 5 o'clock on the 8th. That's our only complaint. But our complaint is not a complaint that exists within the context of item 9 within the election schedule or the election timetable. Our complaint exists within the context of the portal not functioning on the 8th when it should have functioned. So we have no complaint with the election timetable. Had the portal functioned as it should have, then our client would not be sitting here today. And we would not be having this debate. But there is also an appeal. And to that end, it's in terms of section 20.
Hang on, Mr. N.
Yes.
Well, I think that you are well aware that you need leave of this court to appeal.
Yes.
Did you seek and obtain leave of this court to appeal against the decision of the IEC?
Your Lordship's question is quite prophetic because that's the reason for the amendment to the notice of motion.
So that appeal is not properly before us.
Well, it's subject to the notice of amendment, and it's to include that specific relief. We haven't heard any objections or complaints from my learned friend or the commission, so I don't know what their attitude is to the appeal.
Yeah.
But our primary case with respect is the review. This is sort of the. I'd like to say
alternative.
It's not quite.
Alternative is an appeal.
Yes, an appeal.
Okay.
But ultimately, what the appeal, whether it's an appeal or review, it relates to the same decision. And Mr. Hopkins has already dealt with that. If there is no objection, we would ask for leave to move the amendment to include specifically paragraph 2A in the notice of motion, which deals with the chairperson's consent, and that the appeal be determined together with the relief. Now, in my learned friends' heads of argument, they make the point that deadlines matter. And we don't dispute that deadlines, well, we don't contend for a moment that deadlines don't matter. But this is not an absolute requirement, and it's certainly not carved in stone. Because if deadlines were carved in stone, there would simply have been no reason for Parliament to have included Section 22A, a provision which grants the Commission the express power to amend the timetable. So the starting point and the very fundamental defect in the attitude with respect of the Commission to this matter, and there's a brave and valiant attempt, as Mr. Hopkins has already dealt with it, to walk away from what they intended to say when they use the phrase, I think it's, what do they say, carved in concrete. But we know for a fact that the election timetable is not carved in stone or cast in concrete, because there is that express power in Section 22A. And that power must be exercised for purposes of rendering the elections free and fair. It's as simple as that. I'll deal with the rather intellectually gymnastics, or the intellectual gymnastics that my learned friends engage upon in order to try and separate themselves from an obligation under Section 22A, and I'll deal with that in due course. Our learned friends also similarly say in their heads of argument that rules also matter. We agree rules matter, but for the same reasons they are not carved in stone. But rules cannot, with respect, be carved in stone where it's objectively impossible to meet those rules. It's objectively impossible to comply with those rules, and it's objectively impossible through no fault at all of my client to comply with those rules. And if the Commission were to regard the rules as being carved in stone, irrespective of an objective impossibility, which has two particular features, lies solely within the hands, the cause of the objective impossibility lies solely in the hands of the Commission and their portal. It's a portal they designed. It's a portal that is not disputed. Parties were strongly encouraged and to use. In actual fact, the reference in the affidavit is they believed it was compulsory that be used, but that manual submissions were also possible. And in due course, I'll deal with the question His Lordship Justice Shongwe put to Mr. Hopkins regarding the manual submission of lists. Now, the objective impossibility has two features, as I indicated. The first is that it's an impossibility that's created, and the responsibility for the impossibility lies with the Commission. The second is the other side of the exact same coin. The impossibility is not my client's fault. And the door is opened with respect for an amendment and leeway to be given by the court in the Liberal Party matter, where the impossibility to perform is not dependent upon any fault of the, in this instance, my client. Now, if we can just place the Liberal Party decision in its proper context, because that's a drum my learned friends beat repeatedly in their heads of argument. But with respect, it's the wrong drum. Either it's the wrong drum or they're not listening to what's coming out of it. The Liberal Party was late by 21 minutes in submitting its list. Okay? Its excuse for its failure to submit the list was essentially threefold. Its excuses. The first was that it was a newcomer to the political scene. The second was that it had limited resources. And the third is that it was initially unaware of the formalities that had to be complied with in order to enable it to participate in the elections. So that was the high water mark of the failure. And it's not an inability, it's a failure to timeously make the relevant submissions. And they were 25 minutes late. So 21 minutes late, and because they were 21 minutes late, they did not comply with Section 27 of the Act. The court said the only possible way, and it considered Section 28, and it found that 28 didn't apply in these particular circumstances, and this is the Constitutional Court, said the only possible way to avoid the consequences of Section 27 would be for the Commission to change the actual election timetable, which it is empowered to do in terms of Section 20. but it can only exercise that option if it is necessary for a free and fair election. And the court then found, as Mr. Hopkins has already read to you in paragraph 30, that the applicant's inability to contest the upcoming elections arose solely from its failure to comply with the mandatory provisions, and which cannot be laid at the door of the Commission. So the other side of that coin is that there are circumstances which can arise where the fault for non-compliance should be laid at the door of the Commission. And this is exactly that particular situation. And it's in the particular circumstances of the Liberal Party case that the Constitutional Court was disinclined to grant direct access and disinclined to uphold the appeal. Because if they had to compel the Commission to reopen the election, they couldn't do it on an ad hoc basis party. In the particular they couldn't do it on an ad hoc basis for one party. In the particular circumstances of that case, they would have to open it for everybody. That would then result in a new timetable which would be applicable to all the parties. It would affect all the parties contesting the elections, and it would then open the door for other parties to seek changes in the timetable. None of those features with respect appear here, primarily because this is not a fault that can be placed at my client's door, but lies at the door of the Commission. And the allowance, in allowing the limited relief that Mr. Hopkins has already referred to, it can, with respect, be only allowed to those parties that have approached the court with legitimate complaints about the portal. It cannot be a free-for-all carte blanche opening of the portal to everybody who didn't make a time period. If they did not exercise the rights that they had in terms of the Electoral Act or the Electoral Commissions Act, then they shouldn't, with respect, be entitled to that access. So it's certainly not a case of a free-for-all and we start over from scratch, which is really the high point of the opposition to the Commission to effectively amending the timetable. And it's only item 9 with respect that would need to be reconsidered, and item 9 deals with the submission of submissions and compliance with section 27. Now, it's not without some moment that at the very least in 2 separate places in my learned friends' heads of argument that they refer to the Liberal Party matter, and they refer to the fact that the blame is not to be placed at the Commission's door. But as I've already indicated, inherent in that surely must be, well, what happens then if the blame is to be placed at the Commission's door? And that's where the factual dispute.
Sorry, I just want to remind you, somebody switch on their video. Just switch it off, please. Yeah, just wanted to remind you, Mr. M, that your 15 minutes of immunity is over now. Okay.
I'm happy to answer whatever questions that the court may ask, but
the decision against which, well, your review is directed at which decision? There's something that I didn't understand there. What is the decision that you are challenging?
The failure of the failure of the Commission to, first of all, acknowledge and entertain the statutory power that they have in terms of section 22A, namely to amend the timetable, and their failure to make a decision in respect of section 22A, or in as far as they made a decision, they, with respect, simply made the wrong decision on an irrational, reviewable, and unconstitutional basis. So it ultimately...
that will be the reasons, but the decision that you are challenging is a failure to make a decision.
Yes.
Is that what you are challenging?
Yes, but more fundamentally than that, you will not find, as far as we've been able to establish, in the context of our learned friends' heads of argument and the context of the case brought by my client in the affidavits, a single mention of the Commission actually referring to an instance where they applied their minds and considered section 22A.
Okay, but, well, that will be the reason for not making a decision or for making a decision. But but your review must be directed to a decision.
Or a failure to make a decision.
Yes, I feel like
Yes. Yes.
now, what is that decision?
The decision is a failure to
Yes.
to effectively, and we can only look at the result because we're looking at reliefs and remedies, is a failure to accommodate a failing on their part and to accommodate and remedy the consequences of a failing of their part within the context of item 9 of the election timetable.
Well, is it not about a failure to amend item 9?
Yes.
That's basically what we're
Yes.
looking for.
Yes.
Failure to amend, a refusal to amend item 9 of the timetable.
But sorry, I don't want to second guess your lordship. They never even considered section 20.
Okay, well, yeah.
Because we certainly can't find a reference. And if our learned friends can point to a reference in their heads of argument or in the answering affidavit in our case where they claim that section 20 and the power afforded to the commission was considered, grappled with, discussed, but found not to be applicable because of A, B, and C. We can't find such a reference. So as I said, it's a multifaceted decision and non-decision that they take, but it centers on a situation which they create, and it is solely of their creation, and a failure to undo the prejudice that results from that. And it's with
It's 61, 1961, I was 4 years old, and around that time, it's 61, 1961, I was 4 years old, and around that time is when my family went into exile, and many other people's families. Those killings actually ended the discussion is in Arusha, because we needed to understand what was going on, why we go on and go anywhere in the country, ask anybody you wish to live there. They tell you a story that decent progress we're making in social economic areas cannot be, when I look back, I think to an extent, it's not just the right things we have done. There's a bit of luck, there's with so little that the country has, and the magnitude of the
party. So the dispute regarding the organization of the elections can only arise within the context of who is responsible for the organization and the management of the elections. And importantly, our learned friends do not point in their heads of argument to any authority that supports their proposition. Now, the case for the Commission is neatly summarized in paragraph 32 of their heads of argument, and I'll read it to you because it just shows you with respect the blinkered approach, the blinkered and with respect irrational and unlawful approach the Commission adopts. Paragraph 32, page 13. Rigorous adherence to the timetable by the Commission and the parties is a fundamental requirement for free and fair elections. If the Commission failed to apply Section 27, the submission regulations and timetable, that would create the risk that the election would not be free and fair. Enforcing the law has the opposite effect, freeness and fairness. But what that ignores, entirely ignores, is that there is no requirement that the timetable must be rigorously adhered to, particularly in circumstances where there is an objective impossibility to comply with the timeline, and where the cause of that objective impossibility is the Commission itself. And with respect to the position adopted by the Commission in 32, which summarizes the entire attitude to this matter, is irrational, unlawful, and reviewable. There's no regard whatsoever to Section 22. If I can now...
Sorry, Mr. M, but what about the Commission's argument that their systems were okay, there was nothing wrong with their systems, they were working properly, some other political parties were able to log on in time, they were able to upload their candidates' nomination timeously, and it's only those parties that waited until it was too late.
If I can answer,
that were frustrated.
If I can give two answers to your Lordship's question. Again, your Lordship is too quick for me.
Oh, okay.
Those are, with respect, I'm happy to answer them now, but they are the fifth and sixth topics that I want to deal with: the dispute of fact, and firstly, sure, the portal. But what I did threaten the court with earlier was the National People's Party judgment. I gave you the first portion of the judgment at paragraph 37.114 of our heads. But if I can ask the court with respect to particularly have regard to paragraph 59 at page 32, because this is the crux, and it's with respect the subject matters of which the learned professors, as I understood it, put questions to Mr. Cochrane. Because it's that will, if you only have yourself to blame if you leave it to the last minute. I think that's, if I can just as crudely as put it like that, and it's more euphemistically put in our learned friends' heads of argument because they use the word tardy or tardiness. But if you read the quote at page 59, page 32, paragraph 59, the first contention, and then we've put in quotes what the contention is because it appears from the paragraph before that, namely that the applicant's woes were self-inflicted by reason of it not acting in good time, and that's the wording used, is imprudent and simply lacks respect for the applicant's rights. It is not capable of being sustained. So what is not capable of being sustained is, well, you left it to the last minute. You should have acted sooner. The fact of the matter is that the timetable had been established and requirements can be fulfilled at any time within the confines of that timetable. That a particular party or person chose to comply therewith at the last minute does not detract from the right to participate in the election or exercising the right to do so. To suggest that the applicant has only itself to blame and that the chairman would not have had to rush if the requirements had been complied with long before is not helpful. The applicant was entitled to submit the documents at any time before 1700 hours on 25 March 2011. Now, but if I can just take that a step further, there are two important...
Sorry, before you proceed, I see Judge Strong has got a question for you. He has raised his hand.
Certainly.
Yes, Judge Strong, proceed.
Afternoon, Judge.
Yes, afternoon. Well, I just want to ask one question, before you proceed further. Did you, meaning your clients, file a complaint or an objection to the commission regarding the non-functionality of the portal?
It's something I'll deal with shortly, but the answer is yes. At least 10 phone calls were made to the two hotline numbers during the course of the afternoon on the 8th, and my client also attended, albeit after the fact, at the offices of the Commission. And correspondence was addressed by my client's previous attorneys. I think it was on the 12th or the 13th of March, around the difficulties experienced with the portal. So they were definite. This is not an afterthought. My client raised its hand and sought to remedy the difficulties posed by the portal on the 8th, and we're only concerned with respect with the 8th, and more particularly, we're only concerned with a period of 1 or 2 hours on the 8th, and I'll deal with that shortly. But Justice Shongwe, have I answered your question?
Yes, I'm answered. Thank you.
Thank you. There are two important points which we submit are important within the context of this application, the merits of our client's application, and within the context of the relief this court can grant. The first of that, and it's in the answering affidavit in this matter, I've got it at index page 142, and it's paragraph 43.2. It's a reasonably long paragraph, but it concludes as follows. This should take not more than an hour or two once the party receives the completed candidates' forms. So in substance, what the Commission is telling the court and telling our client is, well, it shouldn't have taken you more than an hour to upload your candidate lists. My client had started more than 2 hours with the process of uploading the candidate lists. And obviously I don't want to steal an advantage, but obviously when the Commission talks about it being 1 or 2 hours, it can only be on the assumption that the portal is functioning and operative and fit for purpose, because otherwise it wouldn't make sense. So my client should only have needed 1 or 2 hours to do what it intended to do, but it was unable to do. And the only objective fact, and I'll deal with that shortly within the context of the disputes of fact and Justice Zondo's questions about the portal, is that the only reason why it couldn't do that is because of the malfunctioning of the portal. Now that deals with that quote of the answering affidavit at page 142, paragraph 43.2, that it should take no more than an hour or two once the party has received the completed candidates' forms to upload. And our case is about the submission of the candidate list. That relates to the merit. As to the relief, which this court is obviously at large with respect to grant whatever relief they want. It has a very broad discretion. It's the type, I think, that would fall into that third category in the JCI decision. And that is at page 164, paragraph 115, where the following is stated. Now, a lot of ink with respect is spent in the answering affidavit dealing with the timetable. But if you look through it and you look at what's really important, you will see the following at 115. There is naturally some leeway built into the timetable. The Commission could probably handle a delay of a day or so to any of these deadlines, but any delay increases the risk. So there is leeway built into the election timetable. There is, I think we used the word, or my client used the word tolerance in the affidavit. There's a tolerance of a day or so. But all my client asks on the Commission's own version is an hour or two to do what it would have been able to do had the system not malfunctioned. If I can deal, I'm just going to quickly change the batting order and deal with what is clearly a concern raised by your Lordship Justice Zondi and your Lordship Justice Songwe about the disputes of fact and that the portal didn't work. Now, we deal with disputes of fact, and we don't for a moment suggest that Plascon-Evans doesn't apply, but Plascon-Evans, with respect, is not inflexible. And we know it's not inflexible because the Supreme Court of Appeal has adopted what was then called what it referred to as a robust approach, and that's in Buffalo Freight. The mere fact that there's a dispute in and of itself does not justify the rejection of the applicant's version. And the Supreme Court of Appeal in Buffalo Freight adopted previous dicta of His Lordship Justice Eloff in the Truth Verification Services matter. So you need to consider Plascon Evans within the following context with respect. My client is compelled to bring a review application. It isn't armed with a choice. It cannot bring an action, so to speak. It also has to, given the very nature of this court and its functioning, it also has to act urgently. So the mere fact that a dispute of fact is raised must be considered within that context in the particular circumstances. Now, let's look at whether there is a genuine dispute of fact that is raised. And I want to deal first with the dispute of facts within two particular contexts, or two particular classes, because the one indelibly impacts upon the other. The one is whether the one is what happened leading up to the 8th, and that which is common cause. I'm not going to put anything to this court that isn't common cause in that regard. And then the second consideration will deal with the dispute about whether the portal malfunctioned. Now, we deal extensively in our heads of argument with the common cause facts in this matter, and we do that at page 18 from paragraph 44 onwards. Now, the following is not in dispute, and I would, if my learned friends contest it, then I would invite them at the same time to tell us where what I'm about to put to you is issuably placed in dispute. And when I say issuably placed in dispute, disputed by something stronger and more substantive than a bald denial. Then that is at paragraph 45.1. And if I know I said I wouldn't read the heads to you, but if we can go through, because it provides a context for the two important, or the questions that both your lordships have put to me. So at 45.1, my client to use the online portal for purposes of submitting its lists was at least strongly advised by the Commission or believed to be compulsory that you had to use the online portal. And that deals, your lordship, with the question you put to Mr. Hopkins earlier, Justice Shongwe, about the manual compliance. And this is not contested at all. And this importantly at 45.2 is the first time that the IC uses its online portal. So this is not a system that has been basically set out onto the field, has been pushed around, has been subject to the abuse, and I use the word abuse maybe somewhat loosely, abuse within the context of an 8 March 2024 deadline, where everybody is online and everybody is attempting to access the portal and download on the portal. And then on the 24th of February, my client sought to access it, only got access on the 21st of February, but that's really of historical and anecdotal importance because the focus is the 8th, and that my client had put together those resources I referred to earlier, the 20 people, the team of 4, the fact that they started in the morning and worked till 12 o'clock at night, the fact that they went to the Sandton Hotel or the Sandton Convention Center, and the internet was stable, and that they used new computers. Then the fact that now there seemed to be some uncertainty as to how the deposits are paid. If I can tell your lordships, the only documentary guide, so to speak, or manual as to how the elections would be pursued within the context of the portal is a 22-page presentation document. That's the only written document we've got. And that document, importantly, does not deal with how you pay deposits, when you pay the deposits. And secondly, and I'll deal with it shortly, it does not deal with what is referred to as bulk uploading. Albeit we submit that the case that sought to be made by the Commission about bulk uploading is nothing more than smoke and mirrors. So we've got a 22-page document. You've got two parties, Mr. Hopkins's client and my client, that say, listen, there was no real education about the system. We didn't really know what we're doing. This is the first time the system is being used. But what we do know is that my client had, by the 8th, completed the payment of the deposit process and the uploading of the candidate lists, and that Now I'm at page 21, 45.8. It was impossible with my, and this is the dispute, it's the second part, but I say it provides the context. It was impossible for my client to comply with or meet the 5 o'clock item 9 cutoff because of the malfunctioning of the portal. And that's the second issue. But to answer your lordship, Justice Shongwe's question earlier about what did my client do, on various occasions on 8th March, and because of the technical difficulties experienced while uploading and submitting the candidate list or attempting to effect the deposit payment, because it had to be logged by my client's representatives with the Commission's help desk for assistance. And numerous calls were logged. There were 2 help desk numbers, and 10 calls were logged to those numbers. Then we can go to 45.11. The IEC's, and this cannot be disputed, the IEC's representative standard and often repeated answer to the request for extending the item 9 cutoff was that the election timetable was cast in stone and could not be changed. There's no dispute about that. And the reason why there's no dispute about that, because there's a valiant attempt to now try and explain what was actually intended by that statement. What is also not in dispute is that, as the Commission says, assuming a functioning and adequate IC portal, that it would not take more than an hour or two for my client to have done what it wanted to have done. And that if it took an hour or two, my client would have had sufficient and adequate time to have completed the submission of the candidate list before the 5 o'clock deadline. None of that can be seriously or genuinely in dispute. Now, when we talk about the system malfunctioning, what we've got to do with respect is let's look at objective facts, which cannot with respect be denied by the Commission. The first is that the Commission did receive numerous complaints from numerous parties about the portal hanging. It cannot be disputed that my client logged at least 10 phone calls to the help desk where it complained about the portal hanging, glitching, and freezing. Okay. My client also contends that ID numbers were randomly rejected for no reason. Mr. Hopkins has already dealt with that. But let's look with respect at what the Commission itself has had to say about the complaints. And that you will find at section 26. And I just don't understand, because it's a somewhat Delphic approach. And I make the submission in 2 respects. For the Commission to say, listen, there weren't any complaints. The system functioned perfectly when there were complaints about the system malfunctioning. And secondly, I make the submission within the context in which my learned friends' heads of argument and answering affidavit are structured, particularly the answering affidavit. Their starting point is the system didn't malfunction. They then say, well, if the system did malfunction, it's your fault because you did it too late. Now, we know that that's not a proper ground for the authorities that we've already referred to, but it's a rather contradictory approach. You can't start off by saying the system was perfect, it operated, and then say, but if it didn't operate, because the only persons with respect that can tell you, that should be able to tell you unequivocally whether the system functioned properly would be the Commission. Yet they are unsure because they hedge their bets. And the reason why they hedge their bets is because they have to hedge their bets, because they know the system did not function properly. If you go to paragraph 26, paragraph 49.6 of our heads of argument, now, this is what the Commission has stated under oath. Its answering affidavit in this application at paragraph 49.6.1, the Commission states that some parties also complained about glitches whilst using the platform. And then it's an answering affidavit in Mr. Hopkins's client's matter. It says, the Commission says the following under oath. Some parties did experience difficulties using the online platform. The Commission received some of these complaints from other parties. Well, some of these complaints is that the OCNS, which is, as I understand it, an access of the portal, hanged, and that their users were removed from the system and had to log in again. The Commission states that some parties complained about lagging, hanging, and having to log in again. And that's exactly what my client complains about. And the Commission accepts that because it states under, so it says other parties complained about it. Yet they say to you, with respect, somewhat bizarrely, the system never malfunctioned. So are all of these complaints that they refer to having received complaints of an identical nature of those made by my client, or those complaints where they're all made up? But what they don't tell your lordships with respect, and to take Mr. Hopkins's point, what they should have told you to have raised a genuine dispute is to say, listen, these complaints lacked merit because they were made by the following person, they pertained particularly to the following aspect, and the complaints were remedied, or the complaints were non-existent. Their complaints were investigated and found to be non-existent. But your lordships and professors are told none of that whatsoever. So there's a complete lack of candor on the part of the Commission when it comes to the most fundamental aspect of this case, and that is whether or not the platform malfunctioned. And they had it within their means to have put all this evidence before you. But what evidence they do put before you with respect is evidence that is inadmissible and irrelevant. And the reason why I'll say it's inadmissible is because there are no confirmatory affidavits. And the reason why it is irrelevant is because the people who they rely on to provide this evidence answer the wrong question. The evidence that the best the Commission puts up is evidence that the system was live. That's not our client's complaint. Our clients don't complain that the system was down, or the system was not live, or off. This case is not about whether not about a question of whether the system was live. It's about whether it functioned properly and whether it was fit for purpose. So they could have put up as many reports as they wanted, even by people who don't oppose to confirmatory affidavits, confirming that the system was up. But that's not the complaint. The complaint is quite squarely, and it's not a complaint that was aired by my client. It was in the complaints that numerous complaints were received by the Commission, that the portal frequently hung, glitched, froze, which required the user to regularly log on and log off. And as Mr. Hopkins says, when you log on and log off, you don't know what's been saved and you effectively have to start again. Now, and it refreshed to the home page. So it's got nothing to do with respect. The portal and the complaints about the portal is whether it was up 100% of the time. It may have been up 100% of the time. It just wasn't working properly or optimally. And that's where the complaint lies. So we submit within the context of the dispute of fact about whether or not the portal works. Not only must your lordships and the professors look at the dispute within the context of adopting a robust approach, particularly within the context of my client being obliged to come to court by way of motion, but within the context of what is said and not said. And what is clearly said is that complaints were received about the system. You are not told by the Commission as to what the nature of the specific nature of the complaints were, or the merits, or the duration, or who made the complaints, which with respect shows a lack of candor on their part, when they are the only people that could have done it. You have the objective fact that my client made 10 phone calls. You have the uncontested evidence that my client's representatives were told to log on and log off, which is the very evil that resulted in not knowing where you were and information being lost and having to start again. Justice Zondi, I think you want to ask something?
Yes. Now, on the 8th of March, what time did your client start uploading the candidate list into the system?
I stand corrected, but it was at 14:57.
14:57.
Yes, and we are told.
And the deadline was
5 o'clock.
5 o'clock.
5 o'clock.
Now, there were these problems which were client experience during the process. Now, towards 5 o'clock, surely your client should have realized that I need to come up with plan B, an alternative. Now, there is an allegation in your founding affidavit that you try to, is it in the reply affidavit that your client tried to take the material to be uploaded physically to the offices of, local offices of the Commission. What time did you leave Sandton and what time did you arrive Is it in Randburg or that's what you said?
Was in Sandton. I think the Commission's offices are in Centurion. The Commission says it would have taken half an hour to get there. My client in the half an hour to have travelled from Sandton to Centurion. My client in the affidavit, replying affidavit, states it left at 4:20, but still never got there in time. But Your Lordship, if I can just, with respect, contextualise Your Lordship's question to me. My client sits on the horns of a dilemma. It is uploading. Sometimes it succeeds, sometimes it doesn't succeed. When the system works, it works. And the frustration in all of this is that it was random and ad hoc as to when the system worked and didn't work. So the system at any moment could suddenly have worked. And Your Lordship is told, Your Lordship and professors are told in the founding affidavit that effectively it got to a stage where half of the team was trying to contact the help desk and being told by the help desk to log on and log off, and the other half was trying to facilitate the uploading. So there is this horns of a dilemma. Ultimately, a decision was taken to manually deliver, but there was just not enough time within the available time to do it. But again, we are told under oath that had the system operated efficiently, and we proceed on the assumption for this argument only, had the system or platform operated efficiently, my client only needed an hour or two to do. And it had more than 2 hours to do what it wanted to do.
I see now, Mr. M, it's almost 1 o'clock. Do you still have a lot of submissions to make? Because we have taken...
If I could just, the topics I still want to deal with is section 22.
Yes.
I don't intend being very long. And then just with the relief and cost, I don't intend being long. But if it's appropriate, and I'm obviously subject to Your Lordship's directions, to take a short break, and I can just confer with my junior and take instructions and make sure that I've dealt with everything that I need to deal with. And then I will just deal with section 20 and the relief after lunch.
Do you want to take a break now, or do you want to go to another subject now?
No, I mean,
because it's about 5 to 1 now.
Well, let me be quick. I think I can finish section 20 in 5 minutes.
Okay.
If I can just maybe have an opportunity after lunch to potentially clean up. Okay. Now, we know that in the IFP case, which is referred to in my learned friends' heads of argument at page 14, paragraph 51, that the Constitutional Court emphasizes that there must be a rigorous adherence with the provisions of the rule. We agree with that. We don't dispute that. But that doesn't mean that just because there must be rigorous adherence with the rules, that the rules are carved in stone. And I know it sounds like I'm arguing something that I've argued before, but I'm setting the platform to argue what statutory powers were vested with the Commission in terms of section 22. And it's the failure of the Commission to even consider those powers, because there's no word in the affidavit that they considered the powers, that they evaluated their powers within the context of the complaints, and they decided, listen, well, those powers will have no bearing on whether the elections are free. And not a word is said. Now, the only inference to draw then is that section 22A did not feature at all in the Commission's decision-making process. And when considering not only the complaints of my client, but the complaints of various other unidentified parties. Now, I assume that, and I'm preempting my learned friend's argument, he will say, but we didn't need to consider section 20 because the portal did not malfunction. But that, with respect, argument falls for 2 reasons, or answer fails for 2 reasons. One is we know as an objective fact that there were frustrations experienced with the portal, and secondly, such an answer would be consistent with what they tell my client the position to be on the 12th and 14th of March. If I can just ask Your Lordship and professors to quickly go to Annexure FA7 and FA9 at page 122 and 128 of the founding affidavit, because with respect, there's a falsity in the position adopted by the Commission. In light of what I've already just submitted were existing complaints. Now, at page 112, the Commission says at paragraph 4, this is in response to a complaint by my client, The Commission is unaware of any technical glitches with the IEC systems, which prejudiced any political parties or independent candidates throughout the process, and that is dated the 12th of March 2024. Now, that letter is factually unsustainable because we know that at that stage, Mr. Hopkins' client had already gone to court on the 6th or the 8th of March to deal with this particular issue and to deal with whether a decision has been made or not. So for the Commission to say unblushingly that they're not aware of the technical difficulties with respect to something that needs to be very, very closely looked at. And then on the 14th of March, the Commission says, it suffices to state that the Commission is not aware of any technical issues with the item that would have had content for. We know that because there's already been a court which was argued or argued before His Lordship Justice. So there's a falsity. But with respect adopted by the Commission is inconsistent with the objective. And in any ask you to turn to page 5 of our document. Paragraph 49 onwards. What you find there is what I've been through earlier about the objective facts about which the Commission has already gone under oath and said they knew there were these glitches. So that answer, that listen, we didn't need to consider Section 20. I anticipate the answer by my learned friend within the context of these complaints is because the system didn't malfunction, but they don't tell your lordships and professors when they investigated the system at the time that they understood what the merits of the complaints were and whether or not that had any impact on a decision that they needed to take under Section 20. Now, the last point I want to make, it deals with the Commission's reliance on the word may, and insofar as it affords a discretion in Section 22A. The fact that the Commission says, well, I may do it, I'm not obliged to do it. But with respect, that is a blinkered approach which is inconsistent with what the Constitutional Court says should be a proper interpretation to the Act and the timetable. So insofar as they have a discretion, it can at best be an incredibly narrow discretion. And the reason why I say it's a narrow discretion, because in the decision of Media Workers Association of South Africa, 1992-4, SA 791, it's appellate division decision at 800 DE, Crosscorp JA explained that a truly discretionary power is characterized by the fact that a number of courses are available to the repository power. Thus, where the discretion contemplates that the court may choose from a range of options, it is a discretion in the stricter sense. But here we know that all the Commission could do was amend the timetable. That's the only power they had. So it's a very narrow discretion. But that discretion must also be interpreted with the fundamental objective of the Commission was to give expression and content to the political rights in Section 19 and to ensure a free and fair election. The Commission could not turn a blind eye because it has at large and has whatever discretion it does to an injustice. And with respect, this is an injustice here. It's an injustice because through no fault of my client and on the Commission's own version, it should and was able and in a position to comply. Mr. Hopkins has already referred to the reliance of the Commission on the Offered Enterprise decision, a decision of His Lordship Justice Wallace, where His Lordship says, well, you know, you can't impose a duty on an administrator to make a decision where there is no duty to make a decision. But with respect, there is a duty on the Commission to make a decision. And it's a decision whether or not it's going to invoke Section 22A. So the fact that it has a discretion to invoke it is something different to the decision it makes about whether or not it should exercise that discretion. And we know it never even considered Section 20 and the rights afforded to it. So at the very, very lowest point, there is a duty on the Commission to investigate a complaint, to establish the merit in the complaint, and then to assess whether that complaint in any way infringes upon the freeness and fairness of the election. And if it does, then it must make or not make a decision in terms of Section 22A. But we know that they never even got that got that far. And again, I refer to the interpretations that must be afforded to the Act and the regulations and the timetable. I refer to what His Lordship Justice Sachs says in the August matter at page 9, paragraph 21 of our heads, and what His Lordship Justice Pillay says in the National People's Party matter. And then just finally, I'll deal with the relief just after lunch. But this is a biotype matter. So we align ourselves with the submissions of the African Alliance of Social Democrats that BioWatch applies. If my client is to succeed in the matter, it obviously must have a costs order in its favor. But it's certainly my client, and it's not suggested otherwise, that my client is acting maliciously and not intending to pursue the protection of its constitutional rights. If I can just very briefly after lunch then just deal with the relief, if that's all right.
Thank you. I see it. Yes, Mr. Bishop.
Sorry, Judge Zondi. I just wanted to quickly raise an issue of housekeeping. We're at 1 o'clock and we've dealt with almost 2 of the 5 applicants. As I mentioned earlier, Judge Zondi, I have a difficulty. I have a flight to catch. It's the last flight I can get out of Cape Town today. I was originally supposed to be leaving this morning, and I changed the flight to the last possible flight. I'm concerned that I'm not going to have sufficient time to finish my argument today if we proceed at the current rate. My suggestion was that after Mr. Ammers finished, that the AASD argues, and then that I be permitted to argue, and then the 2 self-represented accused, Mr. Malapane and Mr. Chavalala, they will argue, and Mr. De Beer and Mr. Tsela are dealing with those cases, and they will then respond to those 2 cases. Otherwise, I'm very concerned that I'm not going to be able to meet all my commitments.
Okay, so after Mr. M, then we'll hear African Alliance.
Yes, and then I would respond to all of those. You would then hear the applicants for the other 2 cases, and then the commission's
in-person applicants.
Yes, who are not me. I'm not arguing the specifics of those cases.
Okay.
Yes.
All right. So
if the court would accommodate me, I'd be very grateful.
Yes. No. That's fine. That's fair enough. So after lunch, we will allow Mr. M to finalize his submissions, and then start with African Alliance.
Yes.
And then after African Alliance, then you.
Yes. Yes, and I will deal with those 3 applicants.
Because, well, okay.
And
that's fine.
Some of what I say will be relevant to the other 2 cases, but the specifics of those 2 cases would then be dealt with afterwards.
Yeah, let's try now to summarize, because you know exactly where we are now. So I think that let's try to sort of focus on the point that is relevant to or peculiar to a particular applicant.
Yes.
That might sort of help us, because I mean it's we've got about 5 applicants here.
Yes.
So yeah, it's about 6 minutes past 1. Can we come back, say half past 1? Or maybe half past 1 will be okay.
Yes, Judge. Thank you very much.
Yeah, let's come back at half past 1.
Okay, Judge.
Okay, the court adjourns until half past 1. You may leave the platform. Yeah, let's leave the let's leave the platform. Then after lunch, we'll reconnect. Thank you. The court adjourns until half past 1.
Thank you.
We invite, what's the name, the council? To take an instruction and tell us. Pleading evidence from the bar.
Gregory, your mic is on, so we can hear you.
Mike, I can raise it. Can I raise it something with you now, quick, if that's all right?
Depends what it is.
There's a post that says the Electoral Court's going to delay the submission of lists pending this litigation. I don't know if you know about that.
I don't.
It's a tweet or something like that. That's literally was given to me now.
By
It says
whom?
party lists to be finalised after Electoral Court concludes matters. It's an SABC thing.
No, that's a different process. That's
Is it?
they all the appeals on the Section 30 objections have to be decided by the 9th of April.
So that's a different one, hey?
It's a different one. It's got nothing to do with it. That's automatically appeals go up to the Electoral Court.
Okay. So I'm making a meal out of nothing then, hey?
Yeah.
Thank you. May I dare ask where you're heading off to?
Port
Where are you
Elizabeth
heading off to?
to Rebecca.
So I'm going to be 2 minutes in reply.
Great, thanks.
Hello, guys. Oh, sorry, I think other people are on. Beg your pardon.
Justice Zondi, I think your mic is muted.
Oh, thank you. Mr. Klapo? Mr. Klapo?
Please.
Hi, Mr. Klapo.
Oh, Judge, I'm here.
Yes, is everybody back now? So we can proceed.
Yes, it looks like people are
Okay.
joining back in.
Yes, Mr. M, you may proceed.
Yes, my lord, I intend to be very brief. I've got 3 submissions relating to the relief. The first is that which arises within the context of the CAM decision. This court is really at large to substitute the decision or non-decision of the commission with what it believes is appropriate, and we would ask the court to do that. Within the context of my client, the second submission, within the context of my client specifically, I've already referred the court to the commission's position that it will only take an hour or 2 for my client to complete what it needs to do, and that they do have a day or 2 leeway, that tolerance. So there shouldn't be any unnecessarily burdening of the timetable and the election process. There's something I raised the third point is there's something I raised very briefly with my learned friend for the commission, and that is that there's a post on the SABC at the moment. He says it doesn't apply, but if I can just read it to you, and I hate to give evidence from the bar, but the SABC News reported today that the Independent Commission says that the list of political parties that will contest next month's national elections will be finalised once all matters being heard in the Electoral Court are concluded. At least 6 applications that are before the court will be heard tomorrow. So I assume this was written yesterday. And then it goes on to state that. So there seems to be some decision taken in principle for the Electoral Court to at least slow down the election process, but it's obviously something that my learned friend can address you on.
Yeah, I'm not sure if it's a official statement of the commission or.
With respect, I'll tell you who made the statement. I never. The commission, the electoral body's commissioner, Dr. Nomsa Masaku, says they don't expect the number to exceed 50.
Okay. All right. Okay. We'll hear Mr. Bishop will address us on this point. And then now, as far as the relief is concerned, assuming that we're with you on granting you a further opportunity to upload the remaining candidate list.
Yes.
I see now today we had about 5 applicants who all alleged that they were kicked out by the system. And as of yesterday, we received further, like how many new application, 1, 2, 3, about 3 further applications relating to the same problem. But now, if I'm just trying to think now of the remedy, because if we open up the window, it means that everyone must be given the same opportunity, and I'm not sure what that it will do to the whole electoral process and preparation for the election. And
respect, my lord, if I can just interrupt you, we don't, and I say that with tremendous respect.
Sorry, who is somebody is on? Just switch off your mic, please. Switch off your mic, please. Can you switch off your mic, please, if you're not on the platform? Yes, proceed, Mr. M.
And I say this with great respect and reverence, my lord. We disagree with you. It's not or with the proposition. Let me put it that way, that it has to be opened up for everybody.
Okay.
It simply cannot be. It's only those parties that have legitimate complaints, have acted timeously, and that the failure is attributable to the platform. Just because a party says so doesn't mean it is as a fact, and certain parties have not pursued their rights. And I can suggest that even a relief that is tailored to the particular circumstances of each party would be appropriate. If my client only requires an hour or 2, that's something different to what Mr. Hopkins's client requires. Then the commission can allow my client an hour or 2 and his client a day. So it's always fact dependent with respect, and that's the only basis upon which fairness can prevail with respect.
All right.
Mr. M has made an emphasis that their case is not on the timetable, but on the functionality of the portal, which my interpretation views it through the lens of an indirect challenge on the timetable itself. Thank you.
If I can just respond to your ladyship's comment or concern, your ladyship's correct, but the challenge to the timetable is a challenge which pertains only to item 9 and only arises within the context of the functionality. Nothing more, nothing less.
Okay.
Okay, thanks. I'm fine, Judge. Thank you very much.
Thank you. All right. These are submissions, Mr. Ed.
Thank you. Those are the submissions. Thank you for the hearing,
Okay, thank you.
justices and professors.
Sure. The next applicant, it's who appears on behalf of Mr. African Alliance of Social Democrats.
Sorry, my lord, I was just having a problem with connection.
Okay.
It's Ramaidi.
Okay, Mr. Ramaidi.
It's R-A-M-A-I-L-I, my
I've
lord.
got it.
It's also to, that type of issue of the D and L.
Yes, now I've got it.
Together with Tro and Mobo, we confirm appearance on behalf of AASD.
Mm. Mr. Ramaidi, you also have, well, now I don't think that it's necessary to give you the 15 minutes, unless if you want.
Yeah.
But because, I mean, we've had a debate between the members of this court and Mr. Hopkins and Mr. M. So the issues are simple, narrow at this stage. But I'll give you, do you still need 15 minutes of immunity or minutes?
It will suffice.
Okay.
Yes.
That's good. Okay. Proceed, Mr. So we've got 10 minutes of uninterrupted presentation.
Yes.
Your time starts now.
Yes. So, my lord, on our side, we propose to deal with 3 most important topics.
Mm-hmm.
One is a question of law. It will then appear in page 4, paragraph 12 of IEC's answering affidavit. It's a question of law. I'll argue that point. And the second point, which is most important one, it's compliance, the purported non-compliance by the IEC that they alleges. And the third one, it's merits. So the 3 more important, those are 3 topics that we'll be addressing with that. But the last 2 topics, my learned junior, Mr. Villagas, will deal with those points. Now,
sorry, Mr. Villagas is going to deal with which point? With
non-compliance and the merits of our application.
Oh, okay.
Yes.
The 2 and 3 points.
2 and 3 points.
To be dealt with by Mr. Villagas. Yes, proceed.
Yes. The starting point by way of introduction, my lord, may I humbly refer you to page 4 of the answering affidavit of the IEC.
Yes.
Yes. You'd note that the heading there, it's misdirected. The purpose of that topic, it's written misdirected. But in substance, we would argue a different proposition that in substance, actually, it was dealing with the issue of jurisdiction, not necessarily the topic that it's misdirected. If your lordship would then have an opportunity to look at paragraph 12 of the answering affidavit, it reads as follows. This court has jurisdiction to hear while they talk about appeals in terms of Electoral Commission. They deal about section 20, and then it says an review in terms of 20 subsection 1 against the decisions of the commission. So So ordinary grammatical meaning of that paragraph alone, it's clear in substance that the applicants, the respondents, actually the intendant on raising a point in law, point in limina, objections for this court has got competency to adjudicate this application. Lordship, there's a...
Sorry, I'm sorry to interrupt my learned friend, but I just want to make it clear that the Commission accepts that this court has jurisdiction. We also made that clear in the heads of argument. We take no issue with this court's jurisdiction.
So in light of that, then it rests our case. Then my learned colleague, Mr. Villegas, then will take over, because that's a point that I'm actually going to stay at length. In principle, that we have covered before the court. Then I'll leave it to my learned junior actually to address on that issue as a court pleases.
But in any event, Mr. Ramail, in the last sentence in paragraph 12, the sentence that we have directed this court attention to, it says the court has jurisdiction to hear this application. They concede that. So
well.
The last sentence there.
Well, there are two issues in their heads. I mean, they devote much of the thing because it's a matter of interpretation, my lord. But however, concession, it's okay. I don't have to argue about it. Then, like, let me leave it. Okay.
All right. Let's hear then, Mr. Vilakazi, to deal with the compliance or non-compliance and the merits of the application.
As the court pleases, my lord. Vilakazi, how are you?
Right, how are you, Mr.
Thank you, my lord. Thank you, my lord. My lord, I'm simply going to be brief because I understand that the court is pressed for time at this stage.
No. We can sit until 12 o'clock midnight. Don't worry. Right, then. We've got all the time. Okay.
Right, thank you, my lord. My lord, ultimately, this matter, insofar as our case hinges on strict compliance. Now, my lord, if we ask ourselves the question, which way should this court go, then I think African Christian Democratic Party versus the Electoral Commission and others, a 2006 decision, February, is that the court there had to deal with the failure by ACDP to pay the monies required to contest an election in the Western Cape. They were correctly excluded, it is our view, and they launched an urgent proceedings. So it essentially came down then to the question between substantial compliance versus non-compliance. Now, paragraph 25 of that judgment is quite key, my lord, because the court says the question thus formulated is whether what the applicant did constituted compliance with the statutory provisions viewed in the light of their purpose. It also goes on to say, quoting Vienna Transitional Local Council versus Van Dijk, that the correct approach is to follow a common sense approach and that legalistic debates should be put to the side in this regard, my lord. Now, my lord, if we look at page 10 of our notice of motion, in particular from paragraph 15 in that regard, my lord will see, and the court will see, that we were in the process of uploading these names and lists which were required. In fact, we had begun as early as Monday, the 4th of March, and I remind the Honorable Court that the closing date was then the 8th of March. But we had begun as far back as then uploading bulk Excel spreadsheets and punching in individual ID numbers at least up until 16:05 on Thursday, the 7th of March. And through that act alone, we reached the required numbers to contest the Free State, provincial legislature, all the regions, and the national compensatory ballots. On Friday then, which is the crux of the matter, we were in the process of capturing and uploading the list of candidates, but we encountered, or at least my clients encountered, a very slow system. And I think the court ought to take at least note of that, because if all the parties were on the system, then it's only correct that the system would slow down. In any event, at 1700, we had only uploaded one candidate capture template successfully. So, my lord, then the court ought to ask itself, well, was there compliance or was there no compliance? We submit that that was substantial compliance, my lord. In fact, to borrow the analogy of my learned senior who presented for the Labour Party, we were in the chute on our way to the actual aircraft when the aircraft door was closed. My lord, in the heads of the commission, one will see that they devote time to this aspect, but to be fair, it's not essential. And that is at paragraph 13 on page 8 to paragraph 32 on page 13 of the commission's heads.
Okay, sorry, it's just for, I'm not putting question to you, but it's for the sake of clarity, because I don't want to forget this question.
Yes, my lord.
Now, your case, is it about uploading the candidate list or the support signatures?
We had uploaded the support signatures. In fact, my
signatures.
lord,
okay.
if I can just, if I can assist, my lord, we had actually uploaded the signatures.
Yes.
Yes,
so,
my lord.
The stage at which you were now, when you were kicked out, is when you were busy with uploading the candidate list.
Indeed so, my lord.
Now,
so,
your client was competing for national.
Indeed.
Regional.
Yes.
And how many regions?
I think it was about 6 or 7. May I just get to that response, please? Pardon me, my lord, for turning my back to the court.
That's fine.
Thank you, my lord. I'm just getting that so I can confirm it, my lord. The regions: KZN, Gauteng, Free State, Northwest, and Northern Cape.
That would be 5.
5, my lord. And as I said, the Free State list was already complete at that time, my lord.
Okay, so out of 5, did you do national?
Yes, national is the other one that we were going to do. If I can just confirm to the court, on page 6 of our founding affidavit, you will see that we had reached, and this is paragraph 14, it says on Monday, 4th March 2024, we had begun uploading bulk Excel bundles and punching individual ID numbers of at least up until 1605. When it reached the required numbers to contest the Free State Provincial Legislature, all regions, and the national compensatory ballots.
But well, you started with the candidate signatures on the 4th of March.
Indeed so.
That's what you say. And yes, then you started the process of uploading the candidate list now on the 8th of March.
Yes.
All right. How many candidates did you want to fill? Did the applicant want to field for national?
My lord, I don't have that specific information.
And for regions?
For the regions, we know that it was KZN in provincial names. KZN.
Yes, the number of candidates.
My lord, I'm just going to take instruction on that and revert to my lord a bit later on that, my lord. But my lord, so the point that we are making, sorry, my lord.
Switch off your mic, please, when you're not on the platform. Okay, proceed, Mr. Bilawas.
Thank you, my lord. My lord, our submission is that there was substantial compliance with the rules insofar as uploading of these candidates was concerned.
You have muted yourself, Mr. Bilawazi. unmute yourself. Mr. Vilakazi, unmute yourself.
I do apologize, my lord.
Yeah.
I don't know what happened to that. My lord, our submission is very simple. We have complied substantially, though not to the fullest, we agree, when this issue came about. And on those grounds, my lord, the relief that we seek is simply an opening for us, in particular, in order for the party to be able then to fully upload the rest of the list, my lord.
Well, that's why I asked you earlier on, how many candidates did you want to field nationally? How many candidates did you want to field provincially?
Yes,
and when you were kicked out, at what stage of the process you were? How many of those candidates had you uploaded?
All right.
Because now you said there was substantial compliance. Substantial compliance will mean you had done more than 50% or 70% of the uploading. But
I suppose,
it's
my
about
lord,
figures here.
I suppose, my lord, the response to that is that the courts have never given a specific figure in terms of what substantial is, but we sort of understand what strict compliance is. It's either it's one or the other. So you've either done it or you've not done it. But substantial means in this regard to have started something and then have been kicked out, which is where we found ourselves. My lord, just then to move on then to the next point. In respect of urgency, my lord, there's only one issue that we wanted to put forth to this case, to the court. We confirm, my lord, that there is no substantial redress because this was an issue which was raised by the commission. There is no substantial redress for us in the future. And on those grounds alone, my lord, which is the most important ground of urgency, the court ought to entertain our application. Insofar as the case of the commission is concerned, my lord, one of the issues in terms of the points in limine was that we had come to this court without requesting condemnation. Well, a few facts come in there, my lord. It's not through lack of trying on behalf of my clients. In fact, we do address an issue of condemnation both in our founding affidavit as well as in our replying affidavit, my lord. My lord, you will see that at paragraphs 30 to 32 on page 13, we address that issue. And at paragraphs, pardon me, my lord, I'm just trying to find where I am. And the commission, my lord, is quite aware that we had spoken to them, despite them denying this matter in their answering papers. We do have a call log that's there, and we had spoken to them about it. They also raised other issues, my lord, to say that when they look at this matter in respect of us not applying for condonation and us lacking the merits, is the fact that we failed in the nomination process. Well, that's not true, because my lordship has regard to the fact that we were in the nomination process at that time. Furthermore, much was made about payment of deposits and how the system works. Bottom line is we paid the deposit to show our intention to partake in these upcoming elections. My lord, there's just one other issue because I don't want to take up the court's time. My lord, the answering affidavit of the commission clearly states that
sorry, Mr. Vilakazi.
Yes,
I'm sorry to do that to you. I just want to clear my mind before I proceed any further this month. Now, the decision that you are challenging, it's not clear to me because declaring the respondent's decision to deny the applicants to its system is unlawful.
That's the crux of it.
What decision are you challenging here?
It's a declaratory order, my lord.
Yes, yeah, but yeah, what?
It's the mere fact that they didn't take the decision. My lord, if I can just refer you to the letter that they wrote to us. It's found in our founding papers. It's EC3. Now, my lord, it has been alluded to earlier on lack of taking of a decision is a decision itself. And at EC3 is the letter from the commission. And point number 3 is where the commission performs a Pontius Pilato act and washes its hands, because it says the commission has no discretion to condone non-compliance with the election timetable. And meanwhile, my lord, we know that they do have that discretion. It's just that a discretion that they wish not to exercise. Had they exercised it, we would not be before this court.
Proceed. Proceed, Mr. Villagas.
Yes, thank you, my lord. My lord, another issue that I just want to quickly raise is the answering affidavit of the commission, in that at pages 14, paragraph 51, I believe, they indicated that one could submit their list at any of their offices. And later on, my lord, in their very own heads of arguments, they then abandon that principle. Now, that concession, oddly enough, is made in the heads of arguments, and there is no further affidavit in order to clear up that issue with an affidavit that clears it up, because you can't just simply come to a heads of arguments and abandon an issue that you raised as being one of the avenues that was available to the applicant to take. The bottom line is we were in the Free State. There was only one office that was open for us to be able to submit these lists, and that office was in Centurion. So that issue we wish the court to take note of, because we are finding that it's by ambush, my lord, more than anything. My lord, you
sorry, in Free State there is no IEC office
captured when the cutoff time arrived.
So you didn't do the national list?
We couldn't, yes, my lord.
And the Gauteng
regional, we stood at Gauteng regional, we stood at 3. Any other Gauteng we couldn't do, my lord.
Okay. When did you start on the 8th of March?
Well, we had started as early in the morning, but as my lord would see on paragraph 15, one of our gripes, my lord, is the fact that the system, having so many people working on it, was slow, and we could only upload in 5 megabyte bundles as required by the system. So we had started very early on Friday. Yes, we did suffer from issues such as load shedding, but that for us is not the crux, although it is something that the court ought to look into. But we had started early on the Friday, my lord. And then we were faced with the load shedding, as my lord would see in paragraph 16 of our founding affidavit.
Yes, proceed.
Thank you, my lord. My lord, I suppose for me that is the last issue that we had, my lord, the issue of condonation. I would just like to refer this court to what Grootboom versus National Prosecuting Authority said. It said, of great importance, the explanation must be reasonable enough to excuse the default. My lord, the applicant approached the IEC. The IEC then washed its hands of this issue. The applicant then took steps to come to this court. It was not through lack of trying or any wasting of time. We'll see the lengths to which the applicant went. If there are no further issues, my lord, I would like to just call back my senior counsel onto the chair, my lord. Mr. Ramayidi.
Okay.
I'm indebted, my lord.
No, before you leave.
Before you leave, sorry, Mr. Villagas.
Pardon me, my lord. Pardon to the court.
Don't run away.
Yes, Justice Shong has a question for you, Mr.
Yeah, Mr. Villagas. You said you started uploading on Friday, the 8th.
Yes, according to our founding affidavit, we would have indicated like that. We were in the process.
Yes, but why starting on Friday? Why not on Wednesday?
But my lord, thank you for that question. My lord, you will see that we had actually been uploading the bulk Excel bundles and punching individual ID numbers at least until 16:05 on Thursday.
On Thursday?
16:05, yes, which would have been in the afternoon.
Why didn't you start before Thursday, on Wednesday?
But that's because the steps follow a process.
Oh,
you can't start the last step without having gone through giving the system enough information for similar to the issue around payment. You can't just choose any step. You've got to follow that process. But if I can just perhaps close that point, whilst we all know what the cutoff time was, the owners of the system didn't tell us when would be the best time to begin either.
Yeah, but you started as soon as possible. When you have all the information before you start.
Well,
you don't have to wait. You don't have to wait.
And that's what we did, my lord. We submit that's what we did, and we ran out of that time and the system closed.
Okay, thank you.
That's it, my lord.
There's a hand that is up. Is it Professor Poku? Yes.
Yes. Thank you, Judge Zondi. Counsel, just as a follow-up from Judge Shongwe, we now know that at least 89 political parties were able to register and 29 independent candidates. What's your take on that?
Thank you, my lord. My lord, I'm not sure whether successful parties, but by mere fact that we are all now in this court, virtually claiming the identical issue, it means that some people were left off that bandwagon. And it's premised on a few issues when it comes that IT systems are notoriously unreliable when there is a massive amount of data going through them. So kudos to the 89. But earlier on this year, I was involved in a matter that involved 204 political parties versus the IEC. And so the question is, if we minus 200 minus 89, we are now left with 111 minimum parties that may not have been able to register.
So sorry if my question wasn't clear. We are talking here about a system that presented significant challenges. But out of these challenges, the majority of the users aren't affected, but only a handful. Can we really say, is it a matter of a system? That's where I'm getting into. Thank you.
Thank you, my lord, for the question. Yes, my lord, we can say it's the system, because the IEC itself has got indications of when people would have logged on. So it's not to say that we didn't log on within the required time and start the process. It's that we had these issues with the system, and so do most of the parties before you, and the additional challenges that the court has now received. So the mere fact that the majority managed to pass does not necessarily exonerate the system.
Hang on, Mr. Villalaz. You see, the IEC is saying, well, I captured its first candidate at 16:59 on the 8th of March, and its last candidate at 5 o'clock.
Yes, my lord.
Yes.
My lord, I think in our replying papers, we've actually laid out how we went about capturing. But
are you denying it or?
Yes, my lord, we are denying.
The IEC says you.
My lord, the point I would like to drive to, my lord,
yes,
is the mere fact. The question this court should ask itself in considering this matter: was the applicant in the system or were they out of the system? Because then that's where we at that stage. And I submit.
Okay, but now, I mean, the point that I'm making is that you were late. You waited until late to start uploading.
No, my lord, we did not wait until we were late. In our founding affidavit, we've laid down the steps that we did For instance, if you take it from paragraph 13 in terms of online submissions, we executed a test on the 2nd of March, 2024. On the 4th of March, we began uploading, and this is a manual process, uploading the bulk Excel bundles and punching in individual ID numbers, at least up until 16:05 on Thursday, when we reached that limit. And then furthermore, then we were in the process to capture the list of candidates when then the time ran out. And the payment was done. There were other aspects to this thing. And one couldn't upload without having done the required payments, my lord.
Okay.
Yes, Advocate Vilakazi, I also just wanted to follow up on that because I was going to ask you about that process. I understood you to say, and you just confirmed it again, that you started your uploading on Monday, which would have been Monday, the 4th of March.
Yes.
And you continuously on a daily basis uploaded whatever you needed to upload. And despite all of that continuous effort, you weren't able to complete the whole process. And I understand. So you took the whole week, and it still wasn't enough time for you to upload what you needed to upload. That you basically ran out of runway by Friday afternoon. Is that the case on behalf of the applicant?
That is the case on behalf of the applicant, my lord.
Yes, thank you.
My lord, to the Honorable Court, if the court is so satisfied, may I bring my senior back in then?
Okay, sure.
I'm indebted.
Go ahead. Yeah.
Indebted to the court.
Sorry about this inconvenience, justices. Actually, there are 2 points that I just need to deal with. I think Mr. Villagas actually prompted a lot dealing with it. But it's important, Lordship, that we shouldn't actually, let's deal with this. Mr. Villagas has dealt with it properly. I just want to deal with the issue of substantial and strict compliance within the definition and meaning of the survey. My learned colleague actually dealt with it. So I wouldn't want us to lose sight on what legislation says. Section 27. Dr. Villagas has said it, the payment was done, we uploaded. So we have the issue of the question of law, and then we have the issue of the technical clinch that has to do with IT. So those two things need to be separated. So as a matter of law, within the definition and meaning of 27, we have complied. There's no doubt about it. It's not being debated. So on the issue of the IT, it's the IEC that ought to have made a point about it. So the point that I want to make over and above what my learned colleague said. So on a proper textual, contextual, and purposive interpretation of 27, we have complied with the thing by submission, by payment. That's a point that I also want to make in this aspect. Further, so when we're asking about the issue of the decision, of course, it's the answer to that question. It's a legal answer that I'm going to give it to you. In the Constitutional Court decision, in the Constitutional Court in Batu Starfishing, a case, it's a question of regulations. But what becomes of paramount importance, what will then, the facts are not the same, may not necessarily be binding, but what then becomes a binding jurisprudence insofar as the issue is concerned, what Justice Organ said, as then she was. So it happens at some point in life, whether you're relying in certain provision, whether in the form of a review, anything. But if you're to consider the papers and from the aspect of it, that from looking at the papers, then in substance, then it's a review. So the point that I want to persuade you to is that even though the prayers, the case that we made before the court is a declaratory order, but simply consider, adopt the provisions of that case law to say, regardless of the fact, even if we're not expressing to say that it's either a review or an appeal, but in substance, it's clear it's a decision that ought to be done. There's in administrative law, we need to target accurate decisions that affect us. Of course, there are different types of decisions. So the decisions that they have a direct and external legal effect to us is the decisions, it's electronic decisions of the system for kicking us out of the way. That would have allowed, because the jurisprudence says in administrative law, we have to target, there's a decision that we need to target, and those decisions are the ones that have.
Sorry, Mr. Ramaidi, correctly.
Yes. So
because if I look at the declaratory, the relief that you are seeking in in a notice of motion.
So the prayers like less indicated.
Well, number one, it's a review and setting aside is a decision of the 12th of March. That's a decision that you are seeking to set aside.
That locked us out of the system.
Sorry, maybe I've got, hang on. No, sorry. Number one, sorry. Direct, well, it should read directing the respondent to restore access to his system in order to enable the applicant to submit outstanding candidate list. And then it's not clear to me which decision are you challenging here? If I look at your notice of motion.
Let me clarify in two ways. Hence I'm saying
Yes.
I need to answer in two ways. We brought a declaratory order. There's no doubt about it. But in substance, I'm going to come to the decision. I want to persuade you on that aspect. The first point I'm saying, in line with Batostar fishing, the point that I want to persuade the court is, in substance, it's a review. That's number one.
Well, yeah, it is.
Now we have section 27. Section 27, it says, comply with this definition. Now, unfortunately or regrettably, it's not a manual compliance. It's an electronic compliance. If you are clear about it, I need to separate. So if it becomes a electronic compliance, is on consistent basis from step by step, like my learned colleague has indicated, we complied. Then there's an electronic or technical glitch that kicked that out. So those decisions, even though they're electronic, they're not manual. Even this, I'll prefer, there's a book that I have, it's written by Hoekstra, it's administrative law. There's one, they deal about this electronic, I've got it in my chambers. It deals about these decisions that are taken electronically. I'll just take a break and refer to what you say, that those decisions, also electronic decisions, are administrative in nature because we allow for the fact that, technology is there. So hence our notice of motion is couched in that way to say, you know what, restore us. So those decisions for kicking us out of the way, it constitutes the decisions within the definition and the meaning of a Promotion of Administrative Justice Act. So for the fact that the electronic kicking us out of the system has got a direct and external legal effects, because the right that we are dealing about is section 19. So that electronic or technical, those IT decisions to kick us out of the way, so it has got direct and external legal effects for us to participate in the elections. So it's on that basis that we are saying that those are the decisions that we have, because that technical, it's an IT decision. There's nothing, it's not a manual decision. So I don't know if Lordship was able to answer it properly. So I'm saying, so in line with the notice of motion, we refer to that, we say that we're kicked out, restore us in order for us to proceed with uploading, so that we're able to comply, strict compliance in terms of section 27 as the thing dictates. I'll just have to look at, yes, I'll refer to that, the book, it's called Administrative Law in South Africa. It's written by Cora Hoekstra and Glenn Penford. It's a 3rd edition. I'll just have to look at that specific page and I'll refer to it before we close. It clearly says that those electronic decisions that are the administrative law, those decisions that to kick it out, they fall within the definition and the meaning of what you call PAJA. So the point that I want to make to answer your court is that the decision is an electronic decision to kick us out. It's not a manual decision where we went to Centurion where we submitted, then the kicks. So that's a basis that I want to say. That's what I'm saying, that those decisions have got direct and external legal effect for us in order for us to participate. And it's a section 19 of the Constitution. Of course, I don't want to deal much with the proper interpretation of the rights. I'll deal with it in case that my learned colleague will do it. So the point that I want to make, Lordship, before I close, it's 1, in substance, it's a review application. 2, I'm saying on a proper interpretation, we complied with this within section 27, even though it's not manual, but it's a thing. It's electronic or IT related basis. Those are only submissions that I wanted to say. But then over and above, then on the issue of the costs, of course, if we are successful, BioWatch will then dictate that cost base must be out or not. So if in case we we're not successful, of course, the cost will not be against us. It will be that council including 2 councils as a court places.
Thank you. Justice Song, any question? Justice Song, any question?
Yeah, no, I don't have any question. Thank you.
Judge Adams, any question?
Nothing from my side, Justice Zondi, thank you.
Professor Ntlama-Makhanye, any question?
Nothing from my side as well, Judge. Thank you.
Professor Puga, any question?
Yes, just one question, Judge. Advocate Ramaili, thank you very much. I just want to understand on the issue of a decision.
Yes.
Do I follow you correctly that when the system, for example, kicks you out, you consider that to be the decision? Am I correct?
Yes, it's an electronic decision. So from a jurisprudence point of view, from an academic writings, electronic decisions are taken to be decisions within the definition and the meaning of the promotion of what you constitute to be what you call administrative decision. That's what we don't have a case law, but we have an academic writings that say electronic decisions constitute the decisions within the definition and meaning of PAJA. That's what the point that we were making. A lot.
Thank you, Counsel.
Thanks.
Thank you, Mr. Ramaidi.
Thanks.
Okay, thank you. Mr. Bishop, it's your turn now.
Thank you very much, Justice Zondi, members of the court.
So it's 14:24. You are 15 minutes. Well, you are going well. I think that we need to give you more than because you are responding to all
just
3
10
applications.
Minutes. Just 10 minutes will be fine, Justice Zondi.
Sure.
Thank you. Justices, this case is about parties that knew about a deadline weeks in advance and did not comply with the deadline. The vast majority of parties who wish to compete in this election, 87 parties and 10 independent candidates, complied with the deadline. They used the same system, the OCNS system, to upload their supporter signatures for unrepresented parties and their candidate lists, or they made use of physical submission for candidate lists. But they complied with the requirements of the law and the regulations. These applicants did not. They either failed to nominate sufficient candidates to compete in all the elections they wish to compete in, or sufficient candidates to compete in any elections at all. Now, the Labour Party says that it is entitled to compete because it wished to compete, but it has no entitlement to compete in elections if it does not comply with the requirements of Section 27 of the Electoral Act. The entitlement to compete in elections is limited to those parties who comply with Section 27. And the question really at the heart of this case is whether these parties failed to comply because of their own conduct or because the Commission made compliance impossible. And I agree with the submission of Counsel for ACT, Mr. Am. He said the question is, was compliance objectively impossible? That's the correct inquiry for this court. Did the Commission establish a system that made compliance objectively impossible? And if no party had been able to comply, if we were sitting in a situation where 0 parties were able to comply with the requirements, or only a handful were able to comply with the requirements, then that would be a strong case to say this online system that you've devised in order to enable parties to submit their candidate list, their supporter information, pay their deposits, does not serve its purpose. It's actually made compliance impossible. But what we have here is the reverse of that situation. What we have is a situation where 87 parties, including many unrepresented parties, use the system and will be competing in the election. 2 of those parties were able to compete even though they only began doing so the day before. Now, the evidence of the Commission is clear. The online candidate nomination system enabled compliance for political parties and independent candidates. If the applicants failed to upload all the information they required to compete in the elections in which they wished to compete, it was not because of the system. It was because they left everything to the last minute. The 3 parties who've argued so far, one of them began uploading its first candidate 1 minute before the deadline. Another just 36 minutes before the deadline, and a third 2.5 hours before the deadline. And I think it was Mr. Vilakazi who said, well, the problem was that the commission didn't tell us when to start. But as I think it was Judge Shongwe put it, you start as soon as possible. These systems have been open for the parties to upload signatures since 24th of January and to upload the candidate nomination since the 23rd of February. They were open. You could begin on that day. And 87 parties who acted reasonably were able to use the time available to upload all the information they wish to upload. The other reasons why we're here today is because some of these parties seem to have underestimated the task of not uploading, but the task of collecting the information, because they had to collect the signatures and collate those signatures and collect their nominations and collate the candidate nominations and all the various annexes you have to upload. You don't just upload the list of the candidates you wish to compete. There's various documents that have to be attached to that. Nomination acceptance forms, various other documents. And so you had to collect all of that. And some of these parties seem to have underestimated the time it would take them to do that. That's not the commission's fault. Several of these parties clearly did not understand how the OCNS worked, despite the numerous manuals that the commission made available, despite the training and the workshops that the commission provided. They misunderstood the system. For example, the African Alliance for Social Democrats states that in order to perform, you have to do operations in a certain order. You have to first upload your supporter information before you can upload candidate information or before you can pay a deposit. That's false. That's just not how the system worked. On the system, all you had to do was tick a box to indicate which election you wished to compete in. You had to do that. You have to say, I wish to compete in the Gauteng provincial legislature election, or I wish to compete in the National Assembly election in the following regions. Once you tick the box, the system generates a payment reference for you, and you can upload supporters, and you can nominate candidates. You can do it in parallel. You can have as many users as you like, all uploading information in parallel at the same time, uploading different information. Some can be doing candidates, some can be doing supporters, somebody else can be making the payment. All of that was enabled by the system that the commission created. And the reason some of these parties are here today is because they didn't understand how it worked. But that's not the commission's fault. That's their fault. I think it was Mr. who, near the conclusion of his submissions, in dealing with the question about, well, what about the other parties who aren't before this court today, who've recently filed applications? And he says, well, they shouldn't be allowed an opportunity to compete because just because a party says they had problems doesn't mean it is so as a fact. Again, I agree. Just because these parties said they have problems does not mean it is so as a fact. The commission has put up the evidence to show that this system worked. And if parties fail to upload all the information they wish to upload to compete in the elections they wish to compete in, that was not the system's fault, it was their fault. It's important to note that none of the applicants before the court today challenge any of the relevant underlying law. Nobody challenges the requirements in Section 27. None of the parties challenge the submission regulations, which require the use of the OCNS system for the uploading supporter information and permit it for candidate uploading candidate information. Candidates you can also submit physically, which is a point I'll come back to. And so we have to accept that these are valid requirements. They're lawful requirements. And permitting or requiring parties to comply with those requirements through the OCNS is also lawful. Before I get into the meat of the submissions, there's two other issues I wish to deal with up front, because they're important in framing what the consequences of this case are. The first is about the remedy. There's two different types of remedies sought by different applicants. The Labour Party and the ACT seek, in effect, an amendment to the timetable. They seek to compel an amendment to the timetable. The consequence of amending the timetable is to reopen the opportunity for all political parties and all independent candidates, every single one, including those before this court, those not before the court, those on ballots, those not on ballots.
Sorry. While you're on that point, Mr. Bishop, why should it be so? Because those who say they were not affected, why would they come? Those who are not before us, why would they seek an opportunity to amend? Why wouldn't you create an opportunity for those who are before us and who have proved that there was a problem with, assuming that they're able to do so, that there was a problem with the system? Why should we bother about those parties that are not before us here?
Judge, there's two reasons. The one is a technical reason and the one is a substantive reason. The technical reason is that if the order is an order that obliges the Commission to amend the timetable, then the legal consequence of amending the timetable must apply to all parties. The timetable applies equally to all parties. The timetable applies equally to everybody. You cannot have a provision in the timetable that says, I'm amending item 9 of the timetable so that parties A, B, and C need only submit by a later deadline, but all the other parties must submit by the original deadline. So that's a technical reason. The substantive reason is fairness, because there may well be parties who did upload all the candidates that they wish to, but actually if they'd had more time, they would have chosen different candidates. They rushed the process because they were trying to comply with the deadline. Or there may be parties who are on the ballots for some of the elections, but if they'd had more time, they would be on the ballots for other elections. They haven't come to court. They've said, well, we don't think there was a problem, or there was, but we're satisfied with these elections. But it's unfair to those parties who complied to create a special exemption only for those parties who failed to comply and have come to court. That would render the elections unfree and unfair. And I'll take the court to the authorities on that point. So the consequence of the relief sought of amending the timetable is necessarily to reopen it for all parties. But it must be so also for the other cases which effectively seek exemptions. I'll argue later that exemptions are not possible. It's not possible for the Commission or for this court to grant condemnation or exemption to particular parties. What they really, and the only remedy that can lawfully be given is again one that reopens the opportunity for submission for all political parties and independent candidates. And once that's accepted, the consequence of the relief sought will be a postponement of the election. The Commission cannot arrange an election on the first votes on the 17th and 18th of May for overseas voters. The main election is on the further special voting on the 28th and the main election on the 29th of May. The Commission says it cannot guarantee a free and fair election on those dates if the remedies sought by these parties are granted. It will lead to a postponement of the election. And the reason is very simple. It's not a case of, as Mr. M suggested, just open it for an hour and then we're done. Because once you reopen it, you go back to that point in the timetable. You go back to where we were on the 8th of March. And all the steps in the timetable that followed from item 9 will have to be redone for those parties who take advantage of the reopening of the system. So the Commission will be put back in the position it was on the 8th of March. It'll have to go through the Section 28 process again to allow those parties who put up new candidate names but don't give the nomination forms to fix those errors. It'll have to go through a new objection process for the new candidates who are nominated. It'll have to go through a new appeal process against the decisions of the Commission for those objections. It is not a matter of a date, it's a matter of, it's a month almost since that time closed. And the Commission will likely require close to another month to fairly perform that task again. And then it will not be ready for the election. So that's the reality of the relief that's being sought here.
Well, it will seem to me that your submission is that the timetable cannot be amended. Now, if that is the approach that the Commission adopts, why then do we have Section 20?
I'm glad you asked the question.
Amendment.
Sorry. I'm glad you asked that question, Justice, because the next thing on my notes is need to dispel this argument that the Commission says the timetable is cast in stone. That's not the Commission's position. It's never been the Commission's position, ever.
Right.
The Commission's position, Section 22A is very, very clear. The Commission can amend the timetable when it is necessary, is triggered by when it is necessary for a free and fair election. So if it is necessary, the Commission can and will do so. So if this court grants the relief sought by some of these applicants, then the Commission will amend the timetable because it will be the only option available to it. But the difficulty the Commission has then is that it will amend the timetable, and it will also have to ask the President under Section 22B to postpone the election, because that's the only way that the election can be free and fair. So we're not saying we cannot amend the timetable. We're saying we cannot amend the timetable and hold an election on the 29th of May.
But isn't that the timetable is structured in such a way that there is a leeway, in other words, to deal with some events that might take place that might sort of affect the timetable? You create a space for yourself to deal with those eventualities. Now, what is happening in this particular case, is it not one of those eventualities that would enable the IC to revisit its timetable and look at it?
Unfortunately not, Justice Zondi, because we're now almost a month after that deadline. If what had happened, the Labour Party went to court on the 8th. I was in court on the 8th in the High Court, and they were asking for it to be extended for another day or two. If that had been granted at that point, and the timetable had been amended and extended for another day or two, it might not have had all the knock-on consequences we now have. But the reality is now we've gone through all these processes to go through the Section 28 process, the Section 30 process. And if we reopen the opportunity for candidate nominations, we will have to go through all those processes again. And that time is not a question of a few days. Unfortunately, Justice Zondi, that's the reality. And the Commission is very clear, it cannot hold a free and fair election if it is required to reopen the candidate nomination system at this point. And that will lead to a postponement.
Yes, but what about the argument to say, well, the delay is not, it's not our fault, it's because of the way the litigation goes. You had to be given an opportunity to file answering affidavit. They had to be given an opportunity to file replying affidavit. So yeah, that's unfortunately that's a function of litigation. There are some steps that you can't avoid to take.
Yes, I accept that, Justice Zondi. But we still have to deal with the reality, and the court has to deal with the reality that faces it today. And it may, if the court is against me on the merits, and I'm going to argue this court should just dismiss the application. But if the court is against us on the merits, then the consequence of the remedies that are sought will be a postponement. That doesn't mean that the court cannot grant a remedy. I'm not making that submission. I'm not saying that therefore no remedy should be granted. I'm saying the consequence of the remedy will be postponement.
I see Justice Shong has got a question for you.
Yes.
Yes, Justice Shong, go ahead.
Okay, thank you. Thank you. Mr. Bishop.
Yes.
Is your argument that the portal was functional all the way? Is that your argument?
Yes, and that's what the evidence shows. That's the fact that all these other parties were able to comply, including multiple unrepresented parties and parties who only registered on the portal the day before were able to comply. The fact that we have in the ACT application the information from the Commission's IT specialists that show that it was operational.
Yes.
And that there are other explanations, which I'll get to, for why the failure of these particular parties to upload the information they wish to upload. We can see from their own evidence, was their failure to understand the system, to leave everything to the last minute. That's why they are in the position they are, and the other 87 parties are not.
Now, if one is with you with that argument, that if the relief asked by the parties is granted, then it will mean, and is that the only meaning, that the elections have to be postponed? Isn't there any other way without postponing the elections? Because I'm looking at the preservation of the integrity of the elections being free and fair.
Yes, well, that's what the Commission has said, Justice Zondi, because all of these processes of nominating candidates, dealing with the Section 28 process, the objections to candidates are in order to finalize who's on the ballot and who the candidates are that are standing. And that process is almost finalized. It will be finalized on the 9th of April as we stand today. But if this relief is granted, the Commission will have to go back a month. It'll have to reopen the portal for however many days. It'll get new candidate nominations. It'll get new parties for new elections. It will have to go through the Section 28 process again for all those new candidates. It'll have to reallow objections for the new candidates. It'll have to have new ballots because there'll be new parties on new ballots. It'll have to redraw the ballots. It cannot start printing the ballots. Those are the knock-on effects. And I'm not blaming the applicants. I'm not saying this is the applicant's fault, but this is the reality. And if the Commission cannot go through those steps, it cannot hold a free and fair election. And so if the relief is granted, it should not be granted. There's no basis for the relief. But if it was granted, the Commission will have to amend the timetable and seek a postponement of the election.
Thank you.
Tell me, as of today, how many parties were able to get into the system and upload their candidate list successfully? Do you have that information?
87.
87.
Yes, and 10 independent candidates.
That will include registered established parties and registered new parties.
Yes, yes. As this court knows, there are many unrepresented parties that are on the ballot.
Yes. Okay. And then what about the candidates? How many candidates? Well, the independent candidates. How many independent candidates were able to get into the system successfully and upload their information?
My understanding is there's 10 that will be on the various different ballots.
So there are 10 independent candidates.
Yes. Across all the different ballots.
So those candidates who are on the ballot are the candidates who were able to comply with Section 27.
Yes. It was less onerous, of course, for independent candidates because they only had to upload 1,000 supporters.
Yes,
and no candidate nomination forms.
Yes.
Yes. But again, that whether that's unfair or not is a question that's not going to be decided for this election. The Constitutional Court decided not to address it. So this court has to accept that the requirements of the number of supporters that that an unrepresented party has to upload is a lawful requirement.
Is it true or is it correct to say when the system is being used by so many people, people who are rushing the deadline, then it becomes strained and pressurized, and it may kick off some people because there are too many people in the game, if I may put it that way.
Yes. Well, Justice Shongwe, that's not what the evidence in the ACT case shows. So the evidence in the ACT case, which is the report from Lockett Down, which is the Commission's IT provider, shows that the system was operating at 100% uptime, and that if you look at the speed, it was hovering just under 900 ms, which I understand is a good speed. It doesn't dip at any point, and it's checked every half an hour on the 2 days before the deadline. So the evidence that the Commission has available to it is that no, that didn't occur. But if it did, let's say there was a increase in traffic that caused some slowing down in the hours before the deadline. That might also be a case with manual submission. If you are rushing to get to the Commission's office just before the deadline, and so are lots of other parties, and so there's a traffic jam, or there's not enough parking at the Commission's office, so you have to go outside and find some other parking and walk to the Commission's office, and therefore you're late. That's not something that's absolutely in the Commission's control. It says it's done everything available to avoid that. It uses special servers. If I can just find the reference, it says the OCNS website runs on multiple services that were load balanced. In other words, the website is designed to receive and process large volumes of information. So this is not a situation where the Commission established a system without anticipating that there would be lots of parties using it. It did. And that's why the vast majority of parties used it with no difficulty and have complied.
Thank you.
I see Professor Puga, I've got a question for you.
Yes.
Thank you, Mr. Bishop. But does this report tells us that at this particular time, maybe an X number of people were kicked out? At this X number of time, maybe it became slow, or it merely says it was functioning at optimal level?
Yes. So if you look at it, begins in the ACT papers at page 260. And so what it says is the website had an uptime of 100%. So as I understand it, what that means is that it was up. The website itself didn't go down. It says the website passed 406 health checks in the last 30 minutes successfully. And then it's got a number of graphics, graphs that follow from that, showing health checks by failure reason, no failure, health checks by uptime. And you can see on this, you can see the times at which it's checking. So this is on the 8th. And there's a number of these graphs that come in where what the Commission's ICT service provider is saying is it was working as well as it could. So can I say with absolute confidence that not a single party was ever kicked off the system for some reason? I can't say that. But I don't think.
How does this court then place so much reliance on this report if it cannot tell us everything as asked?
Well, I don't think it has to tell you all of that, Professor Puko, because again, the question is not, the question is, was compliance objectively impossible? So did the Commission create a system and afford enough time that a reasonable political party could comply and could compete in these elections? That's the question. So, and the evidence shows overwhelmingly that it did. And it's not just about the report. The report is one piece of that evidence. The other evidence is the evidence given by the Commission's officials in their confirmatory affidavits, and what we know about what other parties were able to do, how they were able to use the system. Because if it was a system problem, it would have affected every party, not just a handful of parties.
Thank you, Mr. Bishop.
Yes, Mr. Bishop, just from my side, I was wondering if we know how many of the 87 parties that were able to comply, how many of those were unrepresented parties. And whilst we at that, I also wanted to know from you, what are we to do with the evidence, and the evidence on behalf of the Labour Party to the effect that they did the necessary preparations beforehand. They had collated and collected all of the information they required, and they had given themselves 2 full days within which to comply. And they had made sure that all of the logistics are in order. They got themselves a nice center where they could upload, etc. And despite all of those preparations and all of those systems that they've put in place, that they were unable to comply. What do we make of it? I know that you said just now that you'll address these issues, but I was wondering what to do with those, because they seem to suggest that there was nothing more that they could do under the circumstances.
Well, I think the first thing that they could have done is seek to upload their candidates earlier. I just want to make sure I get the correct time when they uploaded their first candidate. If you'll just give me 1 second. So the Labour Party uploaded its first candidate at 16:24 on the 8th of March. So it only started uploading candidates 36 minutes before the deadline. So it was open for it to start uploading candidates from the 23rd of February, but it waited until 36 minutes before the deadline to do so.
Oh, you mean even before they completed the uploading of the supporters list?
Exactly, Justice Adams. That's absolutely right. All you had to do in order to upload your candidate documents was tick the box for which election you wish to compete in. Once you did that, you could do all 3 things. You generated a payment reference, you could pay your deposit, you could start uploading your supporter information, and you could upload your candidate information. And you could have one person doing supporters and one person doing candidates for the same election. The system allowed all of that. And what's particularly telling about the Labour Party is they've changed their case with respect. If you read their founding affidavit, a large part of their case is the reason for our difficulties is our registration, and you didn't tell us when we were registered because you didn't send the letter to the right person. You sent the letter to the wrong person. So we didn't know we were registered. We didn't know we could then get on the system. But we show that that's false. We sent them to the right people, to their contact person and the head of the party. We sent them the notice that they were registered on the 7th of February. They could, on the 7th of February, have written to the commission and said, please, let me create an OPA, an online portal administrator. And then they could have got on the system. They could have then started with their supporter upload.
If I understand you correctly, what you say is when they started the whole uploading process on the 6th of March, they should have run parallel processes. They should have done the supporters list with the generation of the invoices, plus the candidate list, which they could all have done at the same time, and they would have been exactly. They would have been done long before the cutoff date on the 8th of March. Yeah.
Exactly. And again, if you read the Labour Party's founding affidavit and you look at what their complaints are about the system, a lot of the complaints are about the capturing of the information and how long it takes to capture the information. Because what you have to do is most parties, when they collect the signatures, they do it in hard copy. You have a list with you write your name, you write your ID number, and then you sign. Now that has to be captured electronically. At some point, it has to be captured electronically because the commission needs to confirm that these are registered voters in the correct area where they're required to be registered voters by the legislation. So we need the ID number. To do this, we cannot do it manually. It's not possible for the commission to do that manually. It needs it electronically, and then it can check it against the voters roll. And so,
but they did all of that, and they seem to have complied as far as that is concerned. Their difficulty is that they wanted to complete that process before they started uploading their list of candidates.
Well, I'm not sure. It's clear that some of the other parties laboured under the misapprehension that they had to do that. I'm not sure the Labour Party did. But if we look at when, in fact, they uploaded their first candidate, it was only at 36 minutes before the deadline. But the point I wanted to make, Justice Adams, is that these complaints about where they talk about the system and the internet, that's about the uploading. But the capturing, which is actually the time-consuming process, has got nothing to do with the portal. That happens offline. That's
but they said that they collected and captured all of the information until they set up their systems in Birchwood. They said by the time they commenced the uploading process, all of the information was there. If they knew then, all they needed to do was just to take the boxes to the head office in Centurion. But I understand their case to be that they were ready to roll by the 6th.
That may have been the case by the 6th. I think that is what they say in the replying affidavit. I don't think that's clear from the founding affidavit. Mr. Hopkins will correct me if I'm wrong. Okay. But if you look at the complaints in paragraph 36, where they're talking about how onerous it is and how it will take 100 days. It will take 153 work days to complete. What they're talking about there is not uploading the spreadsheets onto the portal. What they're talking about is the capturing.
I see. Oh, I see. Okay.
Yes.
Okay, you were also just going to look at how many parties were unrepresented that were able to comply?
That were unrepresented? So, sorry, what, 1 second?
Yes.
I don't think this is in the papers, Justice Adams, but my instructions are that it's 75 are unrepresented parties. So the majority of the parties who are competing are unrepresented parties.
Thanks, Mr. Bishop.
Yes. Thank you, Justice. Yes, sorry. So I'd like just to come back to the structure I wanted to follow. Oh, sorry, Professor Ntlama.
Oh, so Professor Ntlama Makanyi, you've got a question for Mr. Bishop.
Thank you, Judge, and thank you, Mr. Bishop, as well. I'm listening to the submission, and I'm also digesting the questions that we have on the use or on the functionality of the portal, which takes me to the context within which the portal was developed. My question is the extent to which the Commission has ensured the quality of information sharing to the parties in order to ensure that any glitches that may be encountered during the process of submitting the list are minimized, except for the pamphlets and the workshops.
Yes.
Because that is the gist of the argument that is being made today. There was a few of the parties that couldn't get to the system or kicked out or something. This is my assumption. Maybe they lacked the technical expertise to upload their information. So to what extent did the commission, other than the flyers and the workshop, made sure that it transmitted the needed information for the parties to upload their information? Thank you.
Thank you, President Palmer. So you've mentioned two of the important things already, which are the workshops that were held and the guides that were available. There are multiple guides that go through in detail how the system works, but it's also the evidence. And this is in the Labour Party matter, it's at page 36 of the answering affidavit on page 190, which says, in addition to all this training and resources, the Commission's officials were constantly available on email, phone, and WhatsApp to answer parties' questions and concerns about the requirements and about the OCNS. The applicant frequently requested assistance and was always promptly assisted by the Commission's officials. So if you look at the Labour Party, for example, it had difficulty registering its OPA. The Commission's officials are replying within hours over a weekend to assist the Labour Party to register its OPA. But that type of assistance can only go so far if you have to ask the right question. If you are operating under the misapprehension that you have to upload all your supporter signatures before you can upload a single candidate because you haven't read the guide, but you never ask the Commission cannot help you. The Commission doesn't know you've misunderstood the process. If you are engaging in one-by-one uploading, so there are two ways to upload supporters and upload candidates. You could do it on the website, on the portal, and you upload one at a time, the name, the ID number, submit. It'll check the ID number. It'll either accept it or not, depending whether they're on the voters roll. Or you can prepare your spreadsheets, capture all the information in spreadsheets, and upload those. If you don't know, because you haven't read the guides, you haven't attended the workshops, that you can do a bulk upload, and you don't ask the Commission cannot help you. So the Commission did more than enough to enable parties, and that's why so many parties and so many unrepresented parties are on the ballot. It's not because the Commission created an unworkable system and didn't help anybody.
Okay. Thank you, Mr. Bishop. Back to you, Judge Zondi.
Thank you, sir. If I can just, I've covered a lot of important points in dealing with the questions, and thank you very much for the questions because they go to the heart of, I think, what some of the issues are. But just to come back to the outline of what I wanted to submit, I wanted to first deal with 5 sort of basic principles of law, which underlie how this court needs to approach this question and these cases. The first is, I think, one that I've made already, which is that the submission of this information is governed by law. It's governed by Section 27 of the Electoral Act, which says you must submit in the prescribed manner. The prescribed manner is defined by the submission regulations. I'll come back to this when I deal with substantive compliance, but the submission regulations require signatures to be uploaded on the OCNS and permit candidate information to be uploaded on the OCNS. So if you haven't put it up on the OCNS, then you haven't complied. You must actually upload it, you must submit it. And the timetable, which is a form of subordinate legislation, which this court has held, timetables are forms of subordinate legislation, is a product of consultation. The Commission has to consult with the National Political Liaison Committee before it sets the timetable. And what this court said, also what the Constitutional Court said in Liberal Party, at paragraph 29 of the judgment, it's quoted at paragraph 68 of our heads, says to amend the timetable would in essence be to disregard the consultative process that led to the finalization of the published timetable. Its amendment, unlike a party-specific rectification under Section 28, would affect all the parties contesting the election, not to mention the Commission itself, as the new timetable would be applicable to all parties. That goes to the question you asked earlier, Justice Zondi. And then it says, as such, changing this timetable must be viewed as a last resort, not occasioned by the mere late submission of a candidates list by one party, or a handful of parties. I'm adding the last bit. And the way the timetable works is it generally works backwards in the sense that the commission doesn't set the date of an election. That's set by, in the case of a national election, by the president. And the commission's figured out, well, roughly how much time does it require to perform each of these steps. I can give you the reference. It's in the Labour Party record, page 208, paragraph 80 of the answering affidavit, where the commission explains it's figured out over time how long it needs to perform each step to get ready for an election. And that's how the timetable is calculated. It requires approximately 86 days to get ready for an election. And it knows how much time it needs for each step. And obviously, it cannot publish the timetable until the date is proclaimed. And it has no control over when the president proclaims or for when the president proclaims. So that's the first point. The second point is that the point of the timetable is not to ensure that every single party who wishes to compete can compete. The purpose of the timetable is to enable the commission to prepare the election. And this appears from the National People's Party case. It's quoted in our heads of argument at paragraph 15. And what this court said there is the purpose of the timetable is to facilitate the smooth running of the election process. It is intended to allow the administration of elections to proceed without disruption and for officials to properly prepare for the election, by inter alia the announcement of the contesting parties and candidates and preparation and distribution of ballot papers. It also serves to avoid unfair advantage occasioned by late entry to a particular party. Adherence to the timetable is peremptory since certain requirements have to be complied with within the time limits stipulated in the timetable in order to properly prepare for the elections. Now, of course, the timetable isn't only for the commission. It must afford a reasonable opportunity for any party or independent candidate who wishes to compete. But the purpose of the timetable is not to set dates so that every single party can compete, even if that undermines the ability of the commission to then deliver a free and fair election. The third point, and this is important, is that strict adherence to the timetable is vital for the fulfillment of constitutional rights. It's vital for fulfillment of the basic values in the Constitution and to ensure fairness between the parties. And there's a few authorities I'd like to take the court to briefly. The first is the Inkatha Freedom Party case of the Constitutional Court. It appears at paragraph 39 of the heads of argument. And what Chief Justice Nobo said in that matter is that the foundational values of universal suffrage and multi-party democracy, these values are best advanced through the Commission's rigorous adherence to the provisions of the Act. And that rigorous adherence is crucial to the integrity of the electoral process. And this court explained that again in the National Freedom Party case. It's at paragraph 44 of the heads of argument, where it said that parties that comply with electoral deadlines acted fairly. They are entitled to complain of an unfair election should non-compliant candidates and parties be allowed to join the process despite their failure to comply with the prescripts. So if the prescripts are fair, if they gave parties a reasonable opportunity to comply, and some parties comply and others don't, it is unfair to the compliant parties to then afford the non-compliant parties an extension or another opportunity, another second bite at the cherry. The third point I want to make is in the next paragraph of the heads, in the Inkatha Freedom Party case, what the court said there, and this goes to the role of the commission. And it's particularly important for the three cases that we've called being free and fair. Even-handedness in dealing with all political parties and candidates is crucial to that integrity and its perception by voters. And the commission must... Sorry.
Hello.
Sorry, I thought I heard a
question.
Somebody
from somewhere was...
Thank you, Justice Sunday. The Commission must not be placed in a situation where it has to make ad hoc decisions about political parties and candidates who have not complied with the Act. So this is important because there's either compliance or there's not compliance. That must be substantive compliance, which means compliance with the purpose of the provision. But it's not open to the Commission, and with respect, not open to this court, to say that a party that has not complied with a requirement in Section 27 of the Act should individually be afforded an opportunity to comply. So, but the fundamental point is that some of the applicants argue that the constitutional rights in Section 19 require that they should be allowed to participate, and that exceptions should be made, timetables should be extended to enable their participation. But that's not what the case law says. What the case law says is that sticking to the timetables, requiring all parties to comply with the timetables equally, that is what gives effect to the constitutional rights and values. That's what ensures free and fair elections. That's what promotes democracy. And so for exactly that reason, and this is my fourth point, is that the Constitutional Court has expressly held in Liberal Party that the Commission has no power to condone non-compliance. I don't need to read it, but it's at paragraphs 22 and at 25 of the Liberal Party case. And then the last point is this issue of substantial compliance. So we accept that in the ACDP case, the Constitutional Court held that what is required is not strict compliance, but substantial compliance. And the facts there were that the ACDP had paid sufficient money to the Commission, but it hadn't identified in the way the Commission required it to for which of these municipal elections the money had been paid. And the question was whether that constituted substantive compliance or not. And the court held it was, because the purpose of the deposit was to demonstrate your seriousness in competing the election, and the Commission had received the money by the deadline, even if it hadn't been properly informed for which election. So it held that was substantial compliance. But the question that has to be asked is, with regard to each requirement, has there been substantive compliance with that requirement in terms that the purpose has been met? So this is particularly relevant for the AASD case. And I think I think Mr. Ramalili said that there's no debate that they have substantively complied. There is a debate. The Commission does not accept that they complied. The argument seems to be that because they were logged onto the system by the deadline, that even though they had not uploaded all the candidates they wished to upload, because they had them on their computer and they were in the process of uploading them to the Commission server, therefore there's substantial compliance. But that's simply not what the regulations say. The regulations say that you must have submitted it electronically. Specifically, Regulation 2(1) says that you complied by providing the information required in the relevant fields for that purpose on the CNS system, and B, uploading the annexures required for that purpose onto the CNS system. So it's not enough to say, well, I was logged into the system, but I hadn't provided the information. It's like saying I was in the parking lot of the Commission's office with all my documents in the boot, but I hadn't yet gone and submitted it to the Commission's actual office. If you haven't uploaded it, you haven't complied. And there's no way that the Commission can accept that as compliance, because it isn't compliance under the regulations. And the reality is, if AASD was correct and it had substantially complied, then the relief it should be seeking is to be on the ballot, because it has complied. But that's not the relief it seeks. The relief it seeks is to reopen the portal so that it can comply, because it is currently non-compliant. So that's the constitutional legal background against which this case has to be decided. I then wanted to deal with the facts in two ways. The first is just to briefly describe how the OCNS operated, and I've covered a lot of this already, and I'll try not to repeat myself. And the second is to show that the OCNS did not malfunction, and the reason that these applicants were not able to submit all the information they wished to submit was because of errors on their side. And I want to begin with the issue of Plascon Evans, because it's been debated by the counsel who argued before me. And the principle is trite, that this court must accept the Commission's version unless it is so far-fetched or clearly untenable. We deal with it at paragraph 76 to 80 of the heads of argument. And it's because of this principle that Mr. Hopkins spent the early part of his submissions trying to exclude the Commission's answering affidavit. Because if the answering affidavit isn't before this court, the Plascon Evans doesn't apply. And if it is, then this court has to accept the Commission's version unless it is far-fetched or clearly untenable.
Sorry,
and so,
while you're on that point, Mr. Bishop, your answering affidavit is it properly before this court?
Yes, that is what I was going to do.
In relation to the Labour Party.
Yes. So if I can explain what happened there, as I understand it, is that the directive initially required the Commission to file by Monday, the 18th of March. it wrote to the court on Monday, the 18th of March, and said, we will not be able to comply with this deadline. Please, can we have an extension until the 20th of March? The registrar confirmed orally to both my attorney and a legal advisor at the commission that that extension was in order. That decision was never...
But surely, Mr. Bishop, when you are late, you contact your opponent and say, I've got this problem. I need to file by X, Y, Z date. But because of the following circumstances, I'm unable to do so. You agree to an extension. You don't go to court and approach the registrar for an extension before you have even contacted your opponent.
Justice Sondi, I accept that that might ordinarily be the
Yes.
course to follow. My experience in this court, in the Electoral Court, acting both for the Commission and against the Commission, is that because this court sets its own deadlines, it's not like in the High Court when in an urgent matter, for example, the applicant will tell you by when you have to file an answering affidavit. In this case, the court sets the directives. So even if we had the permission of the other party, we would still have to get permission from the court to file later. And so that's why regularly, if the Commission doesn't believe it will be able to comply with the deadline, it writes to the court to request a short extension. And that's what we've done here.
No. My question to you is, why don't you approach your opponent first and say, in terms of the directive that have been issued by the registrar, I need to file my answering affidavit by the 18th of March. I am unable to do so. I need a 2-day extension or a day extension. Do you consent? Are you prepared to grant consent?
Yes. Justice Sondi, with hindsight, perhaps the Commission should have done so. The question is whether its failure to do so means that this court should not accept the answering affidavit. Because
that's a question then.
Yes. So just to get the timeline right, what happened is that verbal assurance was given by the registrar. On that basis, the answering affidavit was filed on Wednesday. I understand that verbal assurance was never reduced to writing. It was never sent in a new directive to either the Commission or to the Labour Party. That obviously is not the Commission's fault. That seems to be an oversight by the registrar. But the Commission understood that the extension had been granted, and that's why it filed on the Wednesday, because it understood that the court had agreed to that extension. And so that's the situation in which we're now in. And so if condemnation is necessary, and it should be granted on good cause, I submit that there is clearly good cause in this situation. One, because of the reasons why it was filed 2 days late, because we understood that we did have an extension. Secondly, because it hasn't caused prejudice to the Labour Party. It's filed a full replying affidavit. It's had enough time to file further submissions. And also the matter is now before this court together with other applications. It would be an unfortunate result, Justice Zondi, if this court were to disregard the Commission's answering affidavit in the Labour Party case, accept its answering affidavits in the other case, and reach different conclusions in the different applications because on the basis of whether it accepted the answering affidavits or not. So here, where there hasn't been prejudice to the Labour Party, I didn't understand Mr. Hopkins to allege prejudice because of the late filing. It was more of a technical argument that there hasn't been an application for condemnation. So Justice Zondi, I was listening to Mr. Hopkins, and I accept that the facts that I've now described to you are not on an affidavit before this court. I've asked my attorney to depose to an affidavit to place those facts, and that we will file that with this court so that the facts are on oath about exactly what happened. It is consistent with what I've relayed to you from the bar.
Okay.
But we submit on that basis that the Commission's answering affidavit is properly before this court.
So that affidavit, when is it going to be filed?
It will be filed today, Justice Zondi, and it may, I haven't been able to check my emails while I've been in the hearing. It may have already been commissioned. Otherwise, it'll be commissioned later today.
Oh, proceed.
Yes. So it should be filed either because it wasn't late, because there was a directive from the registrar to the Commission, even if it was granted verbally, or if it was late, that we've established good cause for it to be admitted. So there are 5 points I wanted to just mention about how the OCNS works, and I've covered some of them, so I'm going to mention most of them briefly. The first is in response to Professor Nklama's question that the Commission made substantial information and training available. The second is that the whole point of the online submission system was to make it easier for political parties. So instead of having to take all your documents manually to the Commission's head office, you could do it from anywhere. You could be anywhere in the world and upload the information, and you could have multiple people doing it simultaneously. So it's an enabling tool. And importantly,
sorry, while on that point, Mr. Bishop,
yes.
Why? I understand that the Commission has got offices in all the provinces.
Mm-hmm.
Why can't the provinces take the why can't the provinces accept the candidate list?
Yes.
And support signatures document?
The legal answer,
and help those who are unable to, maybe
yes.
For some other reason, there's a problem with electricity as well, load shedding here, or they don't have a reliable system.
Yes. Justice Ondi, in terms of the submission
system that can assist them to undertake that type of activity which is required by Section 27.
Yes. Justice Ondi, so I think we have to distinguish between the submission of supporter information and candidate information.
Yes.
So under the regulations, candidate nomination lists and information can be submitted physically, but the regulation specifies that it can only be at the Commission's head office in Centurion. So that's a matter of law. It's in the regulations. It's not a decision or practice of the Commission. It's law, and it hasn't been challenged. So that's the legal answer for physical submission. In terms of aiding parties, of course, the Commission does try to aid political parties as much as it can. I've gone through how the Commission organizes workshops, provides training, answers questions. But as far as candidate lists are concerned, you can still do that manually if you don't want to do it online. But ultimately, Justice Ondi, the requirement that supporter signatures be done electronically is in the regulations. The regulations haven't been challenged. So I'm not in a position to defend the policy choice to say that this needs to be done online, because it hasn't been challenged. What's been challenged is not that it must be done online, but whether the online system was working or not.
Okay.
Yes.
Sure.
So just to clarify, so what the regulations require is that payments can be made either through a payment gateway, which means you put your card number in, like you'd be buying anything online, and then you do that through the system, or you can make the payment in an EFT and upload your proof of payment, or you can go to the bank and do the payment. And the important point, and I've mentioned this earlier, is that these can be done in any order. The first thing you have to do is select in which elections you wish to compete. And once you do that, the system generates the payment reference for you, because the deposit you have to pay depends on which elections you wish to compete in. It's calculated under Regulation 3, which sets out how that deposit is calculated. And so once you've done that, it generates a payment reference. The payment reference is a unique number, so the Commission knows when it receives a payment with that payment reference, which party made it and to which elections it applies. And once you've done that, you can then upload your candidates, your supporter information, and your signatures in any order that you please. And when we get to the ACT and the AASD, well, that was a fundamental error that they made, that they didn't understand that it could be done in parallel. It didn't have to be done sequentially, one before the other. The fourth important point to make about the OCNS is that there were two ways in which you could upload candidate nominees and supporter information. You could do it one by one on the system. You could fill in name, ID number, submit, name, ID number, submit. You wanted to do it that way, the system allowed you to do it. But it also allowed you to upload bulk spreadsheets. So you download the Commission's template, and it had to be in a template so that it would be able to read the ID numbers to check them against the voters roll. And then you put all your names and ID numbers up to 1,000 in that template. And then you upload that, an Excel spreadsheet, onto the OCNS. And they're not large documents. Excel documents do not contain a huge amount of information. And so that could be done, and that was, again, to make life easier, because doing it one by one on the system is going to take longer, and you have to be on the system all the time. So the Commission created an alternative to make life easier for political parties so they could do bulk uploads. The fifth point is that, and again, I've made this before, it is these complaints about the system only go to the uploading. I think what Mr. Hopkins called it was, you've got to collate the information first. So you've got to, for candidates, you've got to go through your own internal political party process to decide who is it that you want to nominate. And you have to collect from them all the relevant documents that you need under Section 27, including their nomination, signed acceptance of nomination. But that's got nothing to do with the online system. You would have to collect all that information, whether it was being submitted manually or physically. And as far as supporters are concerned, you would have to collect the signatures and then record them electronically. So you'd have to reduce them to an Excel spreadsheet. Those processes have nothing to do with uploading it onto the system. It's once you've completed that, then you upload the information onto the system. If you're going the bulk upload route, if you want to do it one by one, you want to take your 50,000 supporters and go one by one and put it in on the system, you are permitted to do that. It's not the most efficient way to do it. There's a more efficient way that the Commission makes available to parties, which would allow them to start this long before and then simply upload the documents onto the system. The sixth point to make is that the system was open to accept supporter information from unrepresented parties from the 26th of January. So it's also important to remember that the requirement of collecting supporters is obviously a new requirement. This is the first election in which unrepresented parties have had to collect this information. But it's been known since April last year that this would be a requirement, and that when the election was called at some point this year, parties would have to submit that information. That's when Section 27 of the Electoral Act was amended. And parties were able to do so from the 26th of January. So they had the 26th of January all the way until the 8th of March to upload that information onto the system. For candidate nominations, the system was open on the 23rd of February. So parties had 14 days, 2 weeks, to upload the candidate lists. And that is more than enough time to do so. Because for the candidate list, it's a few hundred names that you're submitting if you're competing in all the elections, up to 400 for the National Assembly elections and a few hundred for the various provincial legislature elections. So you have to upload those few hundred names and all the supporting documents. 2 weeks is more than enough time. I would understand the applicant's case if the Commission said, we're only opening the portal for uploads on the 7th of March, and you have to do it within 1 day, otherwise, sorry, bad luck. But that's not what the Commission did. It had it open for 2 weeks beforehand. So the question cannot be that if you started, that the Commission had to ensure that the system would allow you to fully comply to compete in every single election, no matter when you started your process. So it must work, whether I started on the 23rd of February or I started at lunchtime on the 8th of March. If the system didn't allow me to upload everything, it's the system's fault, not my fault. That cannot be the law. Political parties have to know what the requirements are. They have to take advantage of the opportunities, and they have to act reasonably. And any political party that did so would have been able to compete in this election. And that's what the facts show. So that's how the OCNS system worked. I then want to give what's really the heart of this case from a factual perspective is why we know that the OCNS was not malfunctioning. And we submit there's 6 reasons that we know that. The first is that these parties all left compliance to the last minute. The ones that they've argued so far today. The Labour Party, I've already mentioned, left its registration. It only applied for registration late last year. And then it was unaware that it had been registered, even though the Commission informed it on the 7th of February. It then only applied for an online portal administrator, which is what you need in order to access the system, on the 1st of March. That was when it started the process to enable it to begin uploading its signatures and its candidate nominations. And it captured its very first candidate 36 minutes before the deadline. With regard to ACT, it only started uploading candidates at 14:53 on the 8th of March. And its argument seems to be that, well, even if you leave it to the last minute, you have a right to compete. You don't. What you have a right to is a reasonable system that will allow reasonable parties to compete if they take reasonable steps. It doesn't say if you leave everything to the last minute, you must be allowed to compete. As I'll show, the reason ACT failed is also because it misunderstood the system. The AASD, I think, as you pointed out, Justice Zandi, uploaded its first candidate at 1 minute before the deadline. And it said the reason was it thought it had to comply with all the other requirements before it could start uploading candidates. But that's just not the case. That's not how the system worked. So the first reason we know it wasn't the OCNS is that we can see all of these parties left candidate nomination to the last minute, a few minutes or at most a few hours before the deadline. The second reason we know is because we know what other parties complied. And I'd like to take the court to page 202 of the Labour Party record.
Sorry, give me a sec.
It's page 202 of the Labour Party record. It's paragraph 75.
Got it.
So there, the department says that there are at least 3 unrepresented parties that are competing in all the available elections. Rise and Mzansi that captured its first supporter on the 31st of January. Action SA captured its first supporter in February. And the Patriotic Alliance used a different strategy. It had 189 users. So some of them started far, far earlier because they knew this was going to be a difficult process. It would require time, so we must start early. And again, I stress that the requirement for uploading signatures, and to get those signatures, is a difficult requirement, but it's not challenged in this case. And then we say the most striking example is the Economic Liberation Front of South Africa. Like the Labour Party, it only applied for registration last year. The 14-day period in which its application had to be open for objections expired only on 6 March, 2 days before the deadline. Yet it was ready to upload its documents. It managed to upload all the signatures it needed to compete, upload all its candidate nominations, and pay the required deposit. This fact, an undisputed fact, is fundamentally destructive of the applicant's claims. Because if the OCNS was malfunctioning, was not fit for purpose, the ELFSA would not be on the ballot. It complied within 2 days because it had everything ready to upload, and it was able to do so. So it is not far-fetched or clearly untenable for the Commission to say, if you had problems, it could not have been our system, because we have a counterfactual. We have a counterfactual that shows a party who was able to comply in 2 days. And then we say we have another one. We have the African Independent Congress was able to comply even though it only gained access to the OCNS at the last minute. It says the AIC is a represented political party, but it experienced an ongoing debate about its leadership. It was therefore unable to act until 7 March, the day before the deadline. Its representatives arrived at the Commission's office with a court order entitling them to act on the AIC's behalf. The Commission assisted them and was able to upload all the documents it required to compete in the election, when it only started the day before the deadline. So with respect, these facts show, with respect, at the very least, they show that the Commission's case is not clearly untenable, which is the standard that the applicants have to meet. To show that the problem was not the system. The system worked. So that's the second reason we know that the system didn't malfunction. The third reason is that if we look at what these parties say about the problems that they faced, we see that they didn't understand how the system worked. So if we begin with the ACT, so it says that it believed it had to upload all signatures before it could upload candidates. That appears at paragraphs 33 and 35 of its founding affidavit. But as I've explained, that's not the case. As soon as you tick which election you wish to compete in, you just tick the box. You can go ahead and upload signatures, candidates at the same time. You could have 10 different users, 5 doing candidates, 5 doing supporters if you wished. And then secondly, it mistakenly believed it had to upload its candidates one by one. That appears from paragraphs 48 and 50 of its founding affidavit. But as I've explained, that was open. That was one way in which you could upload the information, but you could also do it in bulk uploads. So if a party doesn't take advantage of the system, doesn't use the mechanisms there to enable fast upload, it cannot blame the Commission. The Economic, I want to get the name correct, Economic Liberation Front of South Africa must have done bulk uploads in order to do it within 2 days, because that option was available. The AASD also fundamentally misunderstood, because it believed that you could only generate a payment reference after uploading the signatures. And as I understood, the counsel for the AASD also submitted that you could only upload candidates after you'd uploaded your support information, and that's just not the case. So they could have been doing these processes in parallel, and you'll see both the ACT and the AASD and the Labour Party, they upload all or most of the signatures and supporter information they require, and then they fail at the candidates because they've run out of time to upload their candidates. But there was no reason for them to wait with the candidates. They could have started with the candidates as soon as they got access to the system. So with regard to the Labour Party, I've explained if one looks at...
Mr. Bishop?
Yes.
I'm sorry to interrupt you. I'm just wondering, because the evidence by most, if not all of the applicants, is to the effect that when they experience these difficulties and running into trouble with the timelines, etc., that they then contacted the Commission and they inquired from the Commission as to what the problem is. And the best advice they got most of the time was, why don't you just reboot the system every time? And the answers that you are giving us here, would that not have been the answers to all of those inquiries raised at the time? Yeah.
Yes.
So. Yeah.
Well, Justice Adams, it depends what the question was. So if the party calls the Commission and says, I'm having difficulty with uploading any information, or I'm being kicked off the system, then the Commission would try and fix that technical problem and maybe suggest you log out and log back in again. The Commission will only know that the Commission doesn't know what it doesn't know, if I can put it that way. Unless you tell it that your problem is, I really want to do the candidates, but I have to upload all my supporters first before I can get to the candidates, the Commission won't know that that's the process that you're following. And I don't want to take the court through it, but we've attached various user manuals and help guides that were available for parties to use the OCNS, and those make it clear that you could do these operations in parallel. So that information was always available to parties. So just that, it's a difficult question to answer comprehensively because I don't know what the nature of each inquiry was.
What the questions were, yeah.
Yes.
No, thank
exactly.
you. I think you've covered me, Mr. Bishop. Thank you.
Thank you, Justice Adams. So that's the third reason, is that the problem here was that the parties misunderstood how it worked. Oh, so with regard to the Labour Party, I'd explained that there seems to be their big complaint, if one reads their founding papers, is really about collation and about the time to get everything ready for upload. That's what they're really complaining about. But I know if one looks at reply and one looks at everything they say about Brentwood, and as I understand Mr. Hopkins, he said, well, by the time we got there on the 7th, we were ready to do all the uploading. And again, Mr. Hopkins will correct me if I'm wrong, but that's not how I understood their case in the founding papers. But again, it's difficult to understand how it could be the Commission's or the system's fault if the ELFSA, who was in an almost identical position, was able to comply and the Labour Party was not. So the fourth reason that we know the Commission doesn't malfunction is because the Commission denies it. It denies it expressly and repeatedly. So in the Labour Party case, it's at paragraphs 65 to 67, which are on pages 199 to 200. And this is dealing with hanging. So what it says, the applicant complains that the OCNS regularly stalled or hanged, and that their users were removed from the system and had to log in again. The Commission received some of these complaints from other parties, but the vast majority of parties had no difficulties using the OCNS. The Commission, when it has tested the system, has not experienced any of these difficulties. The Commission therefore believes that the problems are more likely a result of unstable internet connections or other problems for particular users. It's, with respect, Justices, the Commission has to look at it from a system-wide perspective. And if it sees this is working for almost all parties, some parties are having difficulties. Is the Commission's version that, well, the problem was more likely with your operation than with our system? Is that far-fetched and clearly untenable? No. If we turn to the ACT application, the relevant passage is paragraph 73 on page 150 to 151. And this is where the Commission deals with the lockdown IT report and says the Commission's records reveal that the OCNS operated smoothly, and then explains in detail what the lockdown report shows. In the AASD application, it's at paragraph 35, page 93, and this is in particular with regard to this claim of 20-minute sessions. So there's a claim that that you could only be online for 20 minutes and you're kicked off and have to log on again. And the Commission says that's just not the case, that the system doesn't do that. And with respect, that there's no hard evidence to discount the Commission's version. It would be bizarre to design a system that way. And the Commission says that's not the system we designed. So it's true that there were complaints, and it's not unusual for there to be complaints about the system giving difficulty to certain parties. But the fact that there were complaints, one, doesn't demonstrate that the system wasn't working. And also, even if certain users at some point were kicked off a system, that doesn't mean that the Commission failed to provide a reasonable system that reasonable parties could use to upload all their information. The consequence would be if one party at one point was kicked off the system because of some glitch in the programming, that then the Commission had the timetable was unreasonable. There might have been some minor issues that gone on. The Commission cannot conclusively say that didn't happen. But did that make it impossible for parties to comply? No. We know it didn't make it impossible because so many parties complied, even those that started very late in the day. The fifth reason is that the three parties that have argued so far today, their problem is not supporters and it's not deposits. It's candidate lists. And candidate lists could have been submitted physically. So at least for the Labour Party and ACT, which are based in Gauteng, and the one was apparently in Sandton and the other one was at Birchwood, which, as I understand it, is near OR Tambo, could have gone to the Commission's office in Centurion. If they say we had all these candidate lists and we had everything in hard copy, you could have driven them to Centurion. But instead, you try to upload your first one, in the case of the Labour Party, 36 minutes before the deadline. If you just left an hour earlier, it wouldn't be in this situation. It is not reasonable to say that is the Commission's fault, when the Labour Party could have cured all its problems by simply driving to the Commission an hour earlier and handing over the documents. So we submit for those 5 reasons. It's clear that the OCNS did not malfunction. And for that reason, there's no basis. That really is the fundamental claim for all these applicants, is that it was the system's fault. But those 5 reasons show it wasn't the system's fault. And so for that reason alone, before I get into the details of which decisions and grounds of review and all those details, for that fundamental reason, all these applications should be dismissed. So I'd like to then briefly deal with some of the more specific points. Firstly, with regard to what we've called the timetable cases, which are the Labour Party and the ACT case. And so I want to deal briefly with this question of which decision, and did the Commission take a decision or not take a decision, and then with the LPSA's grounds of review. So the Labour Party's case is this. We filed an application in the High Court on the 6th of March. And in that application, we asked the Commission to amend the timetable to give it more time, because at that point on the 6th, it was already concerned it might not be able to comply by the 8th. And the Commission, in its answering affidavit, which it had to file the next day, then implicitly took a decision not to amend, or took a decision not to decide. I think it's important to go to exactly what the Commission says it did. And it appears at paragraphs 96 to 101 of the Labour Party case. It begins at page 209 of the record. And so what it says at paragraph 96, that the Labour Party seeks to review the decision of the Commission taken on Thursday, 7 March 2024, not to amend the deadline. And then I deny that the Commission took such a decision. And then if you go down the next page, page 100, it says the first request the Commission received asking it to amend the timetable was the request in the applicant's papers in the High Court, which it received on 6 March and was required to answer on 7 March. I quote the Commission's answer to that request. The only decision the Commission has made is the decision to adopt the timetable. It will not take a separate decision not to amend the timetable. The Commission, therefore, has not taken any decision to amend the timetable or not to amend the timetable. It declines the applicant's request to take a new decision. Its decision, its only decision, is the one it took when it published the election timetable. And I need to explain the reason why the Commission takes this position. It's clear that Section 22A gives the Commission the power to amend the timetable. The suggestion that the Commission made an error of law and doesn't know that it has the power to amend the timetable is, with respect, absurd. It flows from a throwaway comment made by the spokesperson of the Commission, one of the commissioners, at a press conference. And because at that press conference, the Commissioner says the timetable is cast in stone. And at that point, when she said that, when she said the timetable is cast in stone, nobody had asked the Commission to amend it. There had not been a single request by any party to the Commission to amend the timetable. And in that context, one commissioner says the timetable is cast in stone. And that's then seized on by the Labour Party and ACT to suggest that the Commission made an error of law and cannot read the fundamental legislation that governs elections. With respect, it's really absurd. So the Commission took no decision at that point. And then it gets these papers on the 6th of March. It has to respond to them the next day. And it says, we're not taking a decision to amend the timetable or not. Because one, it's difficult to understand how the Commission could do so. And the Commission's concern is this: if every time a party or any other interested person asks it to amend the timetable, it has to take a new decision whether or not to amend the timetable. And that's a fresh decision that will allow parties to go to court and review on a new record of a new decision with again, starting the 3-day time period to review the decision. It places the Commission in an impossible position. What it says is, yes, we have the power to amend the timetable under 22A. We have a duty to take a decision, but only when it is necessary for a free and fair election. The duty to take a decision arises when that substantive trigger is pulled. The duty to take a decision does not arise when a party or an independent candidate asks the Commission to take a decision. That doesn't trigger an obligation to take a decision. And that's why we rely on the Offered Enterprises case, which is it's exactly what Offered Enterprises says. It says there's certain types of decisions where I make an application for a license or any type of application to an administrative official. the official is then required to decide the application within a reasonable time. And if you don't decide it, it can be treated as a failure to decide. But there's other types of powers. There's other types of powers where you don't have a duty to take a decision. And we submit that 22A is exactly such a power that is triggered by the substantive requirement of necessary for a free and fair election. And this whole debate about what the decision is with respect somewhat academic, because it's used to try and trigger these procedural review grounds. But let's say the Labour Party is right. Let's say the Labour Party is right that the Commission misunderstood its powers and it did actually have the power to amend, that it was wrong. It thought it couldn't amend, but it actually could. What relief would that entitle the Labour Party to? The only relief it would entitle the Labour Party to is to compel the Commission to take a decision. But that's not the relief that any of these parties want. The relief that they want is the actual amendment of the timetable. And to get the actual amendment of the timetable, they don't just need to show that the Commission may have made some reviewable error. It may have been obliged to take a decision when it thought it wasn't obliged to take a decision. They need to show that the substantive trigger is present. They need to show without the amendment, the elections will not be free and fair, that the amendment is necessary to make the elections free and fair. And that's the whole substantive issue I've been discussing. And that's the position the Commission takes. The Commission's position is that an amendment is not necessary to render the election free and fair, and so it's not taking a decision to amend. So with respect that this debate really is kind of goes around in circles, and it doesn't get away from the substantive point in the case, which is, was it impossible for the applicants to comply with Section 27? Did the Commission make it impossible? Objectively impossible, as Mr. Am put it. And if it did, then they must get their relief. And if it didn't, then they mustn't get their relief. And these other debates about what decision was taken with, when, by whom, with respect, don't go anywhere. So I don't intend to engage in detail with the debate about Section 510. So I have to repeat that it says that the Commission can adjudicate a dispute. And a dispute is a dispute between different parties. And there are regularly disputes that arise between different parties about the management of the election. They arise all the time, the Commission adjudicates them. It would respect not be a contextual and purposive interpretation of the Electoral Act to interpret Section 510 to mean that every time any party asks the Commission to amend the timetable, it must take a fresh decision whether or not to do so. But as I say, the debate doesn't go very far. Mm-hmm. That then gets me to the Labour Party's grounds of review, which I think I've covered already. The first is this debate that it's an error of law because the Commissioner's spokesperson said that the election timetable is cast in stone. I've dealt with that. It really is an absurd argument to suggest the Commission didn't know it had the power to amend the timetable. The second supposed error of law is that it was obliged to take a decision. And again, that doesn't get the Labour Party anyway. Let's say I'm wrong. Let's say the Commission was obliged to take a decision and it made an error of law. Well, then the relief that flows from that is a referral back to the Commission to take a decision. The relief that flows from that type of reviewable error is not reopening the timetable. It's merely requiring the Commission to take a decision. The Labour Party, ACT, can only get to reopening the deadline, amending the timetable, if they show necessary for a free and fair election. So the third ground, irrationality, is effectively that's what it is. In substance, it's saying that it was irrational not to amend the timetable because it is necessary to amend it for a free and fair election. And I've given all the reasons why they're wrong about that. The fourth ground of review relates to the deposit. So it's correct that the Commission made an error in its answering affidavit. It said that the deposit had not been paid. It's explained that error. It says because the payment was made by EFT, when it received the papers and it pulled up the information to see whether the payment had been made or not, it reflected as not paid. If I can just take the court to the relevant annexure, give me 1 second. It's on page of the Labour Party record, page 439. And there's a table there that reflects for each of the elections whether the parties represented or unrepresented, candidates captured, candidate capture score, supporter progress, submitted as final, and then it says payment banked, no. So when the commission generated that table, that was a fact. Later, the payment reflected was allocated to the Labour Party, and the commission now accepts that, yes, the deposit was paid by the deadline. But I need to make two important points about that. The first point is that it doesn't affect relief for the Labour Party. The fact that the commission erred about this, in its affidavit, about whether the Labour Party had paid a deposit, doesn't entitle it to an amendment of the timetable.
Mr. Bishop, while on that point, page 439.
Yes.
That document is generated on the 15th of March. And the payment was made when on the 8th of March.
The payment was made on the 8th of March. The email is sent on the 15th of March.
Yes.
It doesn't say when the table was generated, but the email is sent on the 15th of March.
Let's see. First captured Labour Party. Well, it's good day. Labour Party, it's submitted OPA 29.
Yes. But Justice Zoni, this is explained in the supplementary affidavit of Mr. Katiso Siani, where he said that this is what happened. And it has subsequently referenced, and we apologize for the error. It was an error. But what are the consequences of that error? Does the fact that the commission made a mistake about this deposit mean that the timetable must be amended? No.
But, well, the fact that there's a problem here, doesn't it lend credence to the allegation that there's a problem with the system because the system is unable to capture what is happening? It's
no,
a point.
Yes. Why?
Because if the payment was made on the 8th of March and on the 15th of March, it hadn't been, it's not reflected on the system, then there's something wrong with the system.
Well, Justice Zoni, that's what Mr. Siena explains, is that so there's two parts to the payment. The one is that you actually have to make the payment, and then the payment must be in the commission's bank account. And
This one was EFT.
Yes.
The payment was made by EFT.
Yes, which we know takes a few days to clear in some cases. So yes. I don't know, Justice Zondi, when this table was generated. If it was generated on the 15th of March or previously, I don't think that's on the papers. But the point is that was the difficulty, and that the system wouldn't necessarily pick that up immediately because the EFT would only come through later. If one looks at this table, for example, it shows the supporter progress. So how many of the supporters you'd uploaded by a percentage. And that information was available in real time to every applicant using the system. The commission says that expressly in its answering affidavit. Labour Party says, well, we didn't know how many we'd submitted. That's not the case. We say that's the case, and we put the screenshots up that show you can see your progress in uploading your supporters. So you didn't need to upload 122%. You only needed to upload 100%. And the system would tell you how many you'd uploaded. So I don't think, Justice Zondi, that this one error shows that the system didn't work. And it's also a very different type of error because what their complaint is about the ability to upload documents. This error, if there was one, is an error by the Commission's officials in accurately conveying the information to the court. I don't think it shows a system error at all. But also, it's not relevant to the relief sought. Because if what had happened here is the commission had said, Labour Party, you can't be on the ballot because you didn't pay a deposit, and it turned out that they had paid the deposit, the relief would be for the Labour Party to be on the ballot because the commission got the facts wrong. It had, in fact, complied with Section 27, and it should be on the ballot. But this error is not an error that leads to, well, the system didn't work, and because we made a mistake about the deposit, that's why you didn't upload your candidates. The two are not connected. And so it cannot lead to the relief that's sought by the Labour Party. That then brings me to So just before I end on the Labour Party, it paid its deposit. It uploaded signatures, and it uploaded candidates for the national election, but it cannot compete because it didn't upload candidates for any of the regional elections. And in order to compete in the national election, you must also compete in at least one regional election. And it didn't nominate candidates for any of the regional elections. So if it had nominated candidates for the regional elections, it would have been able to compete, but it failed to do so. That's the reason it's not on the ballot. With regard to ACT, it did in fact upload candidates. It uploaded 35 provincial candidates and 15 national candidates. But it said it had more candidates it wished to upload, 245 provincial, and 187 national candidates. But we've got to ask, why did it fail? Why wasn't it able to upload all these candidates? And there's 4 reasons. The first is that it only began with its candidate uploading 2 hours before the deadline. And why? Because it thought it had to upload all the signatures first. And it's wrong about that. It misunderstood the system. Despite all the training, all the user manuals that the Commission provided, it made a mistake. It's an unfortunate mistake, but it's ACT's mistake, not the Commission's mistake. The second is that it believed it had to upload one by one and didn't take advantage of the bulk uploading. The third is that it didn't take it.
Sorry, now that will relate to the supporter signature.
It's both the supporters
and candidate list.
Yes, so it's the supporter information and the candidate lists. With regard to both supporters and candidate lists, so there's the names and the ID numbers, and then for the supporters, you also have to do the signatures. So the signatures you upload as PDF documents because you need to see the actual signature. The names and ID numbers, you either do one by one on the website or you upload the Excel spreadsheet. For candidates, it's the same. You can either put your candidates in one by one on the website, or you can upload a spreadsheet. For the candidates, you also then need to upload the supporting information, the candidate nomination forms, and so on. And those are uploaded as scanned PDF documents. But for those, for example, the signatures, you can scan those in bulk. There will be hundreds of pages of signatures if you're competing in many of these elections, but you put them through a machine that the Commission did the calculations, suggests it'll take about 24 minutes to scan all that information if you have access to an efficient scanning machine. And again, that can all be done. That has nothing to do with the system. All that has to be done before you log onto the system and then upload it. And all the complaints you've heard today, start at the point where you are logged onto the system and are not trying to upload. And that's what we've shown. That cannot have been the cause of these parties' problems for all the reasons that I've given. The other reason that, and this goes for the Labour Party as well and for ACT, is they could have submitted manually. Mr. Am said that the ACT was on the horns of a dilemma. I don't understand what the dilemma is. If you are approaching the deadline and you know it will take you about half an hour to an hour to reach the Commission's offices, and you have all your candidate nominations forms, they're in a file, they're in a box, and you're an hour or so from the deadline, and you know you can get to the Commission's office in an hour, just drive to the Commission's office and give them the documents if you're having difficulties with the uploading. If you choose to go ahead with the uploading and you're unable for whatever reasons because you don't understand the system to get everything uploaded, again, that's not the Commission's fault. There were certain issues that Mr. Am stated were common cause, and he said I must dispute them if I think he's wrong, and there are a few. The first is that this is the first time the OCNS is used. It's not the first time. It was used for the previous local government election. It was used for the previous national and provincial election. It's used monthly in by-elections. So this system has been used repeatedly. It is the first time that supporter information has to be uploaded because it's the first election in which that has been a requirement in order to compete. But it's not the first time that the OCNS has been used. He also says that the only written document is a 22-page presentation. And that's incorrect. There are, in the papers that attach to the answering affidavit in the ACT matter, there are 3 other documents. There's WRS3 at page 179, WRS4 at page 184, and WRS12 at page 204. These are different guides that were available to political parties and independent candidates to assist them to use the OCNS. Finally, on ACT, there was a debate about whether this is an appeal or a review. The Commission doesn't make anything of whether this should be on an appeal or review. The substance, as I understand it, is the same, whether it's treated as an appeal or a review, and it should be dismissed on the merits. That brings me to the AASD, and the relief that the AASD seeks is primarily an interdict to restore access for it. So, and I think this goes to ACT as well, because it seems that what Mr. Am was arguing was that only it and maybe the other parties should be entitled to the reopening of the OCNS. And for the reasons I've given, that's not possible. If the system is reopened, it must be reopened for everybody. It's a different question if there's substantial compliance. Then you've complied. You don't need an opportunity to submit any further documents. You complied with the requirements and you should be on the ballot. That would be a very different case. None of the parties ask for that. All of the parties here say we still need to submit more information because we are non-compliant. So the AASD admits non-compliance. As Mr. Vilakazi put it, they were in the process. But being in the process is not substantial compliance. In this case, substantial compliance, there's only one form of compliance, which is you have uploaded your document, you've submitted them electronically in the words of the regulations. Merely being on the system and having the documents available to you is not compliance. Otherwise, it would be really impossible for the Commission, because how would the Commission know whether any party was in substantial compliance or not? It wouldn't have received the documents by the deadline, and the party would email it and say, yes, but we had the documents and we had them all. They were on our laptop. I promise you, and we were in the process of uploading. How would the Commission know? How would the Commission ever be able to assess substantial compliance? Not to mention that it's just simply inconsistent with the words of the regulations. So there's no substantial compliance. If there was, the AASD would be saying, we complied, put us on the ballot. They're not asking for that. They're asking for an opportunity to rectify their non-compliance. And again, the reasons they non-comply arrive from, again, misunderstanding and negligence. They only started to upload their first candidate a minute before the deadline. And as the council confirmed, they believed they had to upload supporters before generating a payment reference, which is wrong. As soon as you selected the election you wanted to compete in, it would generate a payment reference for you. And then you could pay your deposit, you could upload your candidates, and you could upload your supporters. So if you go through each of these cases, you can see where these parties made mistakes. And obviously it's unfortunate. It's unfortunate that voters who would like to vote for these parties won't be able to vote for them because they're not on the ballot. But the question is whether the reason they're not on the ballot is because the Commission created a system that made it impossible for them to compete, or whether they made mistakes, and that's why they didn't comply and they cannot compete. That then brings me finally to the question of remedy, which I think I've addressed largely already. Just, I think, 3 basic submissions just to round up. Firstly, the Commission would resist any remedy that singled out a particular political party. Any remedy must apply equally to all political parties, otherwise it would be unfair. So the only remedy that could be granted is a remedy that requires the Commission to amend the timetable, because that would allow all political parties to have the same opportunity for compliance. It would not be fair to have different political parties having more time than other political parties and independent candidates. The second point is, if that's accepted, and that's what was said in Liberal Party, then the consequence of that is that the election, if that relief is granted, if the commission is forced to amend the timetable, the election cannot be free and fair on the 29th of May. And so the commission will have to ask the president to postpone it. And this is not the commission trying to be difficult, or it's really the reality. And it's, again, we're not blaming the applicants for this, although some of them did come to court late, others, like the Labour Party, didn't come to court late. But it's just a reality of what the position is today. If the portal is reopened, all political parties will be able to submit new candidates, compete in new elections, and the whole process of Section 28, Section 30 objections will have to be done, and there'll be new ballots. The ballots will look differently. The commission will have to redesign the ballots, so it won't be able to start printing the ballots yet. And that whole process, we know, takes almost a month to complete. So on the timetable, it was from 8th March, timetable closed. 9th April is the date by which this court has to finally decide the objections. And only after that can we get into ballot printing. So it'll add another month, and then the election cannot happen on the 29th of May. And so what is the just and equitable relief if this court is against the commission? So we say that the correct order is to dismiss all the applications. But if this court is to find in favor of one or more of the applicants, what relief should it grant? And that depends on the basis on which it makes that finding. If it upholds some of the technical review grounds advanced by the Labour Party, for example, the complaints about errors of law, that the commission wrongly was unable to read Section 22A and thought it couldn't amend the timetable, or wrongly thought it wasn't under a duty to take a decision, then the relief would be to require the commission to take a decision, if that was the only basis for setting aside the decision. Of course, the commission denies it took a decision, but I've made those submissions. If the court finds that substantively an amendment is required in order to ensure...
Sorry.
Did you guys win?
Hello? Okay.
If
just
the court...
switch your microphone off, please, if you're not on the platform. Yes. Proceed, Mr. Bishop.
If the court finds that substantively an amendment to the timetable is necessary for a free and fair election, that's the requirement for amending the timetable, then the correct order would be to direct the commission to amend the timetable. Following from that, the commission will then take the steps it needs to take to ask the president to postpone the election. There was an issue raised right at the end by Mr. Am about a report from the SABC. I haven't seen that report. My understanding is that that doesn't relate to this case. The commission is proceeding to prepare for the elections. What it does have to await before it can print ballots is the determinations of the objections under Section 30 by this court, because that's how the timetable works. But it's not, obviously it will respect any decision of this court, but I did not understand the commission's position to be that this court's decision in this matter is delaying the preparations for elections. The final issue is costs, and I argued this last week before some of the judges sitting today, that time against the commission. But there's a decision of this court in the Carter Freedom Party case that says that this court doesn't have the power to grant costs orders. It's also been the practice of this court not to grant costs for or against the commission, unless there are some cases that do grant costs in exceptional cases. But we submit that whatever the order, there should be no order as to costs between the parties.
Thank you.
Thank you, Justice. Unless there are
These
any
were submissions.
Yes, thank you, Justice.
Justice Sharma, any question for Mr. Bishop?
No, I don't have any questions.
Judge Adams, any question for Mr. Bishop?
Nothing from my side. Thank you, Justice Ondi.
Professor Ntlama-Makanya, any question?
No question on my side as well, Judge.
Professor Puga, any question?
No question from my side, Judge.
Thank you, Ms. Bishop.
Thank you very much,
Justice. Excused.
Yes, if I may be, but my juniors will remain on the
Okay,
platform.
thank you. Then you are
Thank you very
excused.
much, judges.
Can we just take a comfort break here? Can we just take a 5 minutes comfort break?
Yes, I concur.
Yes, I agree.
Agreed.
Okay, let's take a 5 minutes just to stretch our legs, and 5 minutes break just to stretch our legs. You know, we've been sitting for hours and hours. Okay, so let's say 16. Let's come back at 16:12. Now let's come back at around about 16:20. Is that okay?
Yes,
That
thank
is
you.
fine with me.
Okay, thanks.
That is fine with me.
Okay. We court just adjourn for 5 minutes.
Thank you. Judge, I wonder if I could address you, please, when
Yes.
everyone's back.
Sure.
Thank you, sir. Thank you.
Okay.
Yeah. Thank you.
Miss Clap, is everybody back?
Let me quickly confirm, Judge.
I confirm my presence, Honorable Justice. I'm Slava Michael Chabalala on behalf of AAAC.
Okay.
Sipho Malapani, Honorable Judge, I am back.
Judge, just to confirm, Mitchell De Beer for the Commission and Shabalala's matter, I'm here. I believe Mr. Tsele is also here.
Oh, that's great. Okay, then Mr. Hopkins wanted to say something before we start.
Thank you, Judge Zondi. Judge Zondi, I wanted to make a suggestion. And the suggestion would be this, that we've now dealt really with three matters which are sort of intimately linked and completely separate to the others. And you've heard our arguments as applicants, and now you've heard the Commission. So I was wondering whether you would be amenable, you and the court, to allowing us to reply while it's all still fresh. Then we can do our replies, and then these matters are all wrapped up, and then the other ones can start afresh, if you know what I mean, without kind of getting mixed up in between these ones. It's a request that I know Mr. Would make jointly with me. I've spoken to him during the break.
Is it Mr. De Beer and Mr. Tsele?
No, it was
Because
actually Mr. It was Mr. Bishop, but he's now left for the airport.
Yeah, Mr. De Beer appears for the commissioner in Chabalala, ne?
I do, my lord. I do. So I don't appear for the Commission and the other matters per se, but I don't anticipate there being any objection to Mr. Hopkins' proposal. And I think it probably does make sense to wrap up these three matters. We will listen, and if anything does need to be dealt with, it'll be dealt with by the appropriate counsel. But I'm happy to say that on behalf of the Commission. Thank you.
My lord, if I may just intervene, I certainly don't intend to be very long at all in reply. And I'm sure, I don't want to speak for Mr. Hopkins, but I'm sure he's similarly placed as me.
Justice Zondi, I don't think there's a problem. I act for the Commission in a number of the matters. I think let them say their piece, and then we'll deal with the rest of the matters thereafter. And for my part, I won't be more than 7-8 minutes. What did you argue, sir?
Sorry, Mr. Tsele, we were breaking there. I didn't hear you. Mr. Tsele, we were breaking.
Justice Zondi, I say we have no objection to them doing their reply now.
Okay. So Mr. Hopkins will start.
Thank you.
Can I just establish for my colleagues if that is in order?
I'm in the minority. I'll go with the flow. I'm in the minority.
Sorry, Justice Strong, what do you say to the suggestion?
Yeah, no, it's okay. It's okay. It's okay, Chairperson. It's fine. I'll take your cue.
And then Justice Adams.
I have no objection to the approach suggested, Justice Zondi. I think it makes sense at this point.
Professor Ntlama-Makhanya.
Same here, Judge, as well. I had sent a reaction. Thank you.
Okay, all right. I didn't see it then. Professor Pugu.
I am in support of the proposition, Judge Zondi. Thank you.
Okay, I think that let's try to be short on our replies. Mr. Hopkins, you're going to start, no?
Thank you, Judge Zondi, and I will be short. I don't have much to say in reply. Judge Zondi, maybe just the very first point, which is a quick one, is listening to Mr. Bishop arguing for the commission. What he basically says is, well, if people didn't understand how to use the portal, then it's their fault and it's their problem. He said you can only lay the fault at the feet of the commission if the commission did something wrong. But he said if ordinary people don't know how it works and they make a mistake, then then it's their fault and they must live with it. To that, I want to say it's such an unlikely attitude for a regulator to adopt. Regulators are supposed to regulate people with the measure of certainty. It's part of the rule of law. If you're going to tell people what to do, make sure that they understand the commands that you give them. But in this case, if people don't understand it, it doesn't make a great deal of constitutional sense to me that the regulators should throw their hands up and say, well, that's your problem if you don't understand it. And I'll give you a practical example to make the point, because Mr. Bishop says that the commission did everything that they could reasonably have been expected to do to allow people to understand how the portal works. And I'll tell you why that isn't the case. Now, I'm going to give you an example of London University. During COVID, a lot of universities offered online learning programs for people, and they set up various methods. So lecturers would, for example, have online tutorials, and when you had an assignment or an exam to write, you would write it, and then you would submit it on a particular portal. I know this because I did something through London University during COVID to keep myself busy. And I understood this, but what London University did, like the commission here, they had manuals to try and teach people exactly what to do and how to use their portal. But they went one step further, and what they said is 1 month before you have to submit your exam, they're going to open the portal and you are obliged to go through a dry test run. And you're not allowed to write the exam until you've gone through the dry test run to make sure that you know how everything works. That's because you can't have an untested system with a deadline that keeps you out if you got something wrong. And that's exactly what a responsible regulator would do. And that didn't happen here. And so they didn't do everything they could have done. What happened is they tried to explain something in complicated documents, in workshops where people weren't allowed to ask questions because things were being broadcast from the outside. And then what they do is they then say, well, good luck on the day. Your deadline, the portal slams shut at 5 o'clock on Friday. You're either going to make it or you're not. You're on your own. That can't be the way that a responsible regulator works. So they haven't done everything that they could. And if people still didn't understand it, then it is the commission's fault. Because, Judge, if I've got to make an argument to you, and by the end of it all, you don't understand my argument, it's not your fault. It's mine, because I couldn't explain it to you. And we've got that principle happening here, I'm afraid. So that's my very first point in response. The commission can't simply throw its arms up and say it's your problem. So the second thing is, Mr. Bishop says, well, we've got to reopen the portal for everybody. We can't reopen the portal only for those who appear before you today. I still can't understand his argument as to why not. He says it won't be fair if only people with genuine grievances are given a remedy. He says everybody must get a remedy. I don't understand why everybody must get a remedy. No, those who've got grievances and those who can show that they tried to use the portal but were unable to do so, they're the ones who should be given a remedy, not everybody. I don't understand his argument. It makes no sense. Then the third point, and this is really the big thing. What Mr. Bishop says is that practically, and this is a matter of practice, he says practically you can't reopen the portal. And he says you can't reopen the portal because if you do that, you're going to jeopardize the election. You might even delay the election. It might have to be postponed. But what Mr. Bishop does there is he puts the cart before the horse. You can't say, well, I'm not going to allow anybody to question whether or not this election was free and fair, because just in case I find that it wasn't, well, I'm not going to give you the remedy that you want. It's too drastic. No, you're asking the wrong question. The first question is, was there a problem with the portal? And if that problem renders the election unfair or free, then we find a suitable remedy. But you can't stop people from looking for a remedy because it's going to be something fairly drastic. It's got the cart before the horse. So then the fourth point, and the fourth point I think comes from a question that Justice Adams asked. And the idea that I got from the questioning, and I didn't write it down exactly, so Justice Adams, you will hopefully be kind to me and forgive me if I get it wrong, but I understood you to ask a question about processes being run in parallel. And Mr. Bishop was going on and saying, well, you didn't have to do everything all at once. You should have been gathering and you should have been collecting and you should have been capturing a long time before you uploaded. And you then, Justice Adams, put the question to Mr. Bishop and said to him, but hang on a minute, that is what the Labour Party did. They told you that they went to Birchwood 2 days before the deadline, and by the time they went to Birchwood, they had their stuff in order. So in other words, I think the words you used, Justice Adams, we were ready to rock and roll. When we got to Birchwood, we were ready to rock and roll. Then what Mr. Bishop does is he starts to go back to beat the same drum again and says, well, you registered late. If you hadn't registered so late, you could have done everything sooner. We had done everything sooner. That's the point. The point is everything was done by the time we got to Birchwood. All we had to do was upload. Now, there was some question about we also had to collate, and Mr. Bishop said, well, you don't have to collate. As far as candidate lists go, you could have done that long before. That's not true. Because with candidate lists, what has to happen is you've got to put information into the portal. The portal then generates a standard form document, which is a nomination and acceptance form. You then have to send that to your candidate. He must sign it, send it back to you so that you can upload it. You can't give it to him until you've accessed the portal, because the portal generates the document. So that might maybe just be a slight misunderstanding on the part of Mr. Bishop, but in real life, that's not the point. The point is that the Commission said 1 day is all you need. In fact, they said 1 day is what you need to capture. So not to capture, yes, to capture and upload. Well, we don't need 1 day to capture and upload. We had already captured. All we needed was 2 days to upload, and we couldn't do it. And the reality is we couldn't do it. We couldn't do it. Mr. Bishop says it's our fault. And then he says to you, for example, 36 minutes before the portal closed, we tried to upload our first candidate. Well, that's not that we sat at Birchwood for 2 days and did nothing until 36 minutes before the portal closed. For 2 days and a full night, we were working flat out trying to do other things, but we were battling because the portal wasn't working. So it's true that we might have only tried to upload that particular document 36 minutes beforehand, but we were doing other things for probably 40 hours before that. And the record shows that we were battling and battling and battling. And it's not okay. It's not good logic for Mr. Bishop to say, some people got it right, why couldn't you? Or some people got it right, therefore the portal was working perfectly for everybody. That's not the case. It wasn't working perfectly for us. It wasn't. It wasn't working perfectly for a lot of people. We didn't send 25 people with laptops to Birchwood to go and twiddle their thumbs. They were doing stuff in those 2.5 days. They were doing things. They were trying to upload. The portal kept kicking them out. They had to re-log in. They had to reboot. Then the thing would hang. Then it would reject certain ID numbers. They would be phoning the commission. The commission's person either wasn't there taking lunch or maybe was there and came back and said, I don't know what's going on. Why don't you try to log out and try it all over again? Start the process again. None of that would have been necessary or been advice from the commission if the portal was working perfectly. The portal wasn't working perfectly. It's not a plausible answer in the answering affidavit to say the portal worked well. It's not plausible. And if it's not plausible, you can't accept that version on Plascon Evans. Then the final issue that I'd like to raise, which I don't think much turns on, and I agree with Mr. Bishop that much doesn't turn on it, but it shows you the attitude of the Commission. We say, we draw attention to the media article in the Mail and Guardian, and we say that the commissioner who was the Commission's spokesperson is also a commissioner. In other words, an office-bearing functionary of the Commission, convened a press conference, not any old press conference. It was convened in response to a letter where people complained about the tight deadline. She then comes on to a press conference, addresses a group of journalists and says to all of them, I'm sorry, but we are not going to change the timetable because it is cast in stone. Well, Mr. Bishop tries to belittle that. And he says, what? It's absurd. Do we really think that the commissioner can't read the act, or the commissioner doesn't know that the timetable isn't cast in stone? Well, all I can tell you is what the commission did say. The commissioner did say it's cast in stone, it can't be changed. And if that is absurd to Mr. Bishop, then it's not me who's being absurd by pointing it out. What is absurd is that the commission doesn't know that the timetable isn't cast in stone. That's the real absurdity. So really those are my points in the reply. And what hasn't been adequately dealt with the greatest of respect. And Justice Zondi, I heard you asking a question to Mr. Bishop along these lines, and that's the Rule 10 issue. The Rule 10 issue has still not been adequately answered. The best that Mr. Bishop could do is say, well, yeah, it's true. Mr. Moeti Kanyani did have a telephone call with the secretary, and the secretary did say it's okay. She did have an agreement, and she forgot to tell everybody about the private agreement. Well, that might be true, but who is the secretary to grant condonation? Rule 10 says that condonation is for the court to grant. It's for the court to grant, not for the secretary to grant. It's not for an administrative bureaucrat to give condonation. It's for the court to do it. And when does the court do it? The court does it upon a proper application with an affidavit where there's a true explanation. You know what Mr. Bishop says about that? Well, I'll tell you that there was good cause. Who is he to tell you? He is counsel. Counsel cannot give evidence from the bar. That's not his job. Somebody with knowledge must give evidence in an affidavit. And then Mr. Bishop says, well, the Labour Party haven't claimed any prejudice. Well, we didn't get a chance to claim prejudice. If an affidavit had been sent to us, we would have responded and we would have claimed prejudice, because I did allude to the prejudice that we suffered. I said it's been more than a month since we initially lodged this review. It still hasn't been heard. It's been dragging out. The Commission is the one dragging it out. There is prejudice because now the Commission says so much time, so much water has passed under the bridge, it's too late to amend the timetable. It's only too late because the Commission dragged its heels. That is the prejudice. And I would have put that prejudice in an affidavit deposed to by my client, given the opportunity. But the Commission saw itself as being too important to have to bring an application for condonation. He didn't find it necessary to do so. And then Mr. Bishop says, well, it's absurd that the affidavit should be ignored. But that's what the rules of this court say. If you don't like the rule, challenge the rule. But until you've challenged the rule, you need to obey the rule. You need to be a model litigant. You are the commission. That's your job. Set an example. Don't ignore the rules of the court. Pretend you don't know. And then give evidence from the bar. So I don't think that your question, Judge Zondi, with respect to you and to my colleague, was adequately dealt with. The penalty is in the rule. The penalty is you don't bring an application, you don't show just cause, the court doesn't give you condonation, you are barred. That's the consequence. The consequence is they are barred. If they are barred, Plascon Evans doesn't come into it. And that's the reality. And then the second issue is the issue of payment. Mr. Bishop, with the greatest of respect, has missed the point. He says, well, the problem, he says, even if you hadn't paid, doesn't mean that you can get the timetable amended. That's not the point. The point of showing that the non-payment it was wrong, was a wrong point taken by the Commission, is to show that even the Commission can now see that the portal doesn't work. The portal doesn't give you reports. It doesn't give you accurate information. It doesn't give you feedback. It doesn't register transactions. The portal didn't work. For 14 days or 12 days, the Commission had no idea that we had paid and that we had put proof on the portal because the portal wasn't working. That's the point. Mr. Bishop didn't address that issue. He addressed a completely different issue and said, well, so what? Just, so what? Just because you paid, that doesn't mean that you get to amend the timetable. He's missed the point completely. Those are my submissions in argument. And really, Justices, again, just to reiterate the final point from Cam, and that is that if you think that there wasn't fairness here, then it seems to me as though international jurisprudence quoted by the Constitutional Court and CAM itself tell us that we should err on the side of caution, because that's what we need to do to give credibility to the election. Those are my submissions. Thank you for listening.
I see Justice Shongwe has a question for you, Mr. Hopkins. Yes, Justice Shongwe.
Yes, thank you so much. Mr. Hopkins, I just want to hear your response to the fatality of amending the timetable, if that's part of the relief, yes, which, as we have been told, which may result in the postponement of the elections. What is your response to that? In other words, dealing with the relief that is sought.
Yeah, so it's very difficult for me to comment on that. So my comments are probably going to be confined to 3 points. The very first point is that the Commission can't come here and say to us, even if the elections are not free and fair, I will not budge on the timetable, because it might throw out the election. That question of whether the election will be thrown out is a different question. For now, the first question is it free and fair? And if it isn't free and fair, then we have to find an appropriate remedy. The Commission says the only remedy is to postpone the election. Well, if that's the case, then that's what must happen. It's happened before. The Commission has been caught with its pants down before. In fact, the very case that I gave you, CAM, where they spoke about free and fair elections, well, those were elections, municipal elections, 7 of them, that were postponed because the Commission had run an election that wasn't free and fair. And the Constitutional Court said, well, I'm sorry, but we can't allow that to go ahead. Rather postpone the election for a month and have free and fair elections than try and rush it now on a timetable that's got no flexibility, even if to do so violates people's constitutional rights. That can't be. So Justice Shongwe, I guess what I'm saying to you is the first question is it free and fair? If it's not, we must find a remedy. And as far as remedy goes, I can only say that within the existing timetable, we should try to do what we can. If we really can't do something, well, then I suppose the election would have to be delayed by a month. But that is far worse far less egregious than, for example, just saying to a whole bunch of political parties, well, I'm sorry, I gave you a portal that didn't work. You're penalized, you're out, and that's just too bad. Suck it up. For 5 years. Because that's the penalty, remember, you're out for 5 years. Justice Shonga, I hope I've answered the question. I can't do much better because, I'm not in charge. I don't have an insight into what really would happen if the timetable was amended. But what I can tell you, Justice Shonga, actually, now that we're talking about it, it's part of these papers. On the 6th of March, we went to the High Court and asked to interdict the closing of the portal. It hadn't yet closed. And we said, keep it open just for another day or so that people can upload. So we were the interdict was to keep the portal open. That was a month ago. Mr. Bishop sang the same tune then to the High Court that he sang to you today. He said then as well, we can't do that. He said, and the words that he used in his affidavit, he said there's a cascading effect. He said if we were to allow any wiggle room in the timetable, the whole election will have to be postponed. He used the same argument a month ago. What he can't do is delay it and make it more harder and more harder and more harder. And then we're the ones who are punished. I'm afraid to say, at the end of the day, the most important issue is that we have free and fair elections. And the Commission must find a way to make that happen.
Thank you.
Thank you.
Thank you, Judge.
Thank you. These are submissions, Mr. Hopkins.
Those are our submissions. Thank you.
Yes.
Thank you, Judge.
Sorry, Justice Zondi, if I can just pick up where Mr. Hopkins left off. Mr. Bishop, when he argued, adopted the position that if some sort of relief was to be granted, which had an impact, which would allow the reopening of the portal, that the consequence of that would be the postponement of the elections. With respect, that is not what the affidavits of the Commission say. What the affidavits of the Commission say is that they cannot guarantee a free and fair election. And the references there are in the answering affidavit at bundle page 162, paragraph 110. But you cannot, with respect, hold free and fair elections, and I'm arguing the other side of Mr. Hopkins's coin. You cannot have free and fair elections when the Section 27 process has not been free and fair. By keeping an election date to ensure that the elections are free and fair is an anathema that just can never happen if the elections have already been rendered unfree and unfair as early as the Section 27 process. So it's a bit like a dog chasing its tail, the argument of Mr. Bishop on that score. But there is something very important which my learned junior has pointed out to me, and I'm indebted to him for that, is Mr. Bishop in the argument said there are lots of manuals. Well, as a matter of fact, there is only one manual, and it wasn't even a manual, it was a presentation document, and it's a 22-page presentation document. And that document says nothing about the order in which things are supposed to happen, about bulk uploading, and about the payment process. But let's look at the documents that he did refer to. The first was Annexure WRS 3 at page 171. You'll find the reference in the answering affidavit at page 141. The second document he referenced was Annexure WRS 4 at page 184, and the reference in the affidavit itself is at page 145. And the second is Annexure WRS 12 at page 149. At page 212 in the affidavit at 149. These documents are printouts from the website. They're not manuals. They weren't made available. But the more important point is if you have regard to the printout WRS 12, it shows as a workflow document at bundle page 205 that payment must take place before the uploading of candidate lists. So you have to pay the deposits before you can start uploading candidates. And in the particular circumstances of my client, the founding affidavit says they struggled to make a deposit payment. They had to engage with the Commission, and they couldn't commence with the uploading of the candidate list until that deposit was clear. Now, that position is confirmed by the Commission's own workflow document at bundle page 205. So now to criticize my client for leaving everything to the last minute is, with respect, unpalatable, and it's unpalatable for three reasons. The first is my client did not leave everything to the last minute because on the Commission's own version, it only needed an hour or two to attend to what it needed to do. The second reason why it's unpalatable is because the order required my client to make a deposit payment before it could progress to the next step, which is what its evidence was in its affidavit, but it couldn't do that because of the malfunctioning portal. And we have already evidence of a malfunctioning portal in respect of the payment, and we refer to Mr. Hopkins's case. But the last reason why it's unpalatable is because the authority is quite clear, and that's the authority in National People's Party. And it's at, again, I quote it, and I'm sorry if I'm beating or ploughing old fields, at page 32 of our heads, paragraph 59. National People's Party, and that's where the contention was raised by the Commission that the applicant's woes were self-inflicted by reason of not acting in good time. To suggest that the applicant has only itself to blame and that the chairman would not have to rush if the requirements had been complied with long before is not helpful. And they call it an imprudent attitude to adopt. My client, like Mr. Hopkins's clients, was ready to rock and roll. It had all its documents. On the Commission's own version, had its portal been operating, it would have met the timetable. So it's simply not a situation where my client, with respect, can take any of the blame, and in any event, there's authority that the blame cannot be vested on my client. Now, just a couple of cleaning up submissions. Mr. Bishop referred to the Inkatha Freedom Party decision, which dealt with there must be a rigorous compliance with the timetable. A rigorous and a blind compliance are two separate things. And this is not a case about rigorous compliance by the Commission, but a case about blind compliance by the Commission. You'll also would have noted that Mr. Bishop did not deal with my client's understanding that the use of the portal was if not strongly recommended, it was compulsory. He didn't deal with that. Mr. Bishop also did not take up my invitation to point out to the court where in any of the affidavits the issue of the Commission considering Section 22 sub A and the power was at any time entertained by the Commission in respect of its decision or non-decision making process. And then the last submission I want to deals with, and it was dealt with, I think one of the justices asked Mr. Bishop about the lockdown reports. Those reports are inadmissible. And the reason why they're inadmissible is because there's no affidavit. They're not confirmed under oath. So any reliance that can be placed on those reports is with respect to a non-reliance. There's no endeavour to have the reports admitted under the Law of Evidence Amendment Act as hearsay evidence, but in any event, they're irrelevant. Again, the complaint is not about the website being live. It's a complaint about the website malfunctioning. But what we do say in the affidavit, what my client does say in the affidavit, is two things. And the first, the claimant agree with. And that is that we say that when the website did function properly, it was swift and quick. So my client cannot be blamed for hoping for that moment when it's facing, staring down the barrel of a gun, that the website would be quick and it wouldn't have to rush off to the Commission. And that's the horns of the dilemma. But more importantly, and it's not disputed, the complaint by my clients is that the website's malfunctioning was random. It couldn't be predicted, and it happened when it happened. And I'll give you the references in the founding affidavit to that. Those references are at I'm just trying to find them. Just bear with me. So I'm looking in the wrong affidavit. Sorry for turning my back on you in the court. I certainly apologize. In the founding affidavit at paragraph 20.25. Sorry, so in the founding affidavit at bundle page 20, paragraph 25.1, at bundle page 28, paragraph 34, and at bundle page 30, paragraph 40. So this wasn't a consistent malfunctioning, it was a random malfunctioning, which leads me to the last point I want to make. So, pursuant to a question from the court, it's revealed that 75 of the 87 parties who successfully complied with Section 27, 75% of those are independents. And that is 86.2%. And Mr. Bishop conceded that the task of them complying with 27 is less onerous than the task of parties such as my client. 86.2%. And that's the drum they beat. That 87 people did it successfully, but of that, 86.2% had the easiest path imaginable. That's not comparing apples with respect. And additionally, the fact that some parties were able to do it and others not is not definitive of whether the system malfunctioned, particularly where the complaint is that it malfunctioned on an ad hoc and random basis. So we would submit that an appropriate case is made out for the court to step in and grant what it believes to be the appropriate relief. And I return, this dogged insistence that the only way the elections can be free and fair is if they take place on the 29th of May is with respect misplaced. The election is already, should my clients not be granted the relief they seek, will already, and I say this with respect, I don't want to prejudge anything, but as matters stand today, the election is not free and fair because my clients' candidates have been excluded. And that unfairness is not remedied by the election happening on the 29th. And if the president needs to postpone the election with respect, then the president must postpone the election. What is illegitimate can never be legitimized simply because of a dead date, which is not, the date of the election is also not something with respect that's carved in stone. I'd like to thank you for the opportunity and to thank our colleagues for allowing us to effectively push in with our replies. I don't know if there are any questions from the court, my lords, professors, but those are our submissions.
I've got no questions. You are muted. Judge Zondi, you are muted.
Any question, Justice Shongwe?
I've got no further questions.
Justice Adams, any question?
Nothing from my side, Justice Zondi, thank you.
Professor Tlama Makanya?
No question as well, Judge. Thanks.
Professor Pugu?
No question from my side. Thank you, Judge.
I saw Mr. Vilakazi. I think that it's his opportunity now to reply.
Thank you, my lord. May I proceed, my lord?
Yes. Yes.
Thank you, my lord. Apologies on the name of the screen. That's my son's name, and he uses my laptop now and again. My lord, I just want to touch on a few issues that this court must take cognizance of. You were told that we effectively lodged our first candidate at 1659, and I want to refer you to IEC 1, which is part of the answering affidavit from the commission, my lord. IEC 1. Yes. The first connection. Now, my lord, what you'll see there is that number one, this is an email. It is not a screenshot from a laptop, so it's been tampered with. And why do I say that? Is because at the bottom of IEC 1, it says last candidate captured date. But you will notice that there is a statement in brackets that says this is after 1700, as the front end has a cutoff of 1700, but any database transactions that are processing are allowed to complete processing. So this is effectively hearsay, my lord, because you can't take this without this person, Siane Kitsiso coming through to this court and explaining what he meant. And further, if you actually consider something else on this document, the last 2 points there, it says first candidate captured date, and it says 2024-0308, 1659.59.903 split seconds. But then you have a last candidate who is captured at 17:00:753. So how many candidates were actually captured? Now the IAC says only one. So then how is it that we have a last candidate that was captured after 1700? This actually then can leave this court with only one conclusion, that in fact there were names in the system pertaining to the applicant, and they wanted to get that through, but it wasn't working. Let me show you further why it wasn't working. If you go to the replying affidavit and you go to annexure, just a moment for me, my lord, EC8. If the court goes to annexure EC8, now our entire case is well, not entire, but a portion of our case is premised on the fact that the system was not working. And now you will get to understand why perhaps it only captured us a split second before 5 p.m. If you go to EC8, we have call logs. And if you look at these call logs on EC8, you'll see that an outgoing call was made to Bridget Tshwane, who's part of the IEC, at 13:37 on the 8th of March. Another one at 14:25 on the 8th of March. Another one at 15:26 same day. You go to the next annexure, next page of that annexure, an outgoing call to Max Lehloka IEC at 13:31. You go to the next page of that annexure, 13:26, an outgoing call to the IEC. You go one further and you see the list of names that are listed there, in particular, James IEC, Kim IEC, Itumeleng Liba IEC, Granville IEC. And you will start to see, my lord, and to the rest of the court, that there was a problem with this system. And the applicant was doing everything in its power in order to be able to speak to the IEC and say, listen, we are struggling here. And I think that's also then proven by the earlier IEC 1 annexure, which shows that the first person was captured a second before it closed, and the last one was captured the following second after it had closed. Be that as it may. I'd also just like to take you to the replying affidavit on page 7, paragraph 21.
Mr. Vilakazi, just give me a sec.
Thank you.
I'm sitting at the Johannesburg High Court and the power has just gone off. I just want to check with the security what's going on.
Indeed, so my lord.
Just give me a sec.
Thank you, my lord.
Okay, yeah, you may proceed. Sorry about that, yeah.
Thank you, my lord. My lord, as I was saying, I wish to just take the court to our replying affidavit on page 7 of that replying affidavit at paragraph 21, where the applicant clearly sets out some of the people that they have spoken to in respect of this matter. One of them is written as Akani Mushwana, who advised that we must first upload scanned supporters' signatures, upon which we shall share the appropriate form after she inquired with her seniors. And there is an email in respect of that marked as EC10. So again, there was a lot of attempts by the applicant to get through to the commission and say that your system is not working, we are stuck on the other side. And because we're in Bloemfontein, effectively, we can't get to Centurion in time. Now, my lord, another issue that has been made about is that the system did not time out and it was perfect because there's an IT expert's report. Well, my lord, I'd like to refer you to Annexure EC 12. However, if my lord so permits, I'd like to share the screenshot in color so that you can see then for yourself whether this system did shut down. With permission of the court, my lord.
Yeah, sure, yeah.
I'm indebted, my lord. My lord will see that, and I'm just going up. This is EC12 from our bundle, my lord. But my lord, I just wish to come down to bottom left-hand corner where my cursor is circling. My lord, I'm going to simply blow that up a little bit so that my lord can see some of the issues. My lord, in this bottom left-hand corner, it's written clearly, your submission will time out in 20 minutes. So there was nothing like a system that was running as a well-oiled F1 machine. It was far from it, because every 20 minutes, our applicant had to go back and restart the system. So this puts paid, because this screenshot is from the system itself, that this system was perfect and there was nothing wrong with it. My lord, I'd also just like to, if I'm not mistaken, refer the court, and I'm going to stop sharing this page, but I'd also like to just go back and refer the court to the replying affidavit. I think it's page 8 at paragraph 27. Now, much was made about a system that allows you to do all steps simultaneously. Sorry, my lord, that was not...
Proceed. There's somebody that their mic on.
Thank you, my lord. Now, my lord, much was made about that. But Mr. Bishops himself, when speaking about the layout of this system, said once you've done that, in other words, would have made the payment, then only could you proceed to the next step of capturing details, etc. And this paragraph 27 on page 8 of the replying affidavit captures that essence, because it says, the system does not allow a party to make submissions in any order it sees fit. Parties cannot requisite payment for candidates listed. This was explicitly articulated by the representative of the commission, Graham Abrams, the general manager, electoral matters, who was responsible for the training attended by agents of the applicant and other parties on 22 January 2024. So it would appear that Mr. Bishop does not understand the system that he was talking about, my lord. I'm just going through my notes, my lord. Lastly, my lord, before I close, there was the issue of the rules not being cast in stone, and that phrase was used a lot. My lord, unfortunately, it was cast in stone by the IEC, because their own letter, and I read that for the commission, sorry, for the court, says that they got no place. I believe it's EC3. I'm just going to go back and just read that, my lord, so that the court is aware of what the commission has said, which then effectively makes it cast in stone. EC3 in the founding affidavit, point number 3. The commission has no discretion to condone non-compliance with the election timetable, and the commission may not take ad hoc decisions relating to requests from contestants in this regard. But it's quite clear that section 20, subsection 2 of the Act gives them the power to make such decisions. At the end of the day, my lord, in closing, two things. One, Mr. Bishop says we were in the parking lot. No, we were not. If the system itself shows that we were on the system at the time of closing, then we were not in the parking lot, but inside the offices of the IEC at the desk. But lastly, my lord, this matter is not about a late submission. It's a system that closed while we were submitting. And on those grounds, we seek the relief that we do. I'm indebted, my lord. If there are any questions, I'll take them now.
Justice Shaw, any question for Mr. Vilakazi?
No, thank you. I've got no questions.
Justice Adams?
Nothing from my side, Justice Zondi. Thank you.
Professor Ntlama Makanye?
Hello, Judge. No question on my side as well.
Professor Pogu? Hi, Professor Pogu. Any question?
No question from my judge.
Okay.
My
Thank
side,
you,
Judge.
Mr. Vilakazi. All right.
I'm indebted to the court, my lord.
Mr. Shabalala, it's your turn now.
Justice Zondi, sorry.
Yes.
Eshid Cohen here for the commission. Mr. Bishop introduced me earlier. I'm his junior in the ACT matter, the ACT matter. With the court's leave, I would just like to make two small points of clarification in response to Mr. Am's reply. Just two factual clarifications. With your leave, Justice Zondi, the first is Mr. Am submitted that of the 87 parties on the ballot, 73 of those are independents. That's not what Mr. Bishop said. He said unrepresented parties, not independents. I just wanted to clarify that. And the second point of clarity, Justice Zondi, is the flow chart that he referred the court to, page 205 of the record, clearly shows an arrow leapfrogging payment. You can generate your payment code, and then you can go directly to submitting candidates without paying. The flow chart makes it very clear. I just need to submit those two clarifications with the court lead. Thank you very much, Justice Zondi.
Thank you. Mr. Shabalala.
Justice Zondi,
Honorable Justice.
Sorry. Yes, Mr. Hopkins, what is that you want to say now?
Justice Zondi, so if we are finished, may we please be excused from the Labour Party and I presume from ACT? Or would you like us to remain?
Justice Zondi, can I
yes.
make, Mr. here, can I just make one? I mean, it's a bit difficult in these proceedings, but we want you to have the correct information. So can I just also make one point? And this may have implications for Mr. Hopkins. I hope he hasn't left. Which is, sorry, yes. Which is that the statement by Mr. Oh, sorry, my instruction, Justice, is you asked this question as to, sorry, I'm just now missing when the portal, when that document stating when the payment, whether the payment had been made or not paid was generated. It was generated on the same day of the deadline. So if you on the 8th on the 8th, yes.
Oh, okay, all right.
So if you haven't done the payment via the portal itself, payment wouldn't reflect immediately. If you've done it via EFT as they did, it would reflect some days later. So it's nothing to do with the portal if you're not working. It's the method you use, and that's what Mr. Siani was explaining. And if you pay it via EFT, it may reflect on their systems a couple of days later because the payment itself. So that document says payment not done because it's generated immediately after the cutoff. So that's just a point of clarification.
Thanks, Mr. All right. Mr. Hopkins and Mr. M, if you want to leave, because I mean, I think that for all intents and purposes, you are done now. There's no reason for us to detain you.
Thank you, and thank you for your patience to the professors. Thank you, Kevin.
Thank you very much. You too. Thank you.
Mr. Shabalala.
Thank you, Honorable Justice.
Yes.
Now, firstly, I would like to indicate that where I was, there was electricity. Now I'm just driving home, but I'll be doing my presentation because power left there. There's no longer electricity. I'm now in Gauteng, but my presentation will be as follows. I would like to indicate on record to the Honorable Justice that I am the president of All African Allied Congress, a party that made an application for registration to the second respondents in this application under case number 009/24 EC. The reason why we done that is simply because we were dissatisfied of the respondents, in the sense that we made an application for registration to be registered as a political party, of which such was delayed. We were published in terms of the government notice as entrenched in the application that we filed with the Honorable Court. The publication was made on the 10th of November 2023, last year. And in terms of that directive, it was publication. There was directives to the effect that we must submit the 1,000 list of founding members, of which we have done to the second respondent. Counting from the 13th to the 27th of November last year, 2023, I believe we should have been, because there was no objection. There was no concern raised by any member of the public or any existing political party that is registered in terms of similarities as regulated by the IEC.
So, sorry, Mr. Can I assist you here? Because I just want to, I think the case that you must argue is the case that is made out in your papers. Let's go to your notice of motion. In paragraph 1, you are seeking an order compelling the IEC to exonerate you from, that is your party, from the application of the election timetable. Well,
yes, Honorable Justice.
Under what, what is the authority for this prayer? Because you say that you should be, in other words, you should be excused from complying with the election timetable. Because as I understand, the timetable applies to all political parties and independent candidates.
Can I come in, Honorable Justice?
The timetable applies to all political parties as well as independent candidates. Why do you want to be excused from its operation? And what is the authority for the relief that you are seeking, that you should be excused to comply with the timetable?
What we are saying, Honorable Commissioner, is that the respondents, both respondents, disregarded their duties to facilitate the process in terms of application as a political party. They didn't do that. Then based on that, we were not in the position to comply with regard to meeting the deadline of the 8th of March, on the ground that our application, our approval as a political party registration, it was handed to us on the 26th of February. So for that reason, Honorable Justice, we are saying they delayed to inform, they delayed to inform us. And in terms of that particular document, which was handed to us, marked the Annexa C, as a correspondence from the respondents, it's dated the 4th of February 2024. So we are saying, Honorable Justice, if they should have notified that us of that registration, we should have complied with uploading and all these other things. So when they gave us that letter, they didn't even inform us that there's a standing timetable that we must comply with. They just said we must meet the requirements, of which we have to keep on asking them what are the requirements. They could not provide that until somebody gave us a copy of the timetable around the 29th. That's when we realized that there are some of the things that we should have done. But be that as may, Honorable Justice, we took an effort and met them on the 4th of March, trying to negotiate that let there be extension, because they deliberately not give us the document indicating our approval as a political party. The legal department of the IEC, which is the respondent in this matter, indicated that such is beyond their powers. That's the reason why we says no, man. Sometimes the Honorable Electoral Court can come to our rescue, considering the fact that on the day after our registration on the 4th of February, the respondent didn't inform us. And as a result, we could not attend all the seminars and training. That is the reason we are saying we could not even open a bank account to fundraise. Because as Sister Akani indicated to us that we are not even allowed to open an account. So their delay, the reason why we are saying we need to be exonerated from the timetable is simple because we are saying if we are saying they caused this thing. If they cannot exonerate, let them extend so that we must be able to comply. Hence, we never got any training. We were only handed with the letter approving our register dated the 4th of February this year. On the 26th, more than 18 days from the date the letter was issued, was supposed to be sent to us. When we inquired, they said it was sent to the wrong email. As if you look behind it, as attached there is a fake transmission indicating that such was sent same day on the 26th to a different political party. So meaning even from the 4th, they never attended to informing us. That's the reason why we are saying let us be exonerated. Then they give us an opportunity to extend the date and afford us to upload to comply.
Okay, right. Thank you, Mr. Shabalala. Do you have any further submissions to make? Mr. Shabalala? Mr. Shabalala?
No, I think I've covered that, Honorable
Okay, thank you. I see there's a hand that is up. Whose hand is that one?
Thank you, my lord. It's Vilagazi, my lord. My lord, we were asking whether we could be excused from the proceedings at this time. On behalf of...
yeah, I think that you are done. Yeah, you can go.
We're indebted, my lord, as the court pleases.
Okay, thanks. All right. Are you done, Mr. Chabalala?
Yes, Honorable Commissioner. Honorable Justice.
Okay, I think that before I allow Mr. De Beer to respond, Mr. De Beer, you're also appearing on behalf of the commission in relation in the Dr. Malapane's matter. Is that so?
Justice Ondi, Mr. Tsele is appearing for the commission in that matter, and he's still on the. As far as I know, he's still here. I'm sure he still is here. Yes.
So, all right. Do you want to respond now to Shabalala, or do you want us to wait until you finalize Malapane? Because Malapane, it's also an in-person.
Justice Ondi, if entirely in the court's hands, if the court wants to hear Mr. Malapane, or Doctor, sorry, apologies.
Doctor,
first,
yes.
Apologies, and then for me and Mr. Tsele to answer. Yes. I'm satisfied with that. I've got no difficulties.
Mr. Malapane. Mr. Malapane.
Thank you, Justice.
Yes.
Yeah, my camera is going to take some time, but it will catch up.
No, we can hear you.
All right, thank you, Justice. Well, let me start by thanking the Honorable Court and also thank the Honorable Council for allowing me to go here. I appear as an independent candidate, and then I appear in person in the case number 0010/24 EC. And then I've been a participant in these elections, or a hopeful participant in these elections, depending obviously on how the outcome of these proceedings will go for the Gauteng region for the 2024 national and provincial elections. Basically, I'm intending to contest for the Gauteng region for the seat in the National Assembly. Your Honourable Justice, I have structured my presentation in two parts, Part A and Part B. I'll just go straight to that. Part A is that which seeks to deal with the motion or the notice 2915 of 1998 of the Electoral Court Section 7, which reads that failure to comply with the limits or directives states or failure to comply with the prescribed time limits of the directives of any court having jurisdiction will, by mere fact, also result in a party being barred unless such a court on good cause shown directs otherwise. I would like to submit to the court that in terms of the respondent acted outside the time limits of the directives of the court. And then they have not shown, as far as I'm concerned, any good cause which the court needs to consider in terms of accepting or not barring them in terms of the prescription of this notice.
Yes.
Yes. And then I would also like to mention to the court that despite the respondent acknowledging receipt and forwarding of my emails to their legal team, which is also on paragraph 19 of my reply affidavit, besides them indicating that they've received them and forwarded them, so they did not bother, to follow the due and proper process in terms of applying to the Honorable Court for condonation or maybe even to grant any reasonable, to grant any reasons as to why they are delayed. Now, in terms of the directives which were given by the court on
Dr.
the
Malapane,
18th.
Dr. Malapane,
Yes.
take it that we have read your papers. We also have read your heads of argument. So the first complaint is that the respondent should not have been allowed to file an answering affidavit in circumstances where it was late and there was no application for condonation. And then in terms of Rule 10 of the rules of this court, they should have been barred. That's your case.
Yes.
Is that so? Okay.
That's true.
And then as far as the merits are concerned, you say your complaint is not that the IEC online portal was faulty. Your case is that the cutoff time was too short, considering the amount of data that you needed to upload from the 6th of March 2024, when you got registered, until the 8th of March 2024. That's your case, as I understand it. Am I correct in my understanding?
Yes.
Yes.
Right.
But now, and then
Yes.
the INC response is that, well, you did not qualify because you submitted only 927 signatures. In other words, the support information, the support people that you submitted, instead of submitting 1,000, you submitted only 927, so you were short, and therefore there was a reason. The delay was on your part.
Yeah. Yes. That is how the commission will put it, Justice. But if you can look at on what it's in my argument, especially on Part B, because of Part B of my submission deals precisely with the primary matter, exactly as the Honorable Justice has indicated. Now, in line and in context of the letter that I had wrote to the IEC, I argue that it is not out of practice or something alien to the IEC, to allow that queues be allowed to be completed, even though there's closure. If you can look at what I've said in terms of there's this presentation that I've brought forward, which says systematic closure. In that, what I'm saying is that if you look at the conduct and the function and operation of the commission, even in terms of elections, should the deadline arrive whereby they need to cut off the queue, they do not necessarily cut the queue and chase everyone out. What actually they do is that they lock everybody who's in the queue inside, the premise so that they can conclude the process. So my argument with the commission in this case is that because by the time when the deadline of the 8th at 5 o'clock hit, I assume that in practice and in fairness, we were part and parcel of people who were in the queue. So because of the process had already been began. So instead of the cutting off the queue, even people who are busy, we were busy with the applications, they should have allowed a systematic closure so that those who are already engaged in the process be allowed sufficient time to conclude their submissions on their applications. Because of these are people who arrived on time. We arrived on time to begin the process. I need to highlight to the Honorable Court this one, Justice, that in order for us to get these 927 signatures of supporters, we did not enter 927 signatures. These are 927 valid signatures. Basically, it means that we entered more than 927 signatures. From the top of my head, I can estimate that we entered at least about 3,000 signatures for us to can qualify for 927 signatures which are valid. These are 927 signatures which are valid. Now, if the IEC gives us the same treatment and the same common respect that it grants to voters on an ordinary day, because of if they say, for example, gates are going to be closed at 7 o'clock, and then by 7 o'clock, there's 500 people who are still on the queue. They're not going to turn all of those 500 people away on the queue. They're going to let them inside and close the gates by closing them inside the premise so that they can conclude the process of voting which they had already begun. So this practice, I believe that the IEC should continue with it throughout across all their their processes. Not to select that when it's time for us as candidates, we should be limited in this fashion, and when we are going to as voters for the very same process, but now under different cap as voters, then we should be treated differently. And then I began by pleading to the conscience of the IEC to say, let us consider something like this, but they did not, give an eye and ear to that. So that is why I ended up having to come to the Honorable Court to say, this is not in line with the practical principles of Batho Pele. In any other institution, whether be it commercial or whether be it in banks, even in banks, if they say a bank is going to close at 5 o'clock, and then there are people, they are not going to cut those people, but what they're going to do, they are going to let all their clients inside, and then they're going to close the door so that whosoever was there before the cutoff time of 5 o'clock be serviced so that they can go. So this is the same principle that is generally applied, which I expect that the IEC should have considered in terms of this. Now, the IEC, Honorable Justice, is saying for this election, they've brought up this new system, the OCNS system. It's a very new system. It's a very new system that has not been tested before. But in their papers, they are saying they have perfected the timetable of the elections over a period of years. Fair enough, they've perfected a timetable over a period of years. But this is a unique environment now. Over a period of years, they were not using this system. This is a brand new system. So they cannot limit it and hold it rigid to what they've been used to, or simply conform to what has been always been known to them over the years. Over the years, we did not have independent candidates. Over the years, they did not use this system. Obviously, they should have accommodated that there can be certain challenges unknown to them because this was not tried and tested before. This is the first time. So they should accommodate within this if they are a responsible and accountable authority. And then the IEC does not have a competition in this country in such a way that if they do not perform perfectly, then we can have an alternative authority that can run elections. Therefore, it means they should accommodate themselves sufficient time in their processes and timetables to also accommodate that should there be challenges, what is it that we're going to do? Because this is a new system that is going to be applied for this type of elections in this country. And then in one of their arguments, Chief Justice, they are saying this whole setup was my own doing. I brought this upon myself. They are saying on the 24th, I think 24th or 29th of January, they began to invite known participants to come for briefings and all that. And then they are saying there was no way that they could have known of my willingness to participate in the elections. Therefore, I was not invited. Therefore, the Honorable Justice, it means the very same commission themselves, they were not going in terms or in respect of their own timetable, because their timetable was allowing the obvious reason that there could be people on the next day who can begin to show hands that they are now willing and available to be part and parcel of the elections. And they did not accommodate as to what will happen to that. Now they are saying they have raised an issue of cases. They are saying there's a number of cases, success cases that they are raising, that this number of cases are a success. These particular participants or potential political candidates were able to comply. But then these people who were able to comply, they have so benefited from this process, which automatically, indirectly decided, to prematurely cut some of us off, because they gave people sufficient information and briefings before the nomination process can be concluded. They did not put in place a system whereby as and when we come in and as and when we get identified, we can be given the same opportunity and quality that they've afforded to these other ones. So I will not compare myself with people who were called to provincial briefings and meetings, given all of this attention, when they had, some of us are not as skilled in terms of IT. Now, there are some of these people, even if they would have appeared to be in a similar position like mine, they benefited from these arrangements, which were prematurely orchestrated or prematurely run by the commission. So the commission should have put in place a system whereby all of us, when we come in place, as and when we come, we should be when we identify, we should be, recognized as such.
Yes, you have made a point, Mr.
Yes.
Dr. Malapane. What remedy are you seeking? What relief are you seeking? What do you want us, this court, to order?
Okay. In line with the remedy is in line with my funding. It is contained in the funding affidavit. We'll just be given a minute. I don't want to end up quoting something fresh. But I am going to be brief in it, in respect.
Okay, let's go to a notice of motion and see.
Yes.
Do you want to be given 1 or 2 more days for the respondent to open the nomination for those candidates who are already on the system, so that they can complete that process? Is that what you want?
Yes, Chief Justice.
Okay. So you need 1 or 2.
Yes, because
1 or 2 more days.
Yes, 1 or 2. Okay. Yeah, 1 or 2 more days, so that we could be able to finish the process.
Okay. Is there anything further that you want to say?
No, Chief Justice, that will be all. Oh,
okay.
Justice.
Thank you.
Honorable Justice, I keep on saying.
Thank you. Okay, thanks, Dr. Malapane. Let me, Justice Song, any question for Dr. Malapane?
No, thank you. I have none.
Yes, Justice Lance.
Nothing from my side, Justice Zondi, thank you.
And then Professor Ntlama Makanya.
Same here, Justice, as well.
And then Professor Pogo.
Nothing from my side, Judge.
Okay. Is it now Mr. Cowan or Mr. Debie, or who's going to start now?
Thank you, Judge. So it'll be me first in the Shabalala matter.
Yes.
And then Mr. Tsele for the Dr. Malapane matter. And I must apologize again for misindicating his qualifications. Justice Ondi, I really don't have all that much to say. What happens in this case is that the party, the AAAC, applies for registration in late 2023, and its application for registration is not complete. Certain information is missing. So the Commission, as it does, and as this court knows from recent cases, asks parties that want to register, please amend or rectify or provide us the missing information. And the AAAC and applicants do so, and they only do so late in February. The Commission then registers the AAAC as a party on 26 February, which of course is right before the deadline on the electoral timetable for candidate list nominations and the signature quota requirement for unrepresented parties. My lord, all the applicants' entire case is this. Oh, and the applicants, they don't submit anything. They don't submit this. This isn't a case where they tried to submit and there was an issue with the system. There's no evidence of them attempting, nothing. All the applicants do is they say the letter of registration was dated the 4th of Feb. And they come up with a, Justice Ondi, I see your lights have come off.
Yeah, I don't know, there's a problem in this court.
I was there last week. I was there last week, Thursday. Anyway, I ran up and down as one does. So they latched onto a letter dated 4 Feb, and they say the Commission, for some reason, didn't disclose to them that the party had been registered early on, and that if they had been told, then they would have been able to comply with all the requirements. And there really are two answers. One, it's a typo, and the applicants knew about this because they submitted more information after the 4th of Feb. And two, there's no evidence to show that if they had been registered on the 4th of Feb, they would have met the deadline. As I said, this is not a case where they had the documents in boxes that we've heard of before. So Judge Zondi, my submission is quite simple, that really the case, there's no case here at all. There's no attempt at compliance. The applicants just waited too late in the day. In the other cases, there's reference to parties still being able to do things. I'm not even going to raise that now because it's not on these papers. But the simple point is, if you want to contest the election, you got to fulfill the requirements and you got to make sure you do it on time. And it's not the Commission's job to bend over all the time for every single party. The Commission needs to be even-handed, and the Commission hasn't really done anything wrong here. And the Commission really just says the application should be dismissed.
Thank you.
Thank you, Justice Ondi.
Mr. Tsele. Sorry, before any Justice Song, any question for Mr. De Beer?
Thank you. No questions.
Justice Adams, any question for Mr. De Beer?
Nothing from my side, Justice Ondi, thank you.
Professor Ntlama Makhanya, any question?
No question as well, Judge. Thank you.
Professor Pogo, any question?
No question on my side, Judge. Thank you.
Okay. Yes, Mr. Tsele. Thank you, Mr. De Beer.
Thank you, Judge.
Thank you.
Mr. Tsele. Yes.
Thank you, Justice. Thank you, Justice Zondi. Justice Zondi, I am here, but I've got some rain where I'm at, and my Wi-Fi connection becomes a problem. Is it possible to just keep my camera off?
Yes,
for
yes.
purposes? Thank you very much.
It might help, yeah.
Yes,
I'm going to switch mine off as well because I'm not sure what's going on here. There's it's dark here now in this court, so I'm not sure what's going on. Okay.
I hope you can take your notes, Justice Zondi.
Yeah, okay, but at least I can still see my bench book.
Yeah, wonderful. Yes.
Sure.
Justice Zondi, I will equally be brief. I want to say something, a few things. The first thing is, of course, we've already dealt, particularly in our consolidated heads, and I think it's practical, and we expect that this court will deal with all the issues in one fell swoop holistically in this matter. So I'm not going to repeat some of what, for example, Mr. Bishop had said. A lot of what we say in our answering papers applies across the board. But can I just say in relation to Dr. Malapane, the undisputed facts are these. He registered himself for the first time as an online party administrator on the 6th of March. And this is somebody who now says that he's not an IT expert. He doesn't understand how the system works. And then he first captured his first supporter at 21:38 on 6 March. Later that day, it doesn't explain why he waited some 9 hours after registering himself as a candidate. But the more important point, having regard to what he said today, and it's quite clear that he attempted to comply like the other parties at the 11th hour. But the more important point made in his affidavit, in his founding affidavit, and what he says today is this. He says he didn't know how the process worked. He wanted and he was eager to do so, but he only went to the IEC's offices on the 6th of March. He says, since the beginning of the year, and I assume, and he says, since the beginning of the year, I've been enthusiastic about this. I wanted to follow this process and to register myself to participate in the election. There is absolutely no explanation in the papers as to why he waited until the 6th of March before going to the IEC's offices to seek clarity. And he doesn't say, even after I had sought clarity, which enabled me to register on the 6th of March as an OPA administrator, he doesn't say, well, I faced difficulties. And the difficulties I faced, I tried again to get hold of the IEC. As the other parties allege, nothing of the kind. So he's received the clarity he gets. If he's not satisfied with that clarity, he never goes back to the IEC on the day or on the following day. But more importantly, he never alleges in his papers that the system malfunctioned, as the other parties allege, for example. So you don't need to consider that issue, not an issue here of a malfunctioning system. The closest it comes to is, well, it wasn't an easy system to use. Well, if it wasn't an easy system to use, you should have sought clarity, and you should have sought clarity timelessly. He's done none of that. The point he makes this afternoon, which is, well, you know, I want to make an analogy about people who are queuing in an election to vote. They're entitled to vote even if the cutoff time for the election comes and they're in the election venue. I deal with that. We deal with that in paragraph 59 of the answering affidavit, which is, the point is simple. The analogy is inapposite, because this is not a question of somebody who is in a queue waiting. He's arrived at the election venue, got his ID and everything he needs to vote, but can't vote by 5 o'clock because there are 5 or 6 or 7, 8 people in front of him. When he's in the venue, he's quite right. The commission would close the door and allow those to finish. But there was no queue here, and that's the point. He was not waiting in a queue, waiting for other people to upload onto a system, and then he would get his turn. So the analogy is inapposite. He had all the time in the world. He was not restrained by a queue to do what he had to do. So for that reason, that analogy doesn't work, doesn't help him with respect. The rest of the issues, quite frankly, as I say, are dealt with in the affidavit, in our affidavit. He doesn't say the system malfunctioned. The high watermark is that high watermark of his case is that he wasn't too au fait with IT. But as I say, no explanation as to why he let it lie until the 6th. And even after the 6th, if he had experienced any difficulties, there's no attempt to engage with the IEC. There is an attempt ex post facto days later to use his words again today, appeal to the conscience of the commission, and with great respect for all the reasons set out in cases like Liberal Party, etc. A plea ad misericordiam is not helpful. You can't just appeal generally to the moral conscience of the commission because you failed to comply or meet a particular deadline. So for all those reasons, Justices, the application falls to be dismissed. Justice Zondi, those are my submissions in relation to this matter. My attorneys implore me to make one comment in relation to submission that was made earlier, not by Dr. Malapane, but I think it was I can't remember who it was. But I just want to make that comment, Justice Zondi, because it was a serious attack or slight at the Commission. There's an annexure, I think it's the African Alliance Party, an annexure that was referred to, and it was said that that annexure, EC12, in the replying affidavit of that party, it was said that that annexure discloses that the system of the Commission would automatically kick you out every 20 minutes. That's not correct, but I don't want to tell you factually why that is not correct. All I need to say is this. As a matter of law, counsel cannot in reply pick up an annexure and say, look at this annexure, this is what it says, and interpret an annexure for a proposition not pleaded in the body of the affidavit. So you won't see in the body as vis-a-vis annexure EC12, an allegation that automatically, notwithstanding the circumstance of what you are doing, you will be automatically kicked out every 20 minutes. There is no such statement made in relation to EC12, and Swissboro, DF Wendell Trust, and all those cases are very clear. If you're going to rely on an annexure for a particular proposition, plead it in the body of the affidavit so that the other side can deal with it. You certainly can't interpret the annexure from in argument as counsel, and you certainly can't do so in reply, particularly when you're now seeking to impute, as it were, on the part of the Commission, some shenanigans. But that statement is not correct factually. I won't tell you why it is not correct, because I don't want to lead evidence. It suffices to say, DF Wendell Trust, Swissboro, you can't rely on it unless you said, I draw your attention to this annexure, EC12, and I pleaded for the following propositions, which was not done in the body of the affidavit in relation to that. Other than that, Justice Zondi, justices, and members of the court, those are my submissions on behalf of the Commission in this Malapane matter, and unless you have any questions, I am done.
Justice Shaw, any question?
None, thank you.
Justice Adams?
Nothing from my side. Thank you, Justice Zondi.
Professor Ntlama Makanya?
And nothing as well, Judge. Thank you.
Just Professor Puku?
Nothing from my side, Justice Zondi.
Thank you. This question is directed at you, Mr. Tsele and Mr. De Beer. You remember Mr. Bishop promised to send an affidavit
yes,
to condone the late filing of the answering affidavit. He said it must have been, the attorney was busy preparing it and he must have sent it to him. He's going to check his phone. What's happening?
Judge Zondi, I don't have instruction, but I can speak to Mr. Kanyane quickly just to confirm what the position is.
Justice Zondi, maybe I can help. I think the affidavit is ready. It's on its way. It may have been emailed to you, but I've seen it, and you should get it shortly if it hasn't already been emailed. Okay. But I've seen the affidavit. It's there. Okay. Justice Zondi, maybe on that point, because Dr. Malabane also raises this issue. It's not ideal what has happened, and I have to accept that. And what I mean is, even in our case, I'm conscious of leading evidence, even in our case, my instructions from my attorney, again, was that there was some communication with Ms. Nshapo about the necessity to file a condonation affidavit. As far back as yesterday, it was said, well, in the light of the directions that the matters will be heard anyway, she took the view or was advising us that it was not necessary to burden the court with such an affidavit, specifically for the Dr. Malapane's case, and this ruled the issue of barring. So I accept that perhaps clients sometimes and attorneys err because they communicate with the registrar in good faith, and the registrar gives an indication. Sometimes she'll say directions will come and the directions never come, but that the correct process, of course, is always to err on the side of caution and bring the condonation application. But that is the factual position of what has happened. we accept that the direction, I don't think subsequently came, but we with respect submit that it would not be helpful to the commission, because this is not typical.
Yeah, let's let it go.
Yeah, it's not typical litigation for the court to say, for the applicant to say, gotcha, you filed late, and therefore ipso facto the court shouldn't entertain your affidavit. We are trying to be helpful to the court. The court wants the answers. I apologize that these condonation affidavits haven't been filed in the manner in which they should have, and there seems to have been the errors of the good faith, otherwise good faith communications with the registrar, who is also no doubt very busy, and we're not shifting any blame. And sometimes a statement is made that a direction will come or will be forthcoming, or it's not necessary to further burden the court, and that's all done in good faith. But the affidavit to which Mr. Bishop alluded to will be the court will be furnished with that affidavit, in fact, and an affidavit with respect in relation to this matter. And if Dr. Malapane wants to say something in answer to that affidavit, well and good. We won't reply because the facts are what they are, and it will be very short and explain to the court what I've just said. But those are my submissions, Justices, and
thank you. Mr. Chabalala, it's your time now to reply. Any reply? Mr. Chabalala?
Thank you, Honorable Justice.
Yes.
I want to indicate to the respondent's representative that we have got a case. It's a fact that the fact that we were given the letter dated the 4th of February made us believe on that date that we are registered with effect from that day. The only surprise is that why were we not informed? And we believe such omission on the part of the respondent has been a flaw. That's the reason why we came to the Honorable Court. And immediately when they says we were not registered, it is not true, Honorable Commissioner, because we were even linked immediately after having been given that letter. We were even linked and we also submitted. We were uploading. We uploaded people until 14,000. And those ones, if they can check in their system, they will find, because our main aim was to contend the forthcoming election. We uploaded people in their portal until 14,000 in order to contest nationally. And we were still going to upload until 2 or 3, until 3 or 400,000, because we've got members in all provinces. But the problem is their system has been so slow, and that system only allow one person to punch. It could not allow another person in Limpopo. We talked to Sister Akani of the respondents on several occasions. Why this system only allow one person? And we were told, no, that's how it is. You Chabalala, appointed the deputy president to be the person uploading. So he's the only one who can upload. So that one, Honorable Justice, disadvantaged us. And we feel we are disadvantaged by that timetable. That's why we were saying, we plead with the Honorable Justice to make sure that we be exonerated from the timetable, or else there must be extension in order to accommodate us to punch the other outstanding 300,000 to 400,000 that are outstanding, because in our office we've got so many people that we're supposed to punch. But due to that problem we experienced on the 8th and also on the 7th, it was impossible for us to punch. And as a result, we could not even effect payment. Just like if you look at the papers, we could not even raise the account. But apparently, if we can be given an opportunity to be registered or...
Yes, Mr. Chabalala. We have lost Mr. Chabalala. Mr. Chabalala. All right, while you are trying to get Mr. Shabalala back online, I think that we can go to Dr. Malapane. Dr. Malapane, yes. Any response, any reply?
Thank you. Yes, I have three actually. One is on the IT issue, the other is on the queue, and then the final one is on the issue of the notice to bar. The respondent is actually trying to mislead this court in terms of saying, I said I've registered on the 6th on the system, yet I say I do not have IT skills. I have mentioned in my affidavit, in my filing affidavit, that it was up until I went to the IEC office in Centurion physically, because from the beginning of the year, I've been visiting the website of the respondent, trying to understand how to get the process done. There is nowhere where I saw that I need to acquire the OPA before I can be able to do all these other processes, which I was not even aware of. I went there because of the frustration was now mounting, because I had hoped that maybe the system is developing or something, but when the 6th came, I went physically there. The officials at the IEC are the ones who assisted me to get the registration, to get the OPA registration. And then they keep on saying from my registration up until the first candidate, up until I loaded the first supporter and then the others. But they have a printout of an IT report that they are exposed to, which clearly outlines to them that after I've registered, obviously we need to account that from the office I needed to come back to our own office. Then I needed to brief people who are supposed to assist me with this. So they will realize that on their own report on the 7th, we tried to triple the effort. It was 3 of us trying to load the signatures on the system. We even worked throughout the night of the 7th up until the early hours of the 8th, practically for the entire day from 6 o'clock on the 7th up until 6 o'clock the following day. We did not sleep. We were continually loading these signatures. So he should not put it as if I am misleading the court to say I don't have IT systems yet, I'm capable to do this and that. It is the information that I got after I went to their office physically in Centurion. There is an office here in Mabopane, there's an office in Pretoria, but we are not allowed to go there to assist us with these national elections. We only have to go to Centurion. We went there because we wanted to get this whole process done. Now, on the second one, I have illustrated using different institutions versus their clients. We are clients to the IEC. However they profile us, in terms of proprietary or otherwise, we remain clients. And then in this country, there's a principle of but to pay. I have said, when we have begun a process, we are queued in the system. So it is a queue. Whether that queue is physical or that queue is electronic, is immaterial. The fact is we are a queue. And clearly that is where our civilization is moving, that things are going electronically, whether we like it or not. So definitions, automatic physical definitions will assume also on the electronic side. Now, the question is, if I had taken our lists, all our lists, put them in boxes, and then went to Centurion on the 8th, and when 5 o'clock hits and I'm inside their office with their officials assisting me, were they going to say I am barred from the system, or were they still going to continue assisting me after 7? If he's arguing the issue of queue on the electronic system versus it being physical, because of it's clear that from all their presentations, even if I was there, they were still going to say now the time is cut and then I need to leave. You see, if the commission was fair in wishing to assist us clearly with this brand new system, with this very limited time, they should have said we give them our lists, we give them our boxes, our lists, and then they manually enter these signatures, because it takes at least 30 seconds or more to enter one signature. Now imagine entering 3,000 signatures only to get 927 valid. So they relegated that responsibility to us to do it upon us, even though they know that they did not afford us sufficient training. And today they say possibly the suspicion that we have proper IT skills, which is not true. And then, Honourable Justice, I would like to bring on the issue of the notice. I would like to bring the attention of the court to paragraph 351 and 352 of my heads under my heads of argument, to say, I am going to quote these ones, to say this notice is of this very same honor, is of this very honorable court, and it's evident that this court has it within their authority to uphold the seriousness of its own directives by barring those who do not recognize them. Directives of the court are not just a mere standard operating procedure to be gone through. Rather, they are serious rules of engagement in the court process, and neglecting them has to bear consequences. Otherwise, our courts are just reduced to mere social pubs. Now, the respondent is trying to downplay the seriousness of the directives of the court. Now, what happens? Every ruling that the court makes becomes a precedence. So, a directive of a court has to be complied by. Otherwise, it will just be of the same standard as a social post. We cannot have a situation like that. The respondent is demonstrating its inability to recognize the directives of the court for what it is, and they're busy blaming the registrar of the court for that. These are uniform rules. They are uniform rules that are there. And then I believe that the respondent has to be familiar with the processes of the court, seeing that they are themselves an authority in the election environment. I thank you, Honorable Justice.
Thank you, Dr. Malapane. Justice Strong, any question?
Thank you. I've got no questions.
Justice Adams?
No questions, Justice Only. Thank you.
Professor Makanya?
And no question as well, Judge. Thank you.
Professor Poko?
No questions from my side. Thank you, Judge.
Thank you. Mr. Chabalala. Mr. Chabalala, are you still there? We lost him. Okay, thank you very much, ladies and gentlemen. Thanks very much for your presentation. The judgment will be reserved. You'll hear from the registrar as to when the order will be handed down. Obviously, because of the time constraint, we'll have to give the order without reasons, and the reason will follow upon request. But thank you very much. And it's late now. It's 6:05. We've been patient enough to assist this court to dispose of these matters. Thank you very much. You are excused.
As the court please, Justice Adi.
Thank you.
Thank you, Honorable Justice.
Yes, thank you. Ms. Tapo, just make sure that everybody leave the platform. And then it's going to be us and the...
Noted, Judge.
Hi, Ms. Tapo. Just remove them from the platform.
Yes, Judge, they're still exiting, and I'll remove them if I see that there are some still remaining. They're leaving. I'm still trying to remove Studio 902. I don't know who that is.
Sorry, Delhi. Please check with me. I'm using an external device. Is it not me? I suspect.
Studio 99. I mean Studio 902.
Yes, please check if it's not me.
Yeah, I can see you still have your profile here. And then there's Studio 92.
Okay, that's not me then. Thank you.
Yeah, and it's a bit difficult to sort of remove this profile.
Let me try to leave and come in case it's me. Thank you.
All right. Prof, it's not you.
Okay, thank you.
Yeah, it's